Good evening, chat. Day 11 of the Karen Reed trial. So welcome, everybody. Welcome, one and all. So yeah, I got done with my trial today, a little earlier in the afternoon. Got the one-word verdict. Not what we were hoping for, but it kind of like thought it was going to happen. So, yeah, been a long day, been a tiring couple of days, but you know what? I think we did everything we could. So it's all we can do. It's all we can do. So, yeah, it's good open window weather right now. Yep. Hey, get out of here. Get out of the way, you guys. So anyways, guys, welcome to the show. My name is Sean, also known as Potentially Criminal. I'm an attorney in the Cleveland, Ohio area, and today we're going to get day 11 of Karen Reed. So a little weird. I just talked about what happened today without starting it off right, but there we go. Want to drown your sorrow in some White Claw? Nah, it's all right. It was all right. Yep, Louie was there. Sean told him, just because you did it, well, looks like you are found guilty. Well, no, the jury told him he was guilty, not me. So, not me. But if I told you the case, you'd be like, well, that's not a surprise how that came out. So, but let's get started, guys. So they are on to, well, we're finding out how obnoxious and just how obnoxious and garbage laden this entire situation is. That the investigation, I mean, we already knew that, but some of you might not have. It's an entirely garbage investigation. Does that mean it's reasonable doubt yet? No, but it could help. Remember, Chad, just like building beyond reasonable doubt, you have to build a wall. And you have to meet the standards. Well, reasonable doubt is also taking those bits and pieces and building your own wall. And I think the defense is slowly getting there, but the progress of this isn't getting much better. So, I mean, right now, there's still a very good chance Karen gets convicted. I know a lot of people aren't saying that, but the idea that, there's reasonable doubt everywhere, it's not everywhere, but I think there are some things you could infer reasonable doubt. But remember, the big one still hasn't come yet. The coroner's report. The ME will explain it doesn't look like a car crash. That's the ultimate thing. But for right now, we'll just see where this goes. So let us get started. So anyways, welcome everybody. Hope everybody is doing very, very well. All right, let's get this open. And here we go. All right, chat, it is time. So here we go.
Okay, thank you.
Okay, I think we're waiting on the jury still. There's nothing's happening. All right. Okay, here we go.
Questions, were you all able to follow the instructions and refrain from discussing this case with anyone since we left yesterday?
Here we go, chat.
Yes or nodded affirmatively. Were you also able to follow the instructions and refrain from doing any independent research or investigation into this case? Everyone said yes or nodded affirmatively. Did anyone happen to see, hear, or read anything about this case since we left yesterday? No. All right, Mr. Brennan, your next witness, please.
Thank you, Your Honor. The Commonwealth calls Conner Keefe.
Conner Keefe.
Step up, raise your right hand. Thank you.
Raise your right hand. You solemnly swear the honesty of the court and jury in case I'm hearing should be true.
Here we go, chat.
All right, Mr. Brennan, whenever you're ready.
Thank you, Your Honor. Good morning.
Good morning, sir.
Could you please introduce yourself to the jury? Spell your last name for the record.
Sure. My name is Conner Keefe. The last name is Keefe.
Mr. Keefe, where do you work?
I work for the Massachusetts State Police.
What's your position with the Massachusetts State Police?
I'm assigned to the Norfolk District Attorney's Office.
Are you a trooper?
Yes.
When did you first start beginning working as a Massachusetts State Police trooper?
2017.
Did you go to basic training?
Yes, the academy.
How long was the academy?
Approximately 6 months.
Did you have any further training after the academy?
On the job training?
Yes.
Yes. In various specialties.
What's your role at the Norfolk County District Attorney's Office?
I am assigned to the homicide unit where we investigate homicides, unattended deaths, suicides, stuff like that. And I'm also a digital forensic examiner at the district attorney's office.
Did you have a role in investigating this case?
Yes.
Were you a assigned investigator in this case?
I wasn't the main investigator, but I was involved. Yes.
Did you deal with any of the digital forensic evidence?
Yes.
Specifically regarding the digital forensic evidence, did you meet anybody to obtain a phone?
Yes.
Who did you meet?
I met Jen McCabe and Kerry Roberts.
When you met with them, did you have to obtain anything from them?
I obtained a consent form and their cellular device.
After you received their devices, where did you bring them?
They were brought back to the forensics lab located at the Norfolk District Attorney's Office.
And what, if anything, did you do with either or both phones?
I conducted a forensic extraction on those devices.
An extraction, is that copying an image of the phone?
Yes.
Is that different than analyzing the phone?
Yes.
Were you involved in analyzing Kerry Roberts' phone?
No.
Were you involved in analyzing Jennifer McCabe's phone?
No.
Was your role limited to attaching it to grade key and doing the extraction?
That is correct.
And did you do that?
Yes.
In addition to the phone extractions, if you take us back to January 29, 2022, were you involved in going to 34 Fairview Road in Canton, Massachusetts?
Yes.
Do you know about what time you went there?
Approximately 5:30.
What was your role at 34 Fairview Road that evening?
I was asked by my supervisor, Lieutenant Brian Tully, to assist in processing the scene at 34 Fairview Road in Canton, Massachusetts.
When you arrived at 34 Fairview Road, was there anybody else there?
Yes.
Who was there?
Lieutenant Tully, members of the Massachusetts State Police CERT team, the Special Emergency Response Team.
Are you part of the CERT team?
I am not.
Did you see what the CERT team was doing?
They were conducting an area search, very front of the lawn and the street or road in front of 34 Fairview.
Did you have any role in that actual searching of evidence?
No, I did not.
What was your role, limited role that night?
To process any evidence that was discovered during the search.
When you say process the evidence, can you explain briefly, what does that mean?
Sure, I was had evidence bags, and if a piece of evidence or an item was found, I would place that item into the evidence bag
And why would you do that?
to secure it.
How would you become aware if there was a piece of evidence found?
The CERT team would alert the supervisor, Lieutenant Tully, or myself that there was an item or piece of evidence, and Lieutenant Tully would then take a photograph of it, and then I would secure the piece of evidence in a evidence bag.
Do you know if those photographs were timestamped?
I believe so.
Your role was to put the evidence in the bag and return it to the evidence room?
Correct.
Did you do that?
Yes.
If I could begin, I'd like to show you on the screen.
So real quick, chat, this guy is establishing the chain of custody, saying we got the phones, here's the crap we pulled. Like when we go over, when these phones are examined and analyzed, he could say, look, I'm the guy who picked them up. I got the consent form. I logged them in. You know, it's interesting. It's all the stuff that Canton PD didn't do. So it's funny. You're seeing scales of incompetency, like complete incompetency and then slightly less incompetency. So that's why you're seeing this. They're showing the chain of custody because remember, guys, it goes to the credibility and the weight of the evidence that it's not secured, that it might have been contaminated. We're not looking at this point. It's all admissible, but it's the issue of the credibility. So that's why you show chain of custody if you're a prosecutor. I know we talked about that last night, and if you guys don't remember, let me know and we'll go over it again.
Series of exhibits. If we could start with exhibit 74, please.
Also, does it sound too quiet or do you guys need
Do you recognize that item?
Yes.
What is it?
That is a black Nike shoe.
Did you see that item that night?
Yes.
74A, please.
So,
74B.
hi, McKinley. How you doing?
Is that the same sneaker?
Yes, sir.
After you were alerted to that sneaker, did you place that sneaker into an evidence bag?
Yes.
Did you bring that item with you today?
Yes.
Do you have gloves?
Yes, sir.
Do you want the lights on, Mr. Brennan?
Please, thank you, Your Honor. And Ms. Gilman, you can take the photo down, please. With the court's permission, I'm going to move this piece of evidence, item into evidence.
Or yes, they can make up a chain of custody.
Let me ask you a few questions before you open it. Could you stand and show that bag? There's red tape on it. What's that for?
To secure the bag closed.
If the bag is open, is it then retaped?
Yes.
Do you write on the outside of the bag?
Yes.
Why do you do that?
To memorialize the date time when the evidence was collected.
Could you open the bag and show us what's in it?
Yes, sir.
the court's permission, can he show the item?
Yes.
Trooper, is that the same item that you found that night?
Yes, sir.
If you could place it back in the bag. I'd ask this to be marked as an exhibit.
All right, any objections, Mr. Manning?
There's no question.
677.
Sir, you mentioned there's writing on the outside of the bag.
Yes.
What type of information do you write on the bag?
Date, time, location, who's collecting it.
The time that you write on the bag, is that the specific time the item was found, or does that represent a different time?
That could represent a different time.
And why would that be?
If you're processing multiple things at once, you're bagging things at different times. Then when you seal the bag, that could be the time that is annotated on the bag.
Can the item be found before the time on that bag?
Yes.
Would you ever write a time later than when the item was found?
Yes.
I'd like to move now to Exhibit 75, please. And preferably 75A, please. Do you recognize that item?
Yes.
Is that one of the items you bagged that night?
Yes.
And if we could turn to 76A, please. Do you recognize that item?
Yes.
Is that an item that you bagged that night?
Yes.
Do you have both of those items with you?
Yes, sir.
Could you produce those, please? Ms. Gilman, you can take that down, please. Thank you. 570.
Yes, sir.
With the court's permission, I'd ask the trooper to open the bag and show the jury.
There's no bag ASMR this time. It's interesting. Unlike the other trials, no bag ASMR. Catherine, I'll take a look at it and I'll give you an email back.
Sir, on those items that are stickers, did you put the stickers on them? Do
I did not.
you know where the stickers come from?
I do not.
Do you know if these items are ever sent to anybody other than your evidence locker? Are they ever removed and given to lab personnel and technicians? Do
Yes.
you know if that was done in this case?
Yes, I do.
Inside that bag, is there just two pieces or is there another piece in that bag?
There's another piece in the bag.
When you put the taillight pieces in that bag, how many pieces did you put in the bag?
I put two.
Do you know if the other piece in the bag is a piece that broke off? Or do you know how that arrived there?
I do not.
Could you just pull out that other small piece and show the jury as well? Is that smaller piece consistent with the same color as the two bigger pieces?
Yes.
Is it consistent with the same material?
Yes.
If you could put that back in the bag, please. I'd move this into evidence, please.
Okay. Thank you, sir.
Okay.
Vanessa, he could, but it's standard practice to keep your gloves on. That way you don't ever fuck up. So that's how they do it. Because if he didn't have gloves on, someone like me, an asshole attorney, is going to bring up that he didn't. So,
Sir, on the small chip piece, you don't know how it became chipped?
I do not.
I'd ask you to remove that chip. I'd like you to safely secure it, bring it with you, and bag it when you leave.
Yes, sir.
And I'd like to introduce that exhibit.
678.
So we're going to mark the little chip.
You want-
Mr.
you'd like to
Yannetti
mark it?
asked to
Okay.
mark that.
For identification.
Yes.
Then we're going to submit that for identification. So the small chip that I
Madam
asked you to
Clerk.
secure.
Madam Court Reporter has an envelope.
Thank you very much.
678.
Thank you.
Exhibit BB for identification.
Thank you. Trooper, we have one more bag of items to go through.
we'll answer
Yes.
this at a break.
Could I have exhibit 73, please? Sir, if you could look at exhibit 73 on the screen, do you recognize that?
Yes.
And what is it?
A piece of clear plastic.
Is that piece of clear plastic, when you saw it, was it at ground level?
Yes.
Did you bag that item?
I did.
When you bagged that item, was there another item along with it in the same bag?
Yes.
May I approach, Your Honor?
Yes.
I'm showing you a photo. You recognize what's in it?
Yes.
What's in it?
The piece of clear plastic.
Is that the second piece in the bag, separate from the last exhibit?
Yes.
Fair and accurate depiction of how you saw it that morning?
Yes, sir.
I'd move this into evidence as an exhibit, please.
There's no objection, Mr. Yannetti?
There's no objection.
679.
With the court's permission, could we show exhibit 79 to the jury?
Yes.
Ms. Gilman, would you be able to close? Thank you. You recognize that item, sir?
Yes.
And did you bring those two items with you, the past exhibit and this exhibit?
Yes.
Could you produce those, please? Are these different in color than the last pieces you showed?
Yes.
With the court's permission, could the trooper show these pieces?
Yes.
Thank you, trooper. I'd move these items to evidence.
No objection, Your Honor.
Right.
Exhibit 80.
Thank you.
Thank you, Trooper Keefe.
Thank you, sir.
All right, any questions, Mr. Yannetti?
Please, Your Honor, thank you.
Good morning, sir.
Good morning, sir.
Trooper Keefe, you testified that you received the cell phone of Jennifer McCabe and of Terry Roberts.
Correct.
With regard to the cell phone of Jennifer McCabe in particular, you had her sign what is called a consent form, correct?
That's correct.
What is a consent form?
It allows the trooper or law enforcement to, with the owner's consent, we are able to conduct an extraction of the device.
Okay. And on that consent form, there is a description of the item itself.
Yes.
In this case, it would have been an iPhone 11.
Yes.
And there also is an identifier with regard to a specific phone called the IMEI number.
The International Mobile Equipment Identifier.
And that would be included on the form as well because it identifies the specific iPhone 11 that Jennifer McCabe had, correct?
Correct.
The password was provided on that consent form
Yes.
and the form was signed, correct?
Yes.
By both Jennifer McCabe and by you, correct?
Yes.
And there was also a second trooper that would have signed the form as well.
That's correct.
With regard to the timing of the signing of that form, Jennifer McCabe dated it February 2nd of 2022.
Yes.
You also dated it February 2nd of 2022, correct?
Correct.
Jennifer McCabe did not list a time, but you did, correct?
I would have to look at the consent form.
Okay, so your memory, you don't remember what time you indicated or if you indicated a time, but looking at the consent form would refresh your memory?
Yes.
May I approach, Your Honor?
Yes.
And I just ask you to read that silently and then look up at me when you're done, Trooper. Having reviewed that form, does that refresh your memory as to whether you indicated a date and time?
I did. Yes.
And what was the date and time that you indicated?
It was February 2nd, 2022, 12:08.
And that would have been 12:08 p.m.?
Correct. 12:08 p.m.
The document that I handed you is not an original, correct?
No, it's not.
Does it appear to be a precise copy of the original, however?
Yes.
May I offer that into evidence, Your Honor, please?
Is there an objection, Mr. Brennan?
No, subject to redaction.
So don't put it up on the.
I will not.
Exhibit 81.
Now, Trooper Keefe, as of January 29th of 2022, you were colleagues in the same state police unit as Michael Proctor, correct?
I was.
At that time, was the unit called the CPAC unit or was it called Norfolk County Detectives?
I don't recall when it changed.
Okay, it's been called both, correct?
It has.
As of January 29th of 2022, there were only 10 troopers in the unit, including supervisors, correct?
I don't know.
It's a small unit, is it not?
Relatively small.
Within the CPAC or the Norfolk County Detectives, every case that comes in is assigned to one particular trooper as the lead investigator in the case, correct?
That is something that a supervisor would do, not me.
And have you been assigned as the lead investigator in other investigations?
No, not a homicide investigation. No.
You have not yet.
No.
The lead investigator is the trooper who is responsible for the case, correct?
Yes.
Michael Proctor was the lead investigator for the investigation into the death of John O'Keefe, was he not?
Yes.
If somebody asked within your unit while this case was going on, whose case is it or who has that case, your answer would have been Michael Proctor, correct?
Yes.
The two of you have worked cases together in the past, correct?
A few.
You've worked on this case with Michael Proctor, correct?
Yes.
And in fact, within your work on this case, you actually partnered with him for certain assignments within the case, did you not?
You'll have to be more specific.
Sure. So for instance, on October 21 of 2022, you and Michael Proctor interviewed Sarah Levinson together, correct?
No, I don't recall that.
If I may just have a moment, Your Honor.
Hello. Because where's Michael Proctor's SAR? This is just Conner Keefe. He has no O, but it's still a horrible Mick name. It is the Mickiest name you can have. Conner Keefe. The only thing it's as Mickey as Sean Martin. It's a very Mick name.
Okay, Cooper, you do not remember interviewing Sarah Levinson on October 21 of 2022 at 12:20 p.m. at the Norfolk DA's office. Is that your current testimony?
Yes.
Okay. If you saw a copy of that report, would that refresh your memory?
To an extent.
May I approach, Your Honor?
Yes.
No, not at all. Yeah.
I've placed a document in front of you. I would just ask you to read that silently to yourself. Look up at me when you're done.
Well, let's go. I mean, come on. Come on, you can read it. Let's go.
Sure, go ahead.
Okay.
And, I'm sorry, Trooper Keefe, just so we're clear, I'm not going to ask you any questions about the specifics of what Sarah Levinson said, so you don't have to brush up on that.
I'd just like to refresh. Take a
Sure,
look, sir.
go ahead.
That's actually a very good witness comment. He's like, I still want to make sure I need to refresh all the way. That's actually not bad. I kind of had a similar thing today. Like, you don't need to read the whole thing. He's like, but I want to make sure I am properly refreshed. And I'm like, well, I can't argue with that. So I look like an asshole. So there you go.
Having reviewed that report, does that refresh your memory as to whether or not you participated in an interview of Sarah Levinson with Michael Proctor on October 21st of 2022?
Yes, I don't recall the specifics, but
So when you say yes, is it your current testimony that your memory is refreshed that you were actually there?
yes.
Okay. And the two of you would have participated in that interview together, correct?
Yes.
But you did not write the report, correct?
I don't know why
No, I did
Lally
not.
didn't
Michael
prepare
Proctor
this
wrote the
guy.
report, correct?
Yes, he did.
He was the lead investigator writing the report, correct?
Yes, he wrote this report.
He chose the language to use in that report, correct?
I did not have any input on how he wrote this report.
Right. You had no input. You weren't standing over him while he was typing
Proctor.
it, correct?
Correct.
Now, other examples of, and actually, let me take that back from you if you don't mind. May I approach Judge?
Yes.
You're welcome. Other examples are the reports on the videos that you, well, strike that. Let me start by saying this. You, or asking this, you retrieved videos from both the Waterfall Bar and Grill and CF McCarthy's, did you not?
That's correct.
You and Sergeant Buchanan retrieved the videos from CF McCarthy's, correct?
Yes.
But lead detective or lead investigator Michael Proctor was the one to analyze the video and write a report on it, correct?
I would have to see that report, sir.
Sure. Can I approach?
Okay.
Oh, I'm sorry. Again, if you read that silently to yourself and look up at me when you're done. Okay, having reviewed that report, does that refresh your memory about Michael Proctor being the one to write the report on the analysis of the waterfall video?
Sir, I only obtained a copy of the surveillance video. I did not do any analysis on the video.
That's my question. It was Michael Proctor who did the analysis, correct?
Yes.
And that, by the way, I said Waterfall. Is that CF McCarthy's there, or is that Waterfall?
This is CF McCarthy's.
Okay, I meant CF McCarthy's. He was the one to review that video, correct?
Yes, again, I only got a copy of the surveillance video.
Sure.
I did not do any
And
analysis.
with regard to the Waterfall Bar and Grill, that was another circumstance where you and Sergeant Buchanan were the ones to retrieve the video, correct?
Yes.
But again, lead investigator Michael Proctor was the one to analyze the video and write the report on it, correct?
Yes, I would have to see that report as well, sir.
Now, another member of your unit was Trooper David DeChico, correct?
Yes.
Within your unit, did Trooper DeChico have a nickname for a first name?
Objection.
May we approach?
Well, that's funny. Why can't we ask about that, Hank? What's wrong? What's wrong, Hank? Good old Hankitus Brennicus. What are we so sad about? I don't know. So, Mangios put sanctions Rizzo then be illegal use Cellbrite. Yes, that would be awesome. Keefe is another useful idiot. Well, yeah, he is. Well, we're going to get to that because I think his nickname is relevant. Guys, remember, Keefe is here to establish chain of custody that he's the guy who took possession of Jen and Carrie's phones. He was also there when Sarah Levinson got interviewed. So that's part of why he's there. And then Maddie B brings up, why didn't the public get access to expert reports? Are you talking about in this case right now? Or I don't know what you mean, because a lot of times it is available. I don't know. You got to provide me a little bit more there. So.
Trooper, in terms of the troopers that were in your unit as
Yep.
of January 29th of 2022.
I know, and it's like Proctor lies a lot. It's like that's why he got fired.
Which members of the unit had the least amount of time in the unit at that time?
I don't recall.
Were you one of the newer members of the unit?
As of January of 2022?
Yes.
Yes.
Well, you're not going to get the expert reports in the middle of a criminal case, like during a pending case. That stuff's not available. That's like demanding the police turn over a case file. Like, no, that's not going to happen in the middle of a case like this. Like, it's still an ongoing matter. So not everything's available. Not everything's available. Why not? Because that's how the rules go. No court's going to make the prosecutor hand over shit in the middle of a trial. So, okay, that's why. Because I was wondering, otherwise, generally they are available.
Trooper Michael Proctor had more experience than you did as of January 29th of 2022, correct?
He could have. He'd been on the job longer.
Okay, well, if he had been on the job longer, then certainly that means that he did have more experience, correct?
It depends.
You attended the autopsy of John O'Keefe on January 31st of
I did.
2022. And with regard to
Listen to that. It depends. Wait, he's been there longer than you. Does he have more seniority? I don't know. I mean, this is where you just have to bite the bullet and just say yes. By saying yes, you're not giving everything up, man.
other members of your unit, you were the only one to attend that autopsy?
Yes.
That was done at the medical examiner's office?
The medical examiner's office in Sandwich, Massachusetts.
In Sandwich, Mass. And it was Dr. Irene Scorti-Bello who performed
Road trip.
the autopsy, correct?
Yes.
Had you met her prior to that day?
No.
Had you spoken to her prior to that day?
No.
Did you know before the autopsy was performed that your former colleague, lead investigator Michael Proctor, had discussed the case with Dr. Scorti-Bello without telling us what you knew of what was said?
Objection.
With regard to
What? He's allowed to say, did I know if they talked? He's allowed to testify to knowledge of that.
Dr. Scorti-Bello's knowledge of what the state police theory was of what happened, did you have to explain that, or was it your understanding she already knew what your theory was?
Objection.
What, if any, conversations did you have with Dr. Scorti-Bello about what your unit's theory was about what happened to John O'Keefe?
There was no theory.
Okay. You did not provide any theory to her, correct?
I did not provide a theory.
You learned at the autopsy from your observations that John O'Keefe had 2 black eyes and a swollen right eye, correct?
Yes.
You also learned that there was a small cut above his right eye, correct?
Yes.
And there was a small abrasion on the left side of his nose, correct?
I would have to reference the report for the exact words.
Okay. If I may have a moment.
Okay.
May I approach, Your Honor?
You want this one back?
Oh, please, thank you.
I don't. Who's the other she?
So I placed another document in front of you. Just take a look, read it silently to yourself, and look up at me when you're done.
You know, Proctor
I would direct your
doesn't
attention to the
make
second
it
page for
automatically
the question I
bad,
just
but he makes it so bad it can't be trusted. Ah,
Having reviewed that report, Trooper, is your memory
I see what you're
refreshed
getting at,
as
Luke.
to whether you observed a small abrasion on the left side of John O'Keefe's nose?
Yes.
Now, was this the first autopsy that you had attended, or had you attended ones in the past?
I cannot recall.
It could have been the first one.
Most likely not.
When you're attending an autopsy as a member of the CPAC unit or the Norfolk Detectives unit, you are expecting that the medical examiner is going to examine the body, correct?
Yes.
And you're there to witness that examination, correct?
Yes.
At the end of the examination, you are expecting that there will be a determination as to cause and manner of death, correct?
Not.
In this case, when the autopsy ended, you left the medical examiner's office, correct?
Yes.
When you left, your understanding was that the cause and manner of death was still undetermined, correct?
Objection.
You knew when you left that Dr. Scorti-Bello had seen the scratches or bites or injuries to John O'Keefe's arms, correct?
Objection.
You knew when you left that in your presence, Dr. Scordi-Bello had seen the injuries to John O'Keefe's arm?
Objective to line of question.
Sustained.
Why? You knew that she saw those. Were you aware she found those? I mean, I don't understand how that's objected. Like, how you can sustain those objections. Unless he's arguing speculation. But yes, people in court said, I'm not strong enough to completely close the stream at any point. Well, I hear you. I hear you.
May we approach?
Okay. Jurors, feel free to stand up.
All right, let's see what we got here. Yes, I heard they are calling a different medical examiner, which is really bad for them. It's a bad look. Bite the fucking bullet, Hank. You don't do this skipping around shit. Jurors, no.
Were you watching Dr. Scordi-Bello as she was conducting the autopsy?
Yes.
Did she appear to be looking at John O'Keefe's body?
It's the same thing, just ask a different.
What direction were her eyes facing when she was examining John O'Keefe's body?
I don't recall.
Okay. Was she looking at the ceiling, Trooper?
She was doing her job conducting the autopsy.
And in order to do that,
body.
I'm sorry?
She was looking at the body, I assume.
Thank
Not
you.
in-
Thank you. And looking at the body, you saw her looking at the body, correct?
Yes.
And looking at the body included an arm, correct?
Yes.
And it was at the arm was not covered up during the autopsy, correct?
No.
It was open for you to see, correct?
Yes.
And you saw the injuries to John O'Keefe's arm, correct?
Yes.
You didn't see any bruising on his arm, correct?
I don't recall.
You didn't notice any obvious broken bones, did you?
I'm not a medical expert.
And it is common practice for the state police to attend autopsies when there's an undetermined death, correct?
Yes.
It is not at all common for the defense to attend an autopsy, correct?
I've never experienced that.
Right. And there was no defense attorney or defense expert at the autopsy of John O'Keefe, correct?
There's never
Not
one.
when I was there.
You were there, correct?
Yes.
And there was nothing that prevented you from giving input to the doctor as she examined the body, correct?
We don't give input. We give the facts that we know so far in the case.
Okay. Well, giving the
You
facts
advise her of things.
is giving input, is it not?
It's not input.
Okay. Did you talk to Dr. Scordi-Bello during the autopsy?
Yes.
And you gave her information, if you don't want to call it input, correct?
Yes.
And at the end of it, you left without her ruling it a homicide, correct?
Objection.
I have nothing further.
No, not thank you.
All right, you're all set, Trooper.
That was a good job. Wow, Hank's not going to even fight that. Wow.
So.
I don't think he was there. Who knows?
We're going to take now.
Well, guys, this is the problem with a witness like that. He's going to fight you every little goddamn thing. He's never going to agree with you, so just keep hammering him over the head. Everybody in the jury's like, facts are input. You're advising. You're telling her what's going on. You're consulting with her. So he doesn't look good to the jury like that. Just answer simple fucking questions. So here comes the expert.
All right, we're going to take a break. The lawyers and I have some work that we have to do. So I want to talk a little bit more about what we talked about at sidebar. And I read the decision from Maryland, just cursory while we were waiting for the witness. And that was a March decision. And I can't stress enough that this should have been brought up before today. So I'll hear you about your concerns, Mr. Alessi. I'll hear the Commonwealth's response, then I'll go finish reading everything else you gave me. So what are your concerns about Jessica Hyde? I don't know if she's Dr. Hyde or what, but I remember she testified the last trial, so you have transcripts.
Understood, Your Honor. I first want to just get the evidentiary basis.
Okay, that is actually a very good point. If they're behind on this and it's old case, if it's case law, it's not brand new. Yeah, that's a bad look not to have brought it up already.
This is straightforward judicial notice. There are two separate decisions which require two separate.
One's a Massachusetts case, so that's easy enough.
Okay, so and then that's a shall.
It's an SJC case, so yes.
Yes. Okay. So now to the Maryland case. So that's governed by federal, Massachusetts Rule 39A, and that is records of courts of other states or of the United States. The Act provision is the records and judicial proceedings, and of course, the court is a judicial proceedings, of a court of another state or of the United States shall be competent evidence in this Commonwealth if authenticated by the attestation of the clerk or other officer who has charge of the records of such court under its seal. So I have with me, Your Honor, that State v. Herrera, Maryland case. I have the certified copy with me from the clerk.
All right, so we can mark that for identification.
Thank you, Your Honor. May I approach?
Yes.
Okay,
Sit CC for ID.
let's see
Okay,
where we're
thank
going.
you.
So, assuming Your Honor determines that the seal is the seal, it is a mandatory under the rule that it shall be competent evidence, it shall be in evidence. And to the extent the Commonwealth seeks to argue relevancy or materiality, that argument is precluded, Your Honor. And the best evidence of that conclusion is the immediate section below in Rule 39, which is notice of foreign law, which is not this, but it says there, the court shall upon request take judicial notice of the law of the United States or of any state, territory, dependency thereof, or of a foreign country, whenever it shall be material. So the drafters of this rule knew how to put in a qualification or condition when they introduced materiality in B, but they didn't do it in A.
Okay, so focus on what it is you think Jessica Hyde should be prohibited from testifying about.
Oh, Your Honor, I am not seeking to prohibit her from any testimony under this rule. What I want to do is to have it admitted in evidence, have it published, and question her on what she presented to the court in the Maryland case, what was presented, her report, because it was deemed not reliable. And that is what.
In one area, right? One specific area?
Well, you can call it.
The decision.
Right. Oh, yeah, just what's in the decision, but there's two parts to that decision, two areas. It's FLH.
Hey, you guys might know more than me. I remember, guys, I was at trial this morning. So she got deemed as a shitty witness in Maryland? Ooh. Do we have a better day today? Well, my guy got convicted, but I had a better day today. Today was a lot better. We were in control today. So, They should be allowed to contest her. They should be allowed to ask her, why does the state of Maryland think you're a fucking hack? They should be allowed to do that.
Location history.
Right.
But what the court also got at was Apple source codes, that she didn't have the Apple source code.
Nobody in the country has the Apple source codes, right?
Point exactly, Your Honor.
What is it that, so you want to put in her report and question her about a proceeding in Maryland? I need to know exactly what you're asking
If I could
me
proceed
to allow.
give you the answer, Your Honor, I will
Go ahead.
explain it. It's a very short answer.
Okay.
What I want to do is, with regard to her 227 timestamp and her anticipated testimony on that, where she uses a tool, Celebrite, to determine and come to a conclusion about that timestamp, she is not using Apple source code to find out where that's located specifically in the phone and what it means. She is using a surrogate to do that. And I want to cross-examine her on the topic using this decision to say, in Maryland, you tried to do the same thing with regard to FLH. You tried to use a surrogate approach and make an opinion about whether that is, in fact, what's in the phone. She can't do it, and that means her testimony on 227 is not reliable. I'm not looking to exclude it. I'm looking to cross her on her reliability for the conclusions I anticipate she's going to make on 227.
So if she is not asked about that, then what?
Oh, she's not asked about the 227. I want to think about it, but I'm 99% certain I am not going to pursue that at all.
Okay, what do you say, Mr. Brennan?
This is an attempt to try to malign a witness with something that's wholly unrelated and not relevant to what she's going to testify to or the basis
It's
for her opinion.
entirely
It
related.
is not a law that is
It's
admissible.
entirely fucking
It's an opinion.
related.
It wasn't even about a specific case. It was about a peer review. And so in a Daubert hearing, the court did not allow testimony on significant location. That's not the case here. Try to conflate the argument saying it has something to do with Apple 227. There is absolutely no basis for that argument. They want to say that another court rejected something about you, therefore the jury should reject you. There's no relationship between what she is going to testify as a basis and that opinion. That opinion did not say she was wrong. It said that it was not admissible under Daubert, unrelated. Nobody has the Apple source code. No expert can testify about Apple source code. It's only owned by Apple. And so using the words like surrogate as a way to try to cheapen her testimony in front of the jury. Here, number one, what he said, I really can't follow him. I don't understand, other than he's trying to draw some type of relevance and materiality. There's none. There's none. This is not a denouncement. She hasn't been found incredible. There's nothing about her methodology that has been rejected by a court. This is on significant location. And although she looked at it, that's not part of this opinion whatsoever. And so because another court didn't allow something under a Daubert, has nothing to do with this case. Nothing.
Yeah.
And what is it
it's
that you
important.
expect her to testify to, Mr. Brennan, regarding the 207 stamp? We did not have this issue with Mr. Whiffen, right? This was not raised with Mr. Whiffen.
Oh, it was. The 227 timestamp would.
No, that was raised, but this, what was problematic in Maryland, the same thing that was problematic in Arrington.
That's correct, Your Honor. It wasn't raised because Mr. Whiffen has not been advertised with regard to Apple source codes. And if I could, Your Honor.
Okay,
Mr. Brennan has made a relevance argument. He keeps anticipating my cross, which he has incorrect, by saying it's not relevant. That doesn't go to the admissibility in my cross. I'm entitled to cross her on her reliability. And if I could, Your Honor.
And that's true. Hank, I mean, I get what Hank is doing. He's trying to shield his expert from getting hammered. But a witness's credibility is always up for debate. The credibility is like on cross, especially. I mean, he's dead on here.
Anticipating my cross, which he has incorrect, by saying it's not relevant. That doesn't go to the admissibility in my cross. I'm entitled to cross her on her reliability. And if I
And her reliability, her credibility, that is always allowed to be attacked. Is it bias, her competency? What happened in other courts? Every other court says you're a hack. You know, that the admissibility, that ship sailed. But remember, guys, it's like some of these other things. It's not about the admissibility. Remember, we had the discussion about the evidence. So contaminated evidence. It still could be admissible, but now it's an issue of credibility and weight and reliability. Here, for her, this chick, you could challenge her credibility. You could challenge her reliability. You know, could she be admitted as an expert? Yes. Then you point out she's a fucking toolbox. That is acceptable to do. So, yes, Alessi's right. He has every right to challenge this witness, especially an expert.
Your Honor, in a state Herrera decision, if Your Honor would look at page 3, please, at the bottom of the paragraph, it says, in assessing the reliability of an
Thank you, guys. I see that now. Wow, this is bad.
It's not limited to a Daubert hearing. Every expert can be crossed.
This is really, I just was speed reading that. Wow, she's fucking awful. But yes, every expert, you have the right to challenge every expert at any time.
On their reliability of their methodology. And lastly, with regard to the Apple source code, if Your Honor would please turn to page 6, the last paragraph, it says the issue raised in this case stems from the fact that Apple's algorithms are proprietary and the expert did not have access. That's exactly the situation here and what I want to cross her on. So in conclusion, Your Honor, the fact that how she tried to get around the Apple source code for methodology in the Herrera case, she got Daubertized on because it wasn't reliable. That's exactly what I want to cross her on, is her reliability, how she's trying to get around them in this case. It's just basic cross-examination.
You can see the plan to dehumanize somebody, Daubertized, to use a term to suggest some type of conclusion that has no basis in fact, is an attempt to just dehumanize her and limit her testimony and credibility without any basis in fact. In that case, it did not deal with the search of a tab and a suspended state in Safari. It didn't deal with a timestamp. It was an entirely different issue. By their analysis, if an expert goes into court on a motion on anything to do with data forensics and the court says that issue is not admissible, they should be impeached when they go and talk about a totally different.
I mean, if the Massachusetts state rules say they're correct, that's fine. But generally speaking, you have the right to go after a witness for being shitty.
An issue in forensic data analysis and another case, they have not shown any evidence that this issue has anything to do with her effort in the timestamp. They just use the word.
So I guess my question, Chad, I didn't get to fully read the Maryland thing. Is it a different issue? It's not the exact same issue, right? If it's a different issue, I could see why Hank is correct. If it is the same issue, I don't see why he is correct. I guess I'll say it like that.
Or methodology. Her methodology was questioned in an opinion in a different court. Has nothing to do with her opinions here. What information do they have that her methodology in this analysis has been rejected by any court?
Well, if it's a completely different topic, then that's not part of this. Then that makes sense.
What evidence they have that the methodology used in this case is unreliable or improper? They don't have any. In fact, they called an expert themselves in the last case who tried to provide what he believed to be methodology, and they presented that. They proffered that evidence as reliable.
It is the same issue?
No different on this subject. Herrera case is a totally different subject.
Your Honor, first of all, as the court has noted, the first trial is the first trial. This is this trial. I wasn't at the first trial. The most important
That is true. Remember, Hank was crying about ARCA. The first trial doesn't count anymore. So yes, the first trial is the first trial, but we're in a new trial. The prosecution could present an entirely new case if they wanted to.
And probative aspect, Your Honor, is I don't want to have to give away my entire cross in this argument.
No one's asking you to. I'm not asking you to.
There is parts of Ms. Hyde's slide that go to location. There's a good part of her slide presentation. I don't want to depart from the 227, but the good part of her slide presentation that she's going to present is on location. It is with regard to health data sets. So there are certainly aspects.
Okay, well, that makes sense
relevant.
then, Alessi.
Here's the issue with the 227 in addition. There is, for her methodology, she's claiming a certain conclusion and opinion about the 227. There is no peer review. There is no article that she can cite to support her methodology to come to the conclusion that the 227 timestamp, one, doesn't exist anymore, or two, doesn't mean that the search occurred at 227. That's what she's opined on in her reports pre-trial, and that's what I anticipate she's going to opine on when she takes the stand. I'm entitled to cross her on that. We can't be saddled. It's irrelevant what our witness has said in another proceeding. It's what this witness is going to talk about in this matter, and I'm entitled, and my client's entitled to have me confront this witness on what she's going to testify and her methodology. So my point is, Your Honor, this decision, how you impeach an expert, that one of the fundamental ways you do it is, and I don't even dehumanize her. I won't even use the term downwardized anymore. She's been deemed unreliable. Attorneys who do experts all the time, that's the verb you use to shortcut it, but I won't use it. I have no intention to dehumanize her. What I intend to do is to impeach her on her reliability. So in conclusion, Your Honor, the Herrera case, she was deemed not reliable. That's competency. You, in any expert that's been deemed that, you get to attack that. If the Commonwealth believes the case is not relevant, if Ms. Hyde believes it's not relevant, let Ms. Hyde defend that on the stand. Let Mr. Brennan make that point on redirect. But I can't have my client's constitutional right to confront her on the very subject matter she's going to testify on by anticipating what I'm going to provide for cross. I've given it, and I respectfully submit, Your Honor, this is basic cross of an expert witness, particularly when their methodology on data forensics has been deemed not reliable by a court. And one part is the location. She has in her PowerPoint she's going to testify.
Do you intend to introduce that, Mr. Brennan?
It's not significant locations. There are locations in the database that develop the opinion that the timestamp for 227 is not related to the search. They're conflating the issue. She has not been deemed unreliable. It is the issue of the significant locations by that court that they found insufficient. There's no opinion from a court that she's an unreliable expert. And this is how they're going to distort it. Invoking the Constitution and invoking the client's rights has nothing to do with the analysis. That this is a totally separate subject, or an opinion simply wasn't let in a different court out of this jurisdiction. It wasn't this opinion. It wasn't this methodology for the opinions that she's going to offer in this case. And so if you look at the case, it is a totally different related report, different related item. It's as if a reconstruction expert went into a court and attempted to give an opinion about a medical diagnosis, and the court wouldn't allow that medical diagnosis in. In another court, in another jurisdiction, they would not be able to be cross-examined that in some court there was an opinion they offered that was deemed inadmissible, unless they were talking about the very same methodology and the very same point. This has nothing to do with her opinion whatsoever. It's just an attempt to try to endorse the defense's attempt to suggest she's not credible by hiding behind the shield of a different judge and distorting the fact that it's two different methodologies, it's two different issues.
One last word. Go ahead.
Thank you, Your Honor. You just said credibility. This isn't a credibility issue. This is a reliability. This is the essence of what experts do. You have to show that your methodology is reliable. It's a red herring to bring up credibility. The court opinion.
And this is the equivalent of a superior court opinion, right? It's not an appellate
It is,
decision.
Your Honor. It is, Your Honor. It is the equivalent. I respectfully don't.
And that does hurt a little bit. You're doing an equivalent trial court opinion. That does make it a little weaker than having an appellate opinion. But I think you can challenge her credibility too, because if she's clearly a hack, use it all. But yes, her reliability, her methods are not sound. But her credibility could be attacked too. I think you should be able to attack her credibility. I would.
The level of the court, is it all relevant? Any court, unless you get it overturned on appeal, then this would be a different matter. But this is a valid case. And even if it wasn't.
This is effective advocacy. Unless he gets this is how you get the job done. You have to make these arguments. I had to make an argument like this today. You got to make them.
It shall be in evidence. So there's two issues here. And I think the Commonwealth is conflating that. The question first for the court is this admissible? Can it come into evidence? To me, that's a non-issue. Rule 39 says ipso facto, yes, as long as I got a certified copy. So it is in evidence. I don't know why we're separating respectfully on whether I can question her on something that's going to be in evidence about her. Final point, Mr. Brennan incorrectly says that this wasn't about her. The final sentence, the decretal section on page 7 says, accordingly, defendant's motion to exclude expert testimony regarding the significant location data obtained from the forensic cell extraction is granted. She's the only expert, and her name is mentioned throughout this opinion. It's all about Ms. Hyde. And I'll conclude my last point, Your Honor, where I started, and that is Ms. Hyde's methodology with regard to her PowerPoint. You heard Mr. Brennan's answer. He has included in her PowerPoint locations, steps, etc. It's exactly what was at issue here. The 227 timestamp, she has no, and this will be developed further on cross, she has no peer-reviewed article to say that how she is determining that 227 timestamp should not be in the data. She has nothing to support that, just like she had nothing in this case with regard to data forensics. Final point is, if the Commonwealth believes that this is irrelevant to what Ms. Hyde did, let them come back on redirect on that. I shouldn't anticipatory have my cross-examination struck before I even get to pursue that with the witness. And I believe once I pursue it with the witness, it will become evidently clear that it's a proper basis for cross-examination.
Right. And Mr. Lessie, have you thought about if the Commonwealth does not get into the 227 timestamp, whether you think you're still entitled to do this?
Your answer, or Your Honor, my answer is I would be entitled, but I would say this: if they don't get into 227, I won't go after it. I won't pursue it. I won't pursue use of this opinion.
We necessarily would have to on some basis, because in order for the witness to explain to the jury her opinion that Ms. McCabe did not delete any Safari browser searches, she would have to identify the search, where it is in the databases, and how she can tell, how she knows that it wasn't deleted by a user. The same with the second part of the phone calls. But if I could avoid talking about 227, I would, but it is necessary for the basis of her opinion. There's just no way around it. And again, this is something that after a defendant expert may or may not testify, could be addressed at that point. There is no burden on the defendant. I'm not being presumptuous, although there was a offer of proof earlier on similar evidence, but not knowing the court's wisdom on whether I'll be entitled to rebuttal, I do not want to lose the opportunity to address points that were made in the opening that have absolutely no basis in fact, that have not been proven in any way to this point in the case.
So I asked earlier whether the defense intended to call Mr. Green, and you believe that you do, right?
Your Honor, we have not made a decision on what data forensics expert we're going to call, but if I could just 10 seconds.
Okay, but then answer my question after your 10 seconds.
But I will. Mr. Brennan can't.
Ooh, I get the feeling that the defense has more than one data expert. It's expensive, but that's a great way to fuck with Hank. You don't know which gun you're going to use. Interesting choice.
Have it both ways. He can't say, yes, I need to address the 227 timestamp, and then deny me the ability to cross-examine fully on this expert's methodology and to impeach her and to get at her reliability and her competence, which is a key issue of crossing an expert. Her competence has been determined in this decision, and it is her, because it was her report that was the basis for the court to not allow her to testify. They can't have it both ways. You can't say, I need to do it indirect, but no, I want to handcuff the defense on cross-examination. Now to answer your question, Your Honor, we are going to have a witness that is going to address the 227 issue. Whether it's Mr. Green or somebody else, we haven't determined. My point on that, Your Honor, is we shouldn't be limited in our cross-examination of the Commonwealth.
No, I'm just thinking it in terms of whether this might be appropriate for rebuttal. That's.
And Your Honor, my point would be that's obviously going to be Your Honor's decision ultimately. But again, the Commonwealth can't have it both ways. They're the ones who are triggering this issue, and I say triggering in a legal sense. They are putting at issue the 227 timestamp with this issue, with this witness. If they weren't doing that, I wouldn't be having this discussion at all. But they're putting it at issue. I have the right, respectfully, to cross-examine on the issue that they're putting in issue. And they shouldn't get rewarded with sort of having a pre-authorization of rebuttal to deal with it. They should have to meet their burden of rebuttal depending upon when the evidence comes. But I don't believe just because we may call a witness, that should dilute my ability to cross-examine this witness on an issue they're raising. I'm not raising it.
You can see why I wish I had more notice on this, right?
Your Honor, I have no good answer for that.
So I will do what I can in the next half hour. I might need more time on this, frankly, but we'll see. She's here.
Your Honor, may I ask one?
I just want to know, is she here?
Yes, Your Honor.
Can she stay another day if need be?
I think she'll do what the court directs her to do. She would have to leave by Friday. She cannot be here. Well, may I approach?
Yeah, why don't you come up?
Okay, this is going to be weird. You do need to provide more notice. Like, that's a thing. You have to be careful. If you don't do notice, I mean, that's a critical freaking problem. You know, let's see here. Let's skip ahead. She comes back. Let's see what happens. Let's see what Bevy does. Auntie Bev.
All right, I appreciate the time. I appreciate people's patience. So, in reviewing the rules,
Notice of the island, talking about notice of the motion. And notice of this court decision. You know, if this witness has been known for a while now, very likely, and then showing up the day of with the motion saying "fuck her" and everything she knows, it's too late for that. You have to do it early enough. You know, if you didn't get noticed till that same day, fine. But these guys have known for a while, so that's the issue.
I look at Rule 2, so Mass Rule of Criminal Procedure, Rule 2, purpose and construction. And so upon reflection and consideration, it says, these rules are intended to provide for the just determination of every criminal proceeding. They shall be construed to secure simplicity in procedure, fairness in administration, and the elimination of expense and delay. Also looking to
Can we get a tower for the goodest boy around? Ah, good boy tower.
Commonwealth versus Durand. I don't have the site. I know it's from 2016, 2017. A judge, Robert Kane, was the trial judge. So because none of the purposes here in Rule 2 are served by the admission of the Maryland trial judge's decision, particularly were offered without notice to the court previously, I'm excluding that decision. Your rights are saved, Mr. Alessi. We've got that decision marked for identification, and you certainly are free to cross-examine Ms. Hyde regarding her methodology. So that's my decision. So bring the jurors in, please.
That's sloppy work. They should have been on top of that. They should have been on top of that. They should have been on top of that. That's an own goal. That is a completely unforced error on their part. Like, seriously, like, that's... Acted for, it says they were citing two different decisions. Yes. But the problem is you can't do this the morning of if you've known about it the whole time. There are times for motions in limine, like I had a motion in limine today, based on information that came out from one of the detectives. And I'm like, oh shit, now we got a problem. And then I found out that there's a witness that all of a sudden appeared that we didn't know about. Like we knew they were a witness. We didn't have their identity. We had their identity. We didn't have their location. We found out they're in the jail. Like I had to serve a subpoena at like freaking 3:00 in the afternoon on the sheriff's office. And I had to file them. Like there are times where you will have last minute things, but if it's clear you had time to prepare, the judge is going to exclude it. And that makes total sense. It makes total sense. You can't punish the defendant and they could have postponed the witness. Yeah, you can though. I mean, this is an issue. Hold on. What did Katie say to make? What kind of dog is that? Keith is saying he is a Shih Tzu mainly. He is part terrier. He's like 30% Shih Tzu, 30% terrier of some sort. Lhasa Apso, Chow Chow, all kinds of things, and a little bit of Schnauzer, like 2% Schnauzer, and 1% Ashkenazi Jew. But no, he's mainly Shih Tzu, and you can tell by his. Well, if he'll look at you. There you go. He's a Shih Tzu, and you got your underbite when you see it. So, can I send his Christmas cards from Clyde with his paw print? Yeah, we could do that. Rule 2 is a bullshit site, Lamau. Yeah, but if it's there, it's there. So, didn't Alessi get what he wanted? Oh, I don't know. We're gonna see here. Chat. So let's keep going.
You are unmuted. Chrissy, do you want this under that?
Oh, are they deadlocked and sure? That's wow. I thought they'd acquit him. Keith says, I took in a dog very similar and it was told it was all Shih Tzu, but I'm not buying. Mine looks very similar to yours. They're great. Oh, he is amazing. He's the best dog ever. You can use those. It's called Embark. It's like Dog 23andMe. So, oh, Luke, you're saying there's not even a how to interpret the rules section. Well, we've already established Beb is incompetent, so shouldn't be a surprise. Oh, you're welcome for answering. Thank you for being here, man. Thank you for being on. Thank you for stopping by. Hope you stick around. And guys, thank you for the tower. The Tyree Nichols cops got clean sweep? What? What? Are you kidding me? They beat that guy to fucking death and they get a walk? That is horse shit. That is horse shit. They murdered that guy.
Jurors, I appreciate your patience. So your next witness, Mr. Brennan.
Hey, Kurt, how you doing?
Commonwealth
Well.
calls Jessica Hyde.
Guys, give Kurt on civil law a look. Doing great work. Real quick, guys, tomorrow night, Kurt has Turtle Boy on tomorrow for an interview. I don't know what time, but Turtle Boy is coming over and they're talking. So, well, it was 3/5 of them. That's, Luke, you have to be careful using 3/5 in terms of black people. That's not a good thing. One pled, one got severed. I don't remember which one did the field goal kick. Okay. So you got to be careful how you phrase that. All right. Ariel says that's tomorrow. Yeah, that's what I said. I thought I said tomorrow. If it's not, I meant it. Kurt has the interview tomorrow night with Turtle Boy.
Follow me, please. Raise your right hand.
You solemnly swear the evidence given to the court and jury in the case now hearing the truth, the whole truth, and nothing but the truth, so help you God.
Yes, I do.
Good morning.
Good morning. Good morning, Your Honor.
All right, Mr. Brennan, whenever you're ready.
Thank you. Good afternoon.
Good afternoon.
Could you please introduce yourself to the jury and spell your last name for the record?
My name is Jessica Hyde, Jessica space Hyde.
What do you do for a living?
I'm a digital forensics examiner. I'm also an associate. I'm also an adjunct professor at George Mason University, where I teach mobile device forensics in the graduate program. I also own a digital forensics company that does.
Did she? I don't remember her with this shit. What the fuck is on her head? What the fuck is on her head? That is obnoxiously large head wrap. What the hell she got going on under there? It's like a cone head.
Training services
One of the crystal skulls.
and research.
In addition to teaching at Georgetown University, do you teach in other ways?
Correction, I teach at George Mason University,
I'm
not
sorry.
Georgetown. But thank you. I also
Well, yes, George Mason University is different from Georgetown, but they're both very good. And he's back to using my voice. Well, for some reason, he stopped for a couple of days. I don't know why was that, but yeah. Can't wait till we have one where just, we'll hear that on screen one night. Just keep it up. Well, actually, that is a big deal. That is a big deal, though, Chris. For people that are there, they have a right to, there is a big difference between Georgetown and George Mason. Ask the people who go there. Holy shit, they will let you do that. Like, they will tell you. Andrea says she's got dreads or crazy hair color. She very well could, and if she does, that's why you're not supposed to look like a fucking weirdo when you testify. I think it was in this case, or one of them we watched in the past year, where one of the experts or one of the lab analysts was like a fucking weirdo. It might have even been like a troon or something. And it's like, no, you got to look fucking normal when you go to court. So.
teach. My company writes and develops training courses. I teach a mobile forensic analysis course and a data structures course there to law enforcement, civilians, etc.
Do you engage in any other type of academics or research?
I do. I do other research as part of some volunteer activities I do in the digital forensics field. So I'm the chair of DFIR Review, which is a body that reviews practitioner-created research so that it can go through peer review. I often do reviews as a member of a reviewer for Forensic Science International Digital Investigations Journal, which I was a previous associate editor of.
What does peer
Oh, I'm so sorry.
What does peer review mean?
Peer review means that when a study is done or a research paper is done on a topic, that an assessment is done of it. There are three types of assessments that can be done. One is a methodological assessment, where you read through the methodology of the academic or practitioner-created paper and state if it is acceptable or not. The second is you conduct your own testing using the same methodology to conduct a peer review with your own generated data sets. And the third is if the original author has shared their data sets, reviewing their data sets and checking that against their work.
Has any of your work been peer reviewed in the past?
I've had 2 peer-reviewed journals. I've had an article that was peer-reviewed and published in Forensic Science International Digital Investigations regarding the standardization of file classification of recovered items. The layman's term of that would be talking about what deleted means. And then I have another paper that's been accepted that I was a co-author on in terms of timelines and correlations of forensic evidence.
You mentioned you work in forensic data analysis. Generally, what does that mean?
It means that I look at evidence of digital forensics devices, be them mobile phones, computers, Internet of Things devices, and do analysis to provide meaning and context to the data that's recovered from them, as well as performing data recovery of those same computer-related devices.
Debbie for $5 here. We're gonna get this out of the way real quick, just because I do think it's important. Debbie says, I have a bachelor's from George Mason. One of my sisters has a bachelor's from Georgetown. Completely different schools, completely different educations. Very, very true. Very true. But they both have phenomenal law schools that I probably was never going to be able to get into. Thank you for the super chat, Debbie. It's good to see you, by the way. Hope you're doing well. She needs an eyebrow pencil. Yeah, well, we all do.
Did you have any specific education or training to learn about forensic data?
Absolutely. I have professional training both from courses I've taken, as well as I have a master's in digital forensics from George Mason University. A master's degree in that. I've taken multiple courses, advanced mobile analysis, iOS forensics courses from SANS, computer forensics courses from SANS. I have multiple certifications. I hold the GIAC GCFE, which is the GIAC Certified Forensics Examiner. I also hold the NWC 3CFE, which is a Certified Forensics Examiner.
Do you, through your company, teach other forensic examiners how to study forensic data?
Correct. I teach government agencies, both federal and state and local, how to do digital forensic analysis, as well as private sector digital forensics examiners.
How do you teach private digital forensic examiners? What's the method?
I've developed an online virtual course that we teach virtual live, so I'm always there when I'm teaching, but I also have a team of instructors. So for example, the mobile forensic analysis course that I developed right now this week is being taught to a police department in Texas right this moment.
Forensic data analysis seems like a broad field. Is there certain parts that you focus in?
I personally specialize in mobile phones and Internet of Things devices.
I want you to just give us some very basic, very general and brief background. When you're looking at a forensic device and you're analyzing it, do you rely on any tools?
That is a really interesting question. Reliance on tools is not precisely what we do. We utilize tools to extract data from a device, and then we utilize a variety of tools to attempt to parse results from those devices. But the forensics examiner has to take the additional step to both understand, validate, and provide meaning to those results.
Is there any shortcomings or dangers in simply relying on a forensic tool for a result or an opinion?
There is absolutely a danger in just relying on parsed results. When an algorithm is used to determine what data is stored as, it doesn't tell you what that data means, and that's where you need a forensics examiner. Tools don't necessarily understand how the data got there and what causes the data to exist, and that takes deeper and further human analysis, as well as, if you think about it, if on your phone, you can go to the Google Play Store or the App Store, and you can actually download millions of apps. There's like 6 million apps between the two stores. Digital forensics tools maybe support generously 1,000 applications. So in order to be able to parse and understand the data from applications that the tools don't know how to support, you need a forensics examiner who knows how to dig into that data, conduct testing, and determine the meaning of the data.
Were you asked by the Norfolk County District Attorney's Office to look at and analyze a phone that was related to a person by the name of Jennifer McCabe?
Yes, with a very, very specific scope to a specific date range.
Were you asked during that scope and date range to analyze it and provide an opinion about whether there were any user-initiated deletions of any web searches or Safari-type searches?
Yes, I was asked to look for deletions of Safari searches within the scope of the time frame that was dictated by the purpose of the exam.
Were you asked to look at the phone device and determine whether or not there were any user-initiated deletions of phone calls on the device?
Yes, I was asked to look for deletions of phone calls in that same date range.
And did you do both of those tasks?
Yes, that's correct.
Did you ultimately have opinions on both of those issues?
I do have opinions on both of those issues. That's correct.
And engaging in the efforts to answer those two questions, did you necessarily have to review and analyze a web history that included searches on January 29th, 2022 at 2:27 a.m.?
I did analyze web searches that occurred at 2:29 a.m. on local time here in Norfolk on January 29th, 2022 from the device that was provided. Yes, not the device, forensic image, for clarity.
So before we get to the two opinions that you were asked to consider, or what your opinions were after analyzing the data, I want to begin by giving the background and having you share with us your analysis and your observations and opinions about the search on Safari relative to this 2:27 time frame. Before we begin that, let me just ask you one question. Did you do anything to ensure the integrity of the data that you were looking at?
Upon receiving the forensic image, the first thing I did was I did what's called a hash of the image. So a hash is an algorithmic representation of a file. So a forensic image, all the data from the phone, it comes in one file that can then be extracted and have the rest of the data. That singular file that's received, there's actually three, but focusing on the one that has all of the data, that archive file, you can run what's called a hash algorithm against it. There's actually multiple hash algorithms, and I hashed it, and then I validated that hash to the document that was provided along with the image file that contained the hashes that were contained in. Those hash values matched. Now, just for clarity, if you change one bit in a file, it will not have the same hash. So the hash provides integrity, and having used both hashes, which are available in that report, and ran two different algorithms, they both matched. Additionally, I reviewed the PDF that was received for signs of alteration. The PDF that comes with a Gray Key report is not signed by Adobe Acrobat. However, I was able to take that PDF and then examine it just like I would a phone. So I'm using the same techniques on the phone. Using a tool called EXIF tool, I was able to learn a lot about the creation of that particular PDF. And what I was able to learn about it was that it was created by, it's labeled it as being produced by Grayshift using a particular code-based application to create the PDF called PYF PDF, standing for Python Framework PDF. It is on, it's a program that you can download, and developers who create tools like Magnet Forensics, who owns a Gray Key, utilize that script, which is why it says it's produced by it, to create the actual PDF. That's what the evidence there in the data tells me. It also contains a time of when that is created, and that time was February 2nd, 2022, at global UTC, that's the global constant time, think what's in the UK, at 22:49, which local time would be 5:49 p.m. So that says that it was created approximately 2 hours and 45 minutes after the document said the image started, and it correlated with the document information. So that provided some level of certainty that that document was factual. And on top of that, I further opened the file of that PDF in what's called a hex editor, which lets me see like every byte, every 1 and 0. And from doing that, I looked for tag markers that are made sometimes in some modifications of PDFs called XMPs, which is Adobe's format of markup. And I did not find any evidence of those tags.
When you're trying to determine whether there's integrity in the data, are you able to tell whether or not there's been any alterations or tampering before the item is put on the Gray Key machine to make the extraction?
That would be when you're talking about if the physical device had been manipulated, is that correct?
Yes.
I cannot tell if the physical device has been manipulated prior to it being imaged. I can only validate if the image was correct. In theory, all of the data of anything that you did on that device would still show in the evidence of device logs and whatever locations that were touched or communicated with. But at that point, it's the same as any user interacting with the device itself.
After the phone's extracted or at the time it's extracted, does it have the history of the device on that extraction?
Could you rephrase?
Yes. At the time the phone is extracted and the copy is made in the PDF and the digital copy, does the digital copy and the PDF contain the history of searches and calls and other items on that phone?
The forensic image itself contains a variety of different artifacts or traces that are left behind by activities that a user does on a phone. Yes.
You use the term artifact. What does that mean in a basic sense?
An artifact is any type of evidence that is left behind on your phone of an action. So, for example, if you receive a call, there are multiple places in the phone that show that a call was received. That can be in the call log. That could be in a notification. That could be in a unified log that tracks the activity that the phone's doing. There's multiple locations, and each one of those residue of the fact that the call came in, that's what I would refer to as an artifact. So you could have an artifact not just about a call, about a web search, about taking a photo, any action you take on your phone may create an artifact.
Before we get into the two questions about any alleged deletions from Safari or Google search or internet search, and any alleged deletions of phone calls, I want to start with your explanation or your sharing how the time.
I wish I knew enough that just listening to her, I could tell you she's full of shit, but I know I'm going to have to wait till cross. Sorry, chat.
Timestamp works relative to that search beginning at 2:27 a.m. on January 29th, 2022.
So for clarity, there's more than one
See ya,
search that
Palmyra.
happens actually at 227. There is some activity that's looking at, and I don't want to mispronounce the name of the town. I'll try Hockomock Sports, looking at activities for the sporting events at that school system, I assume, or county location. There is a timestamp
She is a white
for the
version
search
of
How Long
Krogan.
to Die in Cold.
Well,
However,
yeah.
that
Krogan's
timestamp
white
isn't
too, I
about
think,
active
though.
searches. It's about the time that a tab was either opened or moved to the background. So How's Long to Die in Cold is the most current search in the tab that you opened at that was opened at 227. So if you're using your phone and you go to your browser, you have some choices. You can just open an existing tab or you can open a new tab. A new tab was opened at 2:27 a.m. and that search was done there. Another tab, actually at 2:27, was moved to the background, and its last search at the time it was moved to the background was for, I believe it's Raining Men, the YouTube video. So those two searches both exist as what's called browser state searches, but that browser state isn't about the time that it was searched. It's about the time that the browser tab that you opened either went to the background, or if it's never been moved to the background, the current search. So the time in the instance of the It's Raining Men video is the time that that video was moved to the background and the new tab took over as the tab that's active. And that tab, the last search done in that tab is How's Long to Die in the Cold, because that database holds the current search. It constantly gets updated, and the time that the tab was either opened if it's the first time it's opened, or moved to the background if it's an existing tab.
Did you put together an exhibit that would help explain some of
I
the different
did
databases?
put it together an exhibit that would show that.
May I approach?
Yes.
Handing you a piece of paper. Do you recognize that?
I do. This is table 1 from the first report I created on this case on the phone that I was told was Virginia.
Is that the exhibit that will help you explain?
It will.
I move this to evidence.
Will you go, Chairman? Or have that bit back if you want.
Come on up.
So yeah, she talks over him. This is a bad witness. This is a bad witness. She doesn't understand how to talk here. Any expert that uses air quotes is super reliable. Yeah. Yeah, that is a bit of a thing there, huh? Well. All right, let's see how far we have to go ahead here. There we go.
Before we look at any chalk, I want you to explain the entire basis for that chalk and your ultimate opinions that are reflected in the chalk. So let's start from the beginning.
May I
And-
look at my copy of the chart or no?
Why don't I just ask you,
No, until that comes up, no.
Yes, Your Honor.
when you looked at the phone to analyze it, were you trying to determine when a particular search was made, specifically the search How's Long to Die in Cold?
Correct. I was looking for two searches, both How Long to Die in CIKD and How's Long to Die in Cold.
So as a forensic examiner, how do you begin the process to try to identify and determine when that search is actually made?
So the first thing we would want to identify is what application was being used at the time to make the search. So looking at that date timestamp, it was able to, on that date, be able to determine that Safari was the application that was being used as a Google browser. And then you would begin looking at the artifacts for Safari, both those that are parsed by the forensics tools, but then further looking into the data structures that hold that data itself, and then ultimately conducting testing to determine why a certain artifact exists.
So you mentioned the beginning step is the forensic tool or tools. Did you use forensic tools to get information to parse any data regarding this potential search of 227?
Yes, I use multiple forensics tools.
Can you share with us the multiple forensic tools that you used?
Absolutely. I used Celebrate Physical Analyzer. I used Magnet Axiom. I used just the tools I used at first. I used iLeap. There are further tools I used later, but those were the three that I started with.
What tools did you use later?
Later, I used specifically, I used Sanderson's Forensics Toolkit, the forensics browser in Sanderson's Forensics Toolkit, which helps exploit SQLite databases. And then I further reviewed in a tool called Rabbit Hole.
To begin with, Celebrite, is that a tool that you're familiar with?
Yes.
Is it a commonly used tool in the industry?
Yes. Commonly used mobile forensics tool.
Is it reputable?
Highly reputable.
Why did you use Celebrite?
I use Celebrite because on any mobile exam, I'm going to validate what is captured by Celebrite and Magnet Axiom because they have the most robust parsing of what is in my tool arsenal. And then I would also follow up with iLeap closely behind because iLeap has a lot of artifacts that aren't supported by either of those tools. Using a variety of tools is going to give you different coverage, and each tool has a different perspective on how they view and display data.
You said you also use Magnet Axiom.
That is correct.
Is that a leading forensic tool as well?
Yes, that is also a leading forensics tool.
Are you familiar with that company?
I'm very familiar with Magnet Forensics. I was actually their director of forensics for 5 years, then continued to consult for them for an additional 2 years under my company Hexordia, and my company continues to be a reseller of Magnet's products.
You mentioned different tools may present information a different way. Do those tools change the underlying data at all?
That's a great question. So when we're talking about the results that a tool shows, the tools maintain the integrity of that original forensic image. And that's actually something we verify as we continue through our exams to make sure that the underlying data hasn't been changed. There are some tools, I did use some other tools, I apologize. I also used ArtX and Mushy. But ArtX is capital A, lowercase RT, capital E, lowercase x, and then Mushy is MUSHY. You're welcome. I'm sorry, can you repeat the question? I got the spelling threw me off.
I mentioned, or I asked you about using multiple tools and whether or not the use of different tools changes the actual underlying data.
So the actual underlying data is always maintained, and we do validate that. Some tools allow you to see parsed results and then allow you to dig deeper into looking at the actual files and data structures. Those would be tools like Celebrite, Physical Analyzer, and Magnet Axiom. Some tools show you the parsed results and tell you where they got them, like iLeap. It shows you the parsed results and tells you the file location, and then you would open that up in an external tool. And then some of the tools I used are not tools that parse the results, but are tools that allow me to manually look at the data structures. So they directly allow me to look at the data structures. And all of the tools I use in this instance are tools that do not change the underlying data.
Is it important or critical to go beyond the tools presentations and actually analyze the data yourself?
It is absolutely critical. Actually, in the NIST Scientific Foundations paper from the National Institute of Science and Technology that states the foundations of digital forensic science, it states that it is the examiner's duty to not only verify and validate tool results, but also to provide meaning to forensics parsed results.
Does software update regularly?
The software updates all the time. Typically, we get an update about once a month. And to be honest, it's not enough to keep up with how many new apps are developed and how many new phones come out and how many of your applications get updates, new features, for example, maybe in Instagram or Facebook. So the tools update very, very regularly.
When you use the Celebrite tool to analyze the 227 search, did the search How Long to Die in the Cold have a timestamp on it?
There are actually multiple artifacts for How Long to Die in Cold. Remember earlier we defined an artifact and we spoke about it was one of the types of traces. So there are multiple traces for that How Long to Die in Cold. Only one of them is associated with the 227 timestamp, but there are other instances of evidence of that was parsed by Celebrite.
Is there any danger for an untrained eye to rely simply on the software when looking at a search like this, How Long to Die in the Cold, and seeing the 227 timestamp?
Absolutely. There's a really scary danger that an examiner who has not dug into the artifact and tested to see what it means may assume erroneously that that 227 timestamp is the time that what is there is searched. The search in that field of that artifact is going to always be the most recent search in the tab, but that timestamp actually means either the time that that tab was backgrounded or if it's the first time the tab's been opened, when it was opened. So you could erroneously implicate a search was done hours or some time period or even days before it actually occurred. Some of us leave our tabs open forever.
In your teaching, examiners and students, do you teach about the specific?
Afix, you're saying, why don't they object and force them to say How Long to Die in the Cold every time? I don't know, but this, I don't know. And guys, this doesn't make, okay, you know, there are tech people out there laugh at me or whatever. This doesn't make sense. It does not make sense to me. So, yeah, this doesn't make any goddamn sense at all. I mean, like, I have a science degree, chat. I'm a political scientist. I still don't understand this.
Concerning concept.
Yes, I teach about this concern both in my mobile forensic analysis class, my mobile forensics course that I teach at George Mason University in their digital forensics master's program, and in the data structures course where we specifically learn how to analyze these databases in question.
In your experience, how common does an untrained examiner make this mistake?
I wouldn't be able to speak to how common an untrained examiner does it, but regularly my students get those questions wrong on earlier examples I give them in class to kind of indicate to them that they could easily make mistakes without understanding meaning, and I use it as a teaching aid. So teaching, 90, 100 easy students a year, I regularly see that in untrained examiners that I'm teaching in my class, but I wouldn't be able to say that across the discipline.
You mentioned that Celebrite showed the search on the report as How's Long to Die in the Cold with a timestamp of 227. Is it 227:40?
Yes, that's correct.
Do you know whether or not Celebrite has updated its software?
In May, Celebrate of last year, Celebrate made an update to their software actually to remove this artifact because of its ambiguity and the risk that an examiner may overstate or misstate what it is.
Is this ambiguity reflected in other types of software?
Could you rephrase, please?
Sure. For example, when you did a report in Axiom, did it have similar reflection in the report?
Objection, Your Honor.
Ask it differently.
Did you run a report regarding this time frame through Axiom software?
I did process the image through Axiom, yes.
When you did that, was it the same or a different result?
Axiom and Celebrate really show their data very, very differently. So Celebrate takes a perspective of alerting people to possible deletions by annotating either a question mark or a red X next to artifacts that come from different areas. Magnet instead marks if the artifact was parsed or carved. I feel like now I need to explain to you parsed or carved. So parsed means that the data was where it was expected to be found, and the algorithm was able to cleanly see that this is there. Carve means that it had to run that algorithm against the data structure as a whole and found it as a partial result. So it carved it out and went and found it instead of it just sitting there exactly where it was expected to be, and shows you both the results. So it'll show all of the results of, in this instance, the sessions, tab sessions, but the data browser DB, the tab state, it's going to, instead of telling you this has a red X, it'll instead say it was carved. So it's a different presentation of the same data.
So I want to talk about deletions in a little bit, but I want to get back to the 227 search.
Sure.
So when you produced or you looked at the report for Celebrite and it showed this timestamp as well as the phrase "How's Long to Die in the Cold," where did you look? How did you make an analysis to determine whether or not that search was actually made at 227 or another time? What was your next steps for us?
So in looking at that timestamp, the first thing I did was actually go and look at what literature exists on the artifact, if anybody had reviewed this artifact before. I also created my own data set and tested how we could get what that timestamp means. So if I make a search in a tab, and then I make another search in the tab, which timestamp is it? If I make a search in a tab and then open a different tab, what changes? I also looked at the documentation in the artifact reference guide for Axiom, which does state, it describes that timestamp as the time in which the tab is backgrounded, and it gives a stipulation that in certain circumstances, the timestamp can be earlier than the search.
Did you specifically look in any databases or for artifacts in the data to help make an analysis of when the search happened?
Of when the search happened as a whole? Absolutely. So there are multiple databases that I looked at that show search information for Safari. So I looked at the plist, mobile Safari plist. I looked at the browser state database. I looked for the history database. I also looked at the Knowledge CDB. The Knowledge CDB is a little bit different. That isn't a database for Safari. It's a database for all of Apple, so it can predict your behavior. So it takes in information that Apple wants to take in, including browser history, and it saves that information so it can make predictive information. I also looked at the caches in the Safari, which is the things that Safari is trying to make quick reference to. This would include suggested terms for commonly searched items.
When a URL or a search through Safari is typed in, or if it connects, does it leave a trace in different parts of the computer or the phone?
Yeah, so when you actually do any search, you're going to leave traces. Now, it does depend if you are in private browsing or non-private browsing. So non-private browsing is what most of us use regularly. Private browsing might be what you elect to use Well, some people would elect to use it if they're doing searches they wouldn't want their spouse to see, like maybe they're looking at porn, or maybe you're doing something secure, like looking at your banking information. You may intentionally use a private browser. For Google users, this would be the equivalent of incognito in Google Chrome, and you may intentionally use that. And so the artifacts for that are more limited than the artifacts for non-private searches. So some of these artifacts only exist for non-private searches, and some exist for private searches.
And in this case, this phone, was it on non-private or private?
So specifically the two searches we're talking about, how long to die in cold and how long to die in CIKLD, excuse my differentiation there. Both of those searches were done in non-private browsing.
So they weren't hidden.
I don't understand the question yet.
Was there any applications on to mask those searches?
Not to the best of my knowledge. I did not see any.
We began with the 22740 timestamp. The next recording on that tab, do you recall what time that was?
I believe the next, and I'm trying to remember the chart from memory, if that's correct. So I believe the next thing we're looking at is the 623 suggestion from Apple search terms for how long to digest food. Am I matching what you're seeing on your chart?
Well, let me ask you.
Okay.
When you saw that, do you look on the same tab or a database? Where do you find that information?
Fair, understood. So all of those databases I was just mentioning before, we're looking at all the parse results from all of those. And I was looking in the entirety of the scope from the time of midnight till noon. That was the time frame of my scope of all of the content that was done in the tabs for Browser State DB, Cloud Tabs artifacts, History DB, Mobile Safari plist, Knowledge C, each one of those. And then I was combining them to timeline out the activity.
At 62351, did you look into how long TIDIE in CIKD?
So that would be the next thing that we see after
This is getting ridiculous.
After the Apple suggested term of how long to digest food. That's the next thing we see an entry of that. There's two immediately next to each other. I don't remember the precision on the seconds of which one's first off the top of my head, but one is in Knowledge C and one is in the Mobile Safari list.
Can they appear in different rooms in the data bank in different places? The same search?
Searches appear in many different places. They can leave traces, such as
Digital Void saying this is like a lawyer confusing jurisdiction with venue. Is there something I missed? I don't get the joke, but okay, that helps a little bit. This just like, okay, so it happened sometime after 227, but it's still, this doesn't make sense how that works. It doesn't make sense how that works. And she's hypothesizing because she doesn't have the Apple source code. So ultimately, like, that's the biggest thing here. None of this shit makes sense because you don't know what the Apple source code looks like. So I'm just, I don't know.
As that knowledge CDB. I love that Apple calls that knowledge. It's like what it's trying to learn. So the knowledge CDB, what Apple's trying to learn about you, as well as in that mobile Safari P list, as well as at the moment of that search, which I don't have the device in that moment, but just so there's an understanding, that open tab, the URL would have been updated, or URL is the website, would have been updated to that search at that moment. Had we imaged it at that moment, it would have been how long to die in CIKD.
And finally, at 62447, did you identify any artifacts with that search that appears with the timestamp of 22740? Did you find the same?
Correct. At 624, we have two timestamps in the same two locations for Hoslong to die in cold, the Knowledge C and the Mobile Safari P list.
So based on your analysis in that issue, did you come to an opinion whether or not the phrase "how's long to die in cold" was actually searched at 2:27 a.m. on January 29, 2022?
There are no artifacts.
So the answer is yes or no.
Can you repeat the question, please?
And so based on your analysis of the phone and the data using all of those softwares, did you come to an opinion whether or not the phrase "how's long to die in cold" was searched at that timestamp tab of 2:27:40?
Yes, I came to an opinion.
And what is your opinion?
Rephrase the question as to the opinion.
I'm sorry?
I'll see you at sidebar, Mr. Leslie.
All right, here we go. Okay, let's see here, chat. We're gonna move along. Let's see. Ooh, wow, we got a break there. That's a bit of a discussion.
You've explained to us the analysis you engaged in and the process you engaged in. In forensic data analysis,
Good question, Peter. We'll talk
is there a
about that.
methodology that you use, not just looking at the printout of the programs, a methodology you use that is accepted in the industry for experts to analyze this data and come to your opinion?
Absolutely. Beyond looking at what was in the tool results, I further looked at those databases independently and conducted testing of the artifacts.
And in addition to what you did, can you share with us how and why this methodology is accepted in your practice as forensic analyst?
This methodology is accepted by NIST and by organizations like the Scientific Working Group of Digital Evidence. I'm intimately familiar as both a member of the Scientific Working Group on Digital Evidence who helps work towards the building and development of these consensus-based documents of procedures to be followed in digital forensics analysis, and as a member of the National Institute of Science and Technology, NIST, Organizational Scientific Area Committees, OSAC, Digital Evidence Subcommittee. Where we also produce guidelines such as the dataset guidelines for generation of the guidelines for dataset generation, which is how you do your actual testing and creation of datasets. And I was also a part of the subcommittee that drafted that. So I'm intimately familiar with the accepted policies and procedures because I am also a member of the groups that help author these, as well as review them and look and use them.
Are there articles and guidance in the industry about this particular practice of analysis?
For analysis, just for clarification, you're talking about for analysis of Safari artifacts, of mobile forensics, of browser state DB, just for clarity on the question.
Let's work our way through it. How
Sure.
about through Safari?
For Safari, there are multiple different blogs that talk about Safari, as well as I have analysis of Safari through classes I took, such as SANS 4508, which is 518, SANS 4518, which is the Mac and iOS analysis course, which I took.
How about the specific guidance regarding searching the different databases for artifacts?
In terms of methodology for digging into databases,
Yes.
is that correct? There are multiple, I've taken courses throughout my master's program, courses on how to analyze digital forensics artifacts, including mobile device forensics, throughout my GIAC certifications. I've taken multiple instructor-led courses on how to do these, as well specifically that cover mobile Safari history. In mobile forensics at GMU in his master's program as part of the SANS 4518 class. And in terms of data structures, I've taken study on how to analyze databases like SQLite and PLIS are covered in those courses.
There are books on study on this methodology?
There are multiple books on digital forensics, many of which I've read, and including books specifically on analysis of SQLite databases, such as Sanderson's SQLite Forensics, which is probably the most authoritative because not only was it written by Sanderson, who makes a tool, it was tech edited by 3 renowned forensics examiners, as well as Dr. Richard Hipp, who created SQLite itself.
The methodology, the technique you use to look past the reports and actually look at the data to make your determination and arrive at your opinions, is that methodology regularly accepted within the forensic data community?
Absolutely. Again, using the methodology from the consensus-based documents from the community, from the Scientific Working Group Digital Evidence on best practices for analysis, as well as specifically for the SQLite databases I was looking at. I do that deeply verifying and in accordance with the understandings from Sanderson's book.
Now, you shared with us that you had an opinion regarding the timestamp and whether that it was applicable to the search term, how's long to die in cold?
That is correct.
Now, I want to ask you, to a reasonable degree of forensic data, scientific certainty, what is your opinion about whether the phrase how's long to die in cold was made at the time of the timestamp 2/27/40?
It's the last time this policy on this issue, okay?
She's like, the last time I'm going to see you on this? Why? If there's more problems, they have the right to object. This is nonsense. Don't threaten to limit their sidebars, Bev. Is it really, guys? We're almost like halfway done already, and they still have a lunch break and shit? Really? This is insane. Like, this is a fast day in the court.
All right, go right ahead, Mr. Turner.
I'm now going to ask you for your first opinion. So you shared that you have an opinion about whether that timestamp 2/27/40 was, whether or not that was the time the search how's long to die in the cold occurred. Can you tell us, to a reasonable degree of scientific certainty, your opinion about whether that search, how's long to die in the cold, occurred at 2:27:40 a.m. on January 29th, 2022?
Okay, the objections are overruled.
What I can state to a scientific degree of certainty is that that search occurred at 6:24 a.m. and was the last search in the tab that had been opened at 2:27.
Do you have an opinion to a degree of scientific certainty whether there was any other searches similar to How's Long to Die in the Cold that evening on that tab?
Yes, Your Honor.
May I first inquire, you meant morning, as I
I'm sorry,
assume?
that morning, yes.
Just clarifying, I did not look at evening searches. And can you repeat? I apologize. I disrupted my own train
Do
of
you have an
thought.
opinion to a reasonable degree of scientific certainty whether there were any other searches on that tab before the final search at 6:24:47, How's Long to Die in Cold?
Just ensuring that I have the question correct.
Please.
You're asking if what else occurred in that tab prior?
Yes.
That I cannot say with a clear degree of certainty.
Did you develop a chalk that I
I
showed you
did.
earlier?
Yes.
Like to approach?
Yes.
Again, I show you. Same document, you recognize it?
Yes.
What is it?
It is the exhibit that I created that was labeled Table 1 in the first report I had delivered.
And does that provide information that will assist us in understanding your opinion?
Yes.
I've moved subject to redaction that this be introduced into evidence.
Your Honor, I have no issue with regard to the redacting aspect, but consistent with my prior redactions, I would object that.
Okay, I'm going to allow this into evidence. Your rights are safe.
Thank you, Your Honor.
Madam Clerk, 82?
Exhibit 82.
Thank you. With the court's permission, I'd like to show Exhibit 82 to the jury.
Okay.
Could we enlarge the first two?
And Digital Void, this is a great point. She has a financial interest in Magnet being considered good. And remember, these things all analyze is how you make your money. You make your product do the same thing, just different. So we look at different data. We look at different data. We look at different data. We process the data differently. So yeah, she is trying to say why her shit's good. She has a financial interest in it.
We're going to need to get the right column in if we can, please. Thank you. Ms. Hyde, can you see it from there?
I can. Thank you.
If you can walk us through how this exhibit assists us in understanding your explanation and the basis for your opinion.
This exhibit shows the Safari artifacts and artifacts of Google searches in Safari related to the two searches in question, How Long to Die in CILKD and How's Long to Die in Cold, that occurred on the morning of November 29th, 2022 on the device under examination.
If I look at this chart and I see in the top left, it says 2:27:40 a.m. And then under the search term, it says How's Long to Die in Cold. How do I understand your opinion that that search didn't happen at 2:27:40?
This document is showing you the data that is the parsed result. The source of that artifact that you see in the last column is a little bit cut off, the browser state db-wall file. That database does store how the data is stored, the search term How's Long to Die in Cold with an associated MAC absolute epoch timestamp that translates to 2:27 a.m. That is what is physically stored. That does not annotate the meaning of that artifact. That was determined through testing following the NIST OSAC data generation guidelines for testing.
In the second row, we see a timestamp on the left-hand column, 6:23:49. And it provides artifact to cache record.
Mhm.
What is the term? And what does that mean under the search term?
iOS Safari cache records. A cache refers to something that a computer program wants quick and easy access to. When we search on our phones, anything, a lot of times, be it in Google or in Safari, depending on what type of phone you own, it'll suggest what it thinks you're going to type in, right? So you can click it. It's trying to be helpful. In this instance, at 6:23:49, we have a cache record that indicates that Apple suggested the phrase, how long does it take to digest food?
And then under that, 6:23:51, it appears it says a recent web search, and the spelling is changed. How long? TIDIEINCIKD.
So this, in reference to these two search terms, this is the first actual search that occurs at 6:23:51 a.m. Upon beginning the typing of that phrase, Apple provided the suggested search, and the person inputting into the phone at that time continued to type out a phrase and finished it as how long, TIDINCIKD. Which that is available to us in the mobile Safari P list, which tracks recent web searches. And then we'll see 6 seconds later, we get that reference in that Knowledge C database that I mentioned before. That's the next line. So that's the Knowledge C database is Apple's way of keeping knowledge about what the user's doing it sees and holds your knowledge. It's an easy way to remember it. That's what I teach my students. So that knowledge CDB tracks a lot of things for predictive purposes. And so 6 seconds later, it's logging that same search. So that search is being tracked in 2 places.
And so one search can be left as artifacts in different locations on the database?
Correct. There can be multiple traces or artifacts of the same user action in different places on a mobile device.
And if we go down to the bottom, the last column, at 6:24:47, we again see "how's long to die in cold." And if you look in the first column, it's the same phrase. Is that a coincidence that it appears at the bottom at 6:24:47 and also appears up at 2:27:40?
As mentioned before, through testing of the artifact for Browser State DB, that artifact will hold the most recent search that happened in the tab. So it is logical that HOS long to die in cold was searched at 6:24:18, tracked in that mobile Safari plist, repeated in Knowledge C, Knowledge made its tracking in the Knowledge CDB, and then that table for Browser State DB, which again has the time that the tab was opened or the last time it was backgrounded, and updated just the website that was visited. So the website, that is why we get that 2:27 time. That's actually, as far as the data storage is, the first thing I have in there, because I want to put it in chronological time order for exhibit purposes, is actually the last thing to happen because it's the update to what's in the tab.
You offered that the "how's long to die in cold" is the last thing to happen. Do you have an opinion to a reasonable degree of scientific certainty of the time when that search was made?
Objection, Your Honor.
To a reasonable degree of certainty, I can say that HOS long to die in cold was searched at approximately 6:24 a.m.
Now, moving on from the 227 search, there are 2 other issues that you were asked to analyze. We talked about them at the beginning. Let's begin with whether or not you looked at the data and analyzed the data and came to any opinions about whether that phrase, "how's long to die in cold," was user deleted on that device.
So there's 2 really key elements as to if that was user deleted. If the question is, did I come to opinion? Yes.
And can you explain how you came to an opinion that we'll ultimately share with the jury?
The first line in that exhibit, the ending of that, if you remember, it said browser state.db-wall. That's important. So we'll talk about that in a second. But the first thing I want to bring up is kind of how the database works, because I didn't just look at the tool result. I extracted that database and I did a deeper analysis on it using Sanderson's tool, because that information was in that -wall file. So when a SQLite database, which is a specific way of storing, very, very common on mobile phones, actually one of the most common, when that database stores data, it has 2 versions. The most recent version, and the version in use here, uses what's called a write-ahead log. So before data is committed, it is written to a write-ahead log. I'll kind of explain it. So let's say we're in a restaurant and we're sitting at a table and we're ordering food. Our table is the table. Data is going to come to the table, and that's going to be our food. So when we order food, let's say we've got a chicken sandwich, a burger, and a pizza coming to the table. The chicken sandwich, the burger, and the pizza, the kitchen puts it in the warming area. It's the write-ahead log. The server grabs it from there. It's where data sits before it goes to the table, just like your food goes to that serving station before your server brings it to your table. Server brings it to the table. That table's got its burger, its chicken, and its pizza. Another table orders waffles and pancakes. They think it's breakfast. The waffles and pancakes are made by the kitchen. They're put on the serving area. Waitress comes over. This pizza has pepperoni. I don't eat pepperoni. Can you send it back? Waitress picks up that pepperoni and sends it back. That's a deletion. Pepperoni pizza was just removed from the table, right? We're deleting it. We said it's not what we wanted. The waitress is removing it. She brings it back to that serving area. At that moment, that serving area has the deleted pizza, but also the waffles and pancakes that are waiting to go out to the table. That's how a write-ahead log works. Any changes that are happening sit in the write-ahead log until the database is closed. And then when it's reopened, all those changes are made, both additions and deletions. So often when a phone is imaged, when we make a forensic image,
I have a quick question. Can she explain how the data got, like, any of those deletes? Ian Whiffen was like, how did this shit get deleted? I don't know. Does she believe the random ghost deleting theory? That apparently the Apple iOS just fucking deletes shit left and right? Does she believe that too? I know we haven't gotten there yet, but has that come up? Because I really want to know her fucking answer to that. Because that'll tell me, I'm not an expert, but that'll tell me if she's full of fucking shit or not. Well, let's see.
Applications are still open, so we have those wall files. When we look in our Safari browser, the database knows to read it to you in its current state. So it tells you where the waffles and pancakes are going. They're going to that table. So it shows it as if it's in the table, but it's not in the table yet. So if when we parse the data and we look at the restaurant and we don't look at the back kitchen, we would only at that time see the chicken and the burger, right? Pizza got sent back, waffles and pancakes haven't come out yet. So when we get the data, we get two files. We get the restaurant.
She is not making this this restaurant thing does not work for me. This makes no fucking like this is a horrible fucking example.
That's the database, and we get the serving area. That's the wall file. Just because it's in the wall file does not mean it's deleted. It means that that record wasn't where it naturally sits yet. It could be.
No, Joseph, we're not going to that.
That wall file can contain deleted
Cleveland Stuffer's enough,
food
man.
Or data that hasn't yet been delivered to the database. So the wall file consists of both. So an assumption that the data was deleted just because it's in the wall file is actually not true. And the peer review paper I mentioned earlier that I had accepted in Forensic Science International actually has a section that explains.
Yes, and like, I mean, I was peer reviewed, okay? And how much peer reviewed shit are we finding out now is bullshit? You know what else was peer reviewed? The FBI's hair analysis unit. That was bullshit, and they had to close it down. A lot of things get peer reviewed, honey.
Explains its exact presence for SQLite databases about how we refer to that as recovered and not deleted. Actually, through that entire document, we don't use the phrase deleted. We refer to things in statement of recovery because we need to determine why it's there. So we can't say that it's deleted just because it came from the wall file. Some tools will automatically indicate to the examiner that they need to dig deeper into that. I did do further analysis by looking at the wall file. That particular item and it's a little bit more complex, actually exists on multiple pages because it moves as the database is being created, but all of them have the same unique identifier. So it's the same entry. It's not more than one search of how's long to die in cold. If there was more than one search that had occurred where it became the top element in that database, we would see that. There are, as I mentioned, other carved from the database, from the wall file elements, such as the search for the YouTube video, It's Raining Men, because at some point that was the last viewed item in a tab when that tab was retired right before, also 2:27 a.m., but a couple of seconds before the How's Long to Die in Cold search. So we can see that that table is put to the rear. The newest tab that's open, which is why it's in the wall file, it's the most recent thing because it's like our waffles and pancakes hasn't been delivered to the table yet. So it can sit in the wall file for that reason. That doesn't indicate it's deleted. The second reason is there is no user interaction in the interface to delete a tab. You can open and close a tab, and open and close tabs are tracked in that database, but you cannot delete a tab. There's no, if you were to pick up your iPhone, I know you don't have them right now, but if you were to pick up your iPhone and look, that wouldn't be a physical option you have in the interface. So it could not be deleted by a user through the interface for that most basic reason.
So a user, could they delete a tab if they wanted to?
There's no actual option to delete a tab. For your web history, you could clear the cache, for example. Most of us are familiar with clearing the cache in your web history. You might do it because you don't want your kids to see what you searched, or maybe your kids don't want you to see what they searched, so they'll delete it. But you can't delete the tab history. It's just what tabs are there. The device is tracking that.
When you looked at the software, whether it was Axiom or Celebrite, when you look just at the report, not the data itself, do either of those reports have any indication noting that that web, that Safari search is characterized as deleted?
Tools, Celebrite denotes it with a red X, which means that it is recovered. Axiom indicates that it is carved. In the same paper that I referenced earlier that I authored, there's a chart in there that shows the distinction between how different tools, some will use red X's, some will use question marks, some will list carved or parse. So every tool chooses to do that differently. That does not mean deleted. It means it needs further analysis.
Should an examiner who looks just at the reports of the software assume that if it is marked as recovered in Celebrite or carved in Axiom, should
an examiner should never assume something's deleted without doing a manual examination.
The manual examination, is that a method that's used, that's generally accepted in the forensic data field?
The NIST Science Foundation paper, as well as the dataset generation guidelines, both speak to conducting testing to verify and validate, and it states clearly that an examiner is to verify and validate findings and to determine meaning.
So given that you've used multiple tools to look at reports regarding this phrase, how long to die in cold, and have seen indications or characterizations of recovered and carved, and in addition to the fact that you actually analyzed the data, did you arrive at an opinion to a reasonable degree of scientific certainty whether or not the user deleted, any user deleted the phrase, how's long to die in cold?
Yes, if it's how's long to die in cold. Sorry, trying to clarify.
Pardon me. Did you come to an opinion to a reasonable degree of scientific certainty whether any user deleted the phrase, "How's long to die in cold"?
Yes.
And what is your opinion?
My opinion is there was no deletion that occurred by the user because it is not something a user can delete.
Finally, I want to ask you about your analysis of the phone records on this phone attributed to Ms. McCabe. Did you go through an analysis of the phone logs and the phone records on the
I
phone?
analyzed the call logs and the phone logs on the device that I was given, that I was told along to Ms. McCabe, yes.
Would a suggestion or a claim that a user deleted irregularly a number of phone calls, would that be accurate or inaccurate in your experience?
It is inaccurate in this instance.
Can you explain to us why and how you came to that conclusion?
Yeah, this is actually really interesting because of what it appears in the forensics tools.
So is she going to say that Whiffen's a fucking idiot that this actually didn't delete? Is she going to undermine this other guy? I'm very curious how she's going to explain this now.
And additional artifacts that I looked at that are not parsed by forensics tools. So the call logs, when you look at it, it appears, I don't remember if it's 8:57 or 8:59 a.m. in my mind at the moment, but approximately either 8:57 or 8:59 is the earliest phone call we see on the 29th of January. We see no call logs before, but we do see FaceTime logs before. So if an examiner, again, was making assumptions without testing or reviewing, the first assumption might be, well, things must have been deleted because there's data that exists before, but not current data. So then you have to go, how do phone logs work? And again, create test data and review. What the situation here is that there are 3 types of call logs on this particular phone.
So she's saying Ian Whiffen didn't do a thorough job of investigating because he says, I can't figure out how it happened or what happened to the data. He doesn't point out, oh, there's other parts of data I can recover. So Ian Whiffen's a fucking piece of shit. Is that what she's getting at? Sounds like it to me.
There's regular calls, incoming and outgoing. There are FaceTime video chats, incoming and outgoing, and FaceTime audio chats, incoming and outgoing. The storage for that is actually 200 records. So you can only store up to 200 of each. Now, if you were a user of, let's say, WhatsApp or Signal or Telegram, those would each count too, and they'd get their own logs. So when we look at the database for the number of calls between 8:59 a.m. or 8:57, again, I apologize, I'm not looking at that precise
That's what I
time,
mean.
on
That's
the
what I
20
mean. She can't do it both ways. If Whiffen can't figure it out, but she can, Whiffen has no idea. So his reliability's out the window. His credibility's out the window. I mean, these guys contradict each other. I hope Alessi goes after that on cross.
9th of January in 2022. There are exactly 200 calls still in that record from then until the imaging of the phone. There are 199 FaceTime video calls and only 27 FaceTime audio calls. So the question is, how do you validate that that's what's happening? So we actually have call logs that we can pick up in other places for recent call logs in the last 7 to 30 days, depending on the exact version of the device and how the biomes are running. We can actually see incoming call logs, the number they go to, and if they're incoming or outgoing in the biomes. So we actually can see the history going back for the entirety of that day on January 29th till midnight. Again, my scope was from midnight until noon. So we can actually see all of the calls. They're just not all on call history state DB. Now, the call history state DB, from a user perspective, that button on your phone doesn't say call history. It actually says recents. And what it's determining as recents is the most recent 200 of each category. Now, how did I determine this further? There is a running log that exists in a phone. It lasts about 3 days. It's called the unified log. The unified log tracks multiple things that are happening on the phone. In manual analysis of the unified log from this phone, I can clearly see each time a 201st call comes in, the 200th call gets deleted. So it's constantly just the last 200 calls. It may not be typical that we see 200 calls in 3 days, but on this device, we do see 200 regular phone calls in the 3 days between 8:59 a.m. on the 29th and when the phone was imaged.
Do you have an opinion to a reasonable degree?
Oh, I 100% believe Jen made 200 phone calls in 3 days. Afix is saying, can you guys ask the audits with phones in the chat to scroll through their iPhones and count and find if they have more than 200 calls? Yeah. Yeah, who are those 200 calls about? I don't know. It's while she was brushing her teeth. 200 butt dials, chat. That's what she had, 200 butt dials.
Scientific certainty whether there was any user deletions from the phone call log that morning.
Yes.
And what is that opinion?
The opinion is that I can see that it's done by the device itself utilizing unified logs, that the system is deleting the 201st call every time a new call is received or outgoing.
Thank you. I have no further questions.
All right, can I see counsel at sidebar regarding scheduling and a few things?
All right. So I think they're gonna take their lunch break here, chat. Yeah, this is the lunch break. So, well, here comes Alessi getting ready to unlimber his
Make sure that
nuts into her mouth. Chat. We're at hour 5 already, and we're only 2 hours in. This is crazy. So yeah, this whole thing doesn't. She did not seem credible here. So let's see what happens here. Let's get on, Lacey.
cases tried fairly and efficiently.
We're not trying the case fairly, Bev. You're fucking it over.
At lawyers about something I try not to, and I don't think I am. But if I seem to cut somebody short, the lawyers are just doing it. When they request sidebar conferences, they're just doing it. I am going to try to keep all sidebar conferences to a minimum, but the lawyers are just doing it. Okay. All right, go ahead, Mr. Alessi. If you're a witness.
I just need a witness. Yes. Certainly.
All right, good afternoon.
Afternoon, Your Honor.
May I, Your Honor?
Yes.
Good afternoon, Ms. Hyde.
Good afternoon.
I notice you have some documents with you. Could you just state what is in front of you so I know that I might be able to help expedite this if I know what you have in front of you?
Absolutely. I have the first digital forensic analysis report I completed for the previous trial.
Do you have a date? You have several of them.
I do. It's the first one. I apologize. This is the one, I believe it's May. I don't remember the
May
date
of
off the top of my head.
2023,
May of
perhaps?
2023, obviously. Then I have the second one. This was the one that was used in the pretrial motion.
December 2024?
December 20. Yes, that's correct. Very nice. Then I have the third one. This is the final one regarding the phone that was identified as Miss McCabe's.
Yes.
And then I have the fourth one, which is the phone of Mr. O'Keefe. And then I do have the opinion from State versus Huera, but if we don't need that, that's fine.
Okay, very well. I appreciate you telling me that. In March, and you recall on your direct examination, Attorney Brennan asked you questions going to your experience and qualifications. Do you recall those questions?
Yes, I do.
You were involved in a case, is actually a murder trial in the state of Maryland in a case called State v. Herrera as recently as March of 2025, correct?
Correction, it's an attempted murder.
Attempted murder. And in that particular case, you had attempted to offer various opinions to the court, correct?
I object.
You have to move along from this case, from what you're talking about. You have to move along from that Maryland case.
So with regard, do you recall another case from the state of Massachusetts, Arrington case, in which you submitted a pro se amicus? Do you recall that case?
I do.
And is it correct that in that case,
She submitted an amicus? That's weird. An expert, like a voluntary expert? Ooh. That makes you like an intermeddler. That sets off some sussy alarms to me, guys. That sets off some sussy alarms. That is weird. That is very weird. Yeah, she opened the door, Bev shut it, which is bullshit. Wow. Let's rewind that just a hair here. Let's go.
in March, and you recall on your direct examination, Attorney Brennan asked you questions going to your experience and qualifications. Do you recall?
All right, chat real quick. You know what? We're far enough in this. I bet we can refresh and see if we get
along from that.
Yeah, so with
Yeah,
regard,
here we go.
Do you recall?
Here we go. We got closed captioning again. Okay, there we go. Which always helps. I know it's like late right now, but it's here.
And I have the fourth one, which is the phone of Mr. O'Keefe. And then I do have the opinion from State versus Huera, but if we don't need that, that's fine.
Okay, very well. I appreciate you telling me that. In March, and you recall on your direct examination, Attorney Brennan asked you questions going to your experience and qualifications. Do you recall those questions?
Yes, I do.
You were involved in a case, is actually a murder trial in the state of Maryland in a case called State v. Herrera as recently as March of 2025, correct?
Correction, it's an attempted murder.
Attempted murder. And in that particular case, you had attempted to offer various opinions to the court, correct?
I object.
You have to move along from this case, from what you're talking about. You have to move along from that Maryland case.
So with regard,
Do you recall another case from the state of Massachusetts, Arrington case, in which you submitted a pro se amicus? Do you recall that case?
I do.
So an amicus chat, Patty's asking what's an amicus brief. You're basically, as a friend of the court, you're filing to support a position. So like in the Supreme Court cases, you hear about amicus briefs all the time. Well, interest groups will file amicus briefs saying, dear Justice, Supreme Court, file these, support our cause. Here's what we're arguing. Getting these at a trial court case is a little weird, but it does happen. And she, as an expert, jumped into a case all fucking by herself. That is really, really, really troubling to me. That's not something you should do. That, like, it's one thing if you're just like a lay witness, you're a Yahoo, but she, as an actual like expert witness, jumping into things, you shouldn't ever be doing that. Be a fucking expert. Do it the right way.
And is it correct that in that case, you submitted arguments on behalf of the prosecution in that case?
I submitted an amicus brief, which is not on behalf of anybody. It's as a friend of the court.
Right, but the friends of the court, you took a position.
Your position was supporting the state. Your position was in line with the state, though.
In that
That's an actually moment there.
quote, friends of the court brief, correct?
Took a position on the evidence.
Right, and the position you took on the evidence was that the frequent location history data.
So they are letting her bring it up. The Bev let them do this. That was a good call by Bev. Oh, let's see how bad this is.
Is reliable and should be used. Is that correct?
The statement is that frequent. I do not have that amicus in front of me. It has been a year and a half since I've read it. But that amicus does discuss frequent location history records. And I want to be clear, it speaks to both bias on both sides and negative and positive of submitting it. It was an unbiased writing, and it was not specifically in support of the prosecution.
So you are testifying in this case on behalf of the prosecution, correct?
In this case, I was hired by the prosecution.
Right.
That's correct.
And the prosecution is paying you for your services in this case. Is that correct?
Yes.
And with regard to this case, you have been paid and have been on this case since May of 2023, correct?
That is correct.
With regard to
how much have they paid you should be the next question. Like, how many dollars because that is 100% allowed. How much money have you been paid? Probably a couple $100,000.
To the various reports that you have submitted in this case, you have mentioned one, which is a report with regard to the iPhone of John O'Keefe. Is that correct?
That is correct.
And you have, in that report, you have made a statement, have you not, that from 12:20:50 a.m. on January 29th of 2022 and after, there is no indication of interaction with the device. Is that correct?
There is no indication of user interaction with the device. There is all received until about 6:04 a.m. when there is, again, Apple Health data that picks up.
I'll ask it again. And you can feel free to turn.
I hope Alessi also makes her explain why does it show it moved 84 feet.
Turn to page 1529 in that report.
Page 15?
Page
Thank
15,
you, Ag.
1529.
The report is.
Would you like the
50
page of the
pages.
report or the page NDA number at the bottom? I can do either
Oh,
way.
I'm sorry. I thought you were saying page 15 in the report.
No. It's
I
NDAO
apologize.
1529 or page 7, whatever way.
Page 7. Okay, Roger.
Okay, so page 7, you see there's a heading interactive phone activity, correct?
Yes.
And at the top it says, using a variety of different artifacts, we can see active interaction with a mobile device up until 12:20.
Yeah, you have to
Slow down. Okay, sorry about that. I'm just trying to move it along, but I will be slower. I'll repeat, using a variety of different artifacts, we can see active interaction with the mobile device up until 12:20:50 a.m. ET. You see that statement?
Yes.
And then if you skip down, I'm going to skip a couple sentences to the paragraph under the chart. This is the key part.
Okay.
It says from that point, and I'm understanding that point to be the 12:20:50 a.m., correct? You need to say yes or no. I'm sorry.
Yes.
There is no indication of interaction with the device. Did I read that correctly?
That is correct.
So I am going to, and you believe that statement is correct?
Until 6 something a.m.
No, I'm sorry. I'm just asking if that statement is correct. Not if you have other information, but is that statement correct?
Can you answer that? Can you answer that, yes or no?
Did I read that correctly?
You read it correctly.
Thank
yes.
you. If we could, Your Honor, have a document that is put up already in evidence and publish Exhibit 39. And it will be, thank you. And if we could go to slide 82, please. And Ms. Hyde, if I could draw your attention to the entry that is, it says 3209 under app lock, but we know that the 00 is a 12. So it's 12:32:09 a.m. on January 29, 2022. And I'm going to read what it says in red. And this is a timeline of Mr. Whiffen. You know Mr. Whiffen?
I do know Mr. Whiffen.
And so he put in red, not us. He said device locked with lock button for the last time. Do you see that?
I do.
And you know that to lock a phone, you actually have to hit the side button with regard to an iPhone to make it lock. You know that?
Yes, sir.
Okay. And that is an interaction with a phone, is it not?
I concur.
So that means that that interaction with the phone occurred at 12:32:09, correct?
I did not review that specific artifact. I cannot attest to Mr. Whiffen's exam, only to my own.
So do you have any reason to believe that what is in evidence in this case that Mr. Whiffen has produced, and that do you have any basis to contest the fact that the device was locked with a lock button for the last time on the phone of John O'Keefe at 12:32:09 as you sit here?
I cannot contest it because I do not recall looking at that specific artifact.
Don't you think it would have been appropriate to be accurate as a digital forensic analyzer?
Wow. You know why she's saying that? And you guys who are scientifically motivated here can tell me. You know why she didn't look at that? Because she didn't want to have to fucking blow his shit up. Which means she looked at it, realized, oh my God, I'm going to have to fucking blow him up if I comment on it. So I'm disregarding it. I'm going to forget to look at it. If she did that, she would ruin him. That's kind of what I'm thinking there. That's kind of what I'm thinking she didn't do that for. I didn't look at it because I'm going to fuck him out of his ass. Like I said, I'm not science man, but I am sneaky. I'm sneaky son of a bitch man. So, yeah. And real quick, we got some Cat Williams for 5 subs. Cat, hope you're doing well, guys. Cat's doing great work over on her channel, covering all the stuff that's going on, including the Antonio Sledge issues going on with him. Remember, he's one of the guys that got done dirty early on in the YSL trial. And then EDW Raptor with 5 more subs, chat. Just greenifying the chat, gentrifying it with some green. That's right, Grays. We're buying up your homes. You're getting out of here. We're buying you out. That's right. This green ain't gonna end like Mo Green. Let me tell you what. So, YSL Cat. Yeah, there we go. I don't think that it's given that the lock time is really good for Karen. I mean, then why didn't she look at it? I don't know why she look at it then, because it sounds like she skipped it to help Whiffen. I mean, other than that, she's a fucking tardo, which, I mean, if she wants to be a tardo, great, I guess, be a tardo, but why would you want to be a tardo? Yes. Novius, Streamlabs, PayPal, Venmo. What is this a DSP thing? Or are you trying to get me as Aaron? I don't know which. We're on the streaks, chat. Meeting the perfect shows. So, anyways, here we go.
On the topic of the last, of an indication of interaction with the device, don't you think it would have been appropriate to look at that 12:32:09 in any of the tools you said you used on Direct?
I did not correlate that artifact in my timeline.
I understand you didn't, and my question is...
You didn't, notice, there's an artifact that doesn't work. I didn't bother analyzing it. You fucking piece of shit. And look how smudgy her glasses are. Fucking girl, get one of these. Go on Amazon. Get yourself some of these, girlfriend. These things right here. These things right here. You can buy like a box of 200 from Amazon. Focus, you fuck. Optics 55. Pre-moistened lens wipes. This shit is good. These things are amazing. You get like a box of 200 of them for like dirt cheap. So, Having glasses that smudgy would fucking trigger me too so hard. So.
You make a statement. Well, let me back up. Do you understand that in this case, as in many cases, that matters of seconds in activity can be determinative of a case? Do you understand that from your experience?
Absolutely.
So it's important, therefore, to get activity right for any data forensic examiner when they're issuing reports about activity, particularly of a decedent. Is that important?
Absolutely.
So isn't it correct that the statement that you make on page 7 of your report, that from that point, 12/20/50, there is no indication of interaction with the device, is incorrect?
I cannot make that without going back and reviewing and validating the artifact you just produced from Mr. Whiffen. I would need to validate that in order to respond to that.
But as you sit here, you have no basis to contest what Mr. Whiffen has stated, that there was a lock button on the side of the phone of Mr. O'Keefe a full 12 minutes after you say there was no interaction with the device. Is that correct?
I don't. I would have to review that portion.
Is there anything that had prevented you from reviewing that in that data before you wrote this report?
Not that I can think of. I would have to go and re-review that.
My question is,
I don't know if that artifact, I have not reviewed that artifact, so I cannot speak to an artifact I have not reviewed, and I did not, that is not my report, that's Mr. Whiffen's report, so I cannot speak to that without going back and reviewing that evidence.
isn't the interaction with the device a lock?
Aren't you meant to be an expert? You're like one of the, I work at George Mason, I'm this, I'm that, and I'm credentialed. This isn't a new artifact. This is something you knew was there and you didn't bother to do the work. Like what the hell, Holmes? What the hell?
Button readily available to you in the data that you have and had in your possession when you wrote this report?
Yes.
Thank you.
There we go. She knew all about it and she didn't fucking do it. She's like, oh no, I fucked up and they found out. Oh, she's mad. Look at her now. She's like, ree. They probably like drumpf. Ree. Yes.
If you could please turn to, in the same report, page 1528, which is your page number 6.
She's now drawn in.
And I just want you, please, to go to the, just put a placeholder in that. And if you can now just go to the conclusion, which is your page 50. Let me know when you're there.
I'm there.
So in the conclusion, you state that starting at 12:01 a.m. on January 29, 2022, the mobile phone was in use with activity of Waze navigating to 34 Fairview Drive, Canton, MA, active interaction with the screen, steps, audio playing, text messages and calls until 12:31 a.m. EST on January 29, 2002. Did I read that correctly?
Very
Yes.
true.
That statement is also incorrect, isn't it?
On what basis?
Do you believe that statement is correct or incorrect?
I believe that the statement is correct regarding those artifacts that are mentioned in that statement, yes.
Okay, if you could please, if you could turn to page 1535 of the same report.
Can you give me my page number, please?
I will.
Okay, thank you.
You're welcome. If you could turn to your page 13.
13, Roger. Yes, I'm there.
And do you see an entry that says 12:31:56, which is the same time in the conclusion, but I'm going to develop it.
I believe I know where you're going.
Hold on. I'm sorry. I need to ask the
Apologize.
questions.
Yes.
I appreciate you looking to help, but if I could, I'd appreciate it.
Absolutely.
Thank you. So it's got health steps and it has steps 36, duration 20.9 or 20.398 seconds. Did I read that correctly?
That is absolutely correct.
So if you look at this data point in your report on page 13, the steps began at 12:31:56, but they ended 20.39 seconds later at 12:32:16. Is that correct?
That is correct.
So therefore, your statement in your conclusion, if you could go back.
Okay, this is where. So here we go.
Says 12:31:56, which is the same time in the conclusion, but I'm going to develop it.
I believe I know where you're going.
Oh, hold on. I'm sorry. I need to ask the
apologize.
questions.
Yes.
I appreciate you looking to help, but if I could, I'd appreciate it.
Absolutely.
Thank you. So it's got health steps and it has steps 36, duration 20.9 or 20.398 seconds. Did I read that correctly?
That is absolutely correct.
So if you,
That puts it past the date that the last thing worked. That blows up. This blows up Whippet's fucking timeline. This blows up her fucking timeline. This blows up Whippet's timeline. Oh, buddy. Viv Ravandre, he was not in the first trial. This is unless he's a very good science-orientated attorney. But wow. So there's 20 seconds of movement after like Whippet says it's done. So these experts are fucking each other. Oh, Whippet pulled out his dick and she shoved hers up his ass. Wow. No, these are two shitty experts battling each other wrongfully on the same side. Why did the Commonwealth so thoroughly contradict their case? Because they're retarded.
look at this data point in your report on page 13, the steps began at 12:31:56, but they ended 20.39 seconds later at 12:32:16. Is that correct?
That is correct.
So therefore, your statement in your conclusion, if you could go back to 50, and this is in your conclusion, your statement there is that the steps, the mobile phone is used with activity, including steps, until 12:31 a.m. EST. That should read until 12:32:16, correct?
It depends on your interpretation of interaction. As a user is walking, they're not actively interacting with their device. It's their movement that is. It's not direct interaction with the screen. But I would agree to your view that could be interpreted as needing an additional 20 seconds.
Isn't the more correct way to state the conclusion that the active interaction when it comes to steps is not calibrating using the screen, but the phone is calculating steps taken? Isn't that correct?
That is correct, but that's not interactivity with the device.
I understand,
Yes.
but the sentence reads includes steps, and the more accurate.
She's actioning her way out of this chat. It's not real interaction. Well, the phone's documenting movement. Yeah, but it's not interaction. Look at her face. She's like, oh, fuck. She's spooked.
Way to have stated that would have been to put 12:32:16 instead of 12:31 a.m., correct?
I'm sorry, you just said 12:30. I did this to the minute, not to the second. Could you rephrase what you were citing?
Well, I'll state it again.
I appreciate that.
You're welcome. So isn't the more correct way to state this important data point in your conclusion, instead of saying active interaction with the screen and steps, etc., until 12:31 a.m. EST, the 12:31 should be 12:32, because the steps that you have on your page 13, by what you concede, is the duration of 20 would have brought it to 12:32:16, correct?
I would state that depends. I believe either is a correct way to state that. Based on interactivity, based on your interpretation, your definition is more correct.
Okay, thank you. And it's not my interpretation.
My definition and interpretation are more correct. That means yours is wrong. I mean, this idea, we're both correct. No, honey, we're not.
I'm reading from your report, correct?
Your interpretation that 12:32 is a more correct representation of interaction is based on your theory that interaction concludes when the steps end. And I'm saying both would be acceptable.
Okay, so let's follow up on this.
Sure.
You dumb whore. That means the phone was moving after people think John O'Keefe was dead. So you have to now explain why that phone was moving, and you can't. And Ian Whiffen can't explain it. Which means what happened to the phone? 20 seconds. That sounds like easy enough to walk 85 feet. I think that's what he's getting at. Is the 20 seconds and the 85 feet? Because that's where I'm like, well, what the fuck? Yeah. So here we go.
isn't it correct that it isn't my theory when the steps ended?
Oh, it's not
if I
agree.
could just finish,
Please,
because if
absolutely,
we
sorry.
talk over each other, the stenographer's not going to get both of us. Thank you.
Agreed.
So it's not my theory. It's just the simple math from an entry you've made on page 13.
Yes, that's
that
the other
steps
option.
began at 12:31:56. They ended 20.398 seconds after that, which just doing the simple math is 12:32:16. Did I do the math correctly?
That is correct.
Okay,
I'm not
thank you.
debating that.
Thank you very much. So now what I'd like to do is to go to page 1528 of your report.
Do you have my page number for that? I'm sorry.
Yes, and I appreciate that you go page number, so I just center in on the lower one, then I'll go immediately to the one. So it's your page 6, Ms. Hyde.
Thank you.
You're welcome. Just let me know when.
Oh no, chat. Whiskey77 for $5 saying, why won't YouTube let me use the retard word? Retard. You're talking about the proper landing of an airplane. You retard. 50, 30, 20, 10. Yeah, it's talking about the airplane stuff there. Airplane joke. I'm not referring to the host this time. Time to 810 some grays. And Whiskey77 with 20 subs. Let's go, chat. Just find those subs and just running and hiding, Grays. That's all you can do. And then Whiskey with another 20 subs. Wow. Thank you, Whiskey. Big support tonight, chat. Big support. I get to say that tonight before the casino's on. Big support, chat. Thank you, Whiskey. You the man. Guys, remember, Whiskey77 and 3 Beers doing Assholes React every Sunday night at 9:30 Eastern. Maybe I'll see what they're up to this Sunday if I'm around. And I can be an asshole and react, or I could pull a PPP and then they can react to my asshole. I don't know. Either way works. But Whiskey, thank you for supporting your generosity. Yes, her you're welcome or happy, like that's her saying fuck you. Yes. Oh, you guys will be back this Sunday. Perfect. Johan Noxo says for $2, we should call them sub sandwiches. Yes. 77 is very generous. Whiskey's a great guy. So Palmyra Media, yes. You have to set up your account like in your you have to go back through it and set it up so you can get memberships. It's like if you Google it, if you say it, how do I set up my account to receive memberships? It'll help you figure that out. Hyde realizes Alessi has to be correct. Yeah, that's your problem. Yes, PPP. No, you guys get what I'm saying. Johan, what am I? My excitement in the voice. Stop it, you guys. All right. Well, let's get back to this. Thank you, Whiskey. Oh, and we got Suki. I didn't see this one. I'm so sorry. Suki with the good Golden Corral voucher. I mean, is there ever a bad Golden Corral voucher? That's the thing. Like, because if it's a voucher, I mean, like, I'll go to Golden Corral. But Suki with that good Golden Corral voucher. Gifting 1 sub. Just picking out that individual and just dropping them. Good. Thank you, Suki, for the support and your generosity. And Island saying, so Karen Reed drove across town in 3 minutes. Is that the story? Yeah, I mean, that turns into an issue there. Remember, guys, the timeline's important. Destroying the experts is better. But ultimately, remember, the ME still can't explain how John O'Keefe died. What causes death? They can't. Your voucher's still good. Good. Golden Corral is good. I said what I said. Yeah, it is. It's all right. I mean, like, you're not going to like a fucking like, $100 plate steakhouse, but it's good. It's good. Yes. Let's get some greens. And I know you guys are like, hit play, fat man. Well, one more thing. The timeline gang from yesterday eating good now. Now, don't eat too much. I'm not going to share with you. Johan Naxos with 10 subs. Johan, thank you for the support. Helping make our chat, make America green again, chat. You're making America green again and praying the gray away. Thank you. And yes, you can have decent prime rib at a Golden Corral. So, yeah, the Golden Corrals are still around. Yeah. Hell yeah. Your ass will explode if you eat a Golden Corral. No, it won't. If you eat certain things, yes, but you can eat regular food. All right, let's get back to this.
You're there?
I'm there.
If you could please go to Apple Health Data Steps.
Mm-hmm.
And we've been talking about steps because they're important enough that you put them in a report, correct?
That is correct.
So let's go to an important data point, therefore, in your report, in the chart, which is the second entry, which is, as you've stated, 12/21/10 a.m. Do you see that?
I do.
And you note under the data that John O'Keefe's phone registered 80 steps at 12/21/10. Did I read that correctly?
You did read that correctly.
And those 80 steps constituted 191.253 seconds, as you state, correct?
That is what is stored in that database, correct?
And is my math correct? So that the jury understands this perhaps a little better,
Sure.
that 191.253 seconds equals 3.2 minutes,
Approximately, yes.
approximately.
I'm doing the math in my head, so that's why I said approximately.
That's a lot of unaccounted for time. Ooh, buddy. Ooh. Ooh.
Understood. So am I reading this entry correct, that you're stating what the data shows, that 80 steps were taken by the phone of whomever had the phone of Mr. O'Keefe? There were 80 steps taken at 12/21/10 a.m. on January 29, 2022 for a length of time of 3.2 minutes.
That is what the phone registered.
That's what the phone registered. Very well. Now what I'd like to do is to turn to the phone of Jennifer McCabe.
Okay.
And that is for your reports. You don't date your reports, so I can't give you a date, but it says
It's report 3, I believe, is what you're looking at.
exactly. It's 3. And there is, bear with me, I'm accommodating your page reference, and I'll have it soon for you. It is your page 7. And let me know when you are there.
I am there.
Are you aware of an issue regarding the time of an interactive phone activity on Jennifer McCabe's phone at 5:07 a.m.? Are you aware of that issue, and particularly a communication to a person named Coco? Are you aware of that?
I would need to check in my report. May I turn to the page
Absolutely.
for that time?
And
I
if
do
it
see
is-
an outgoing call to someone labeled Coco at 5:07:21 a.m.
And you can tell that because in your report on page 11, you list a 5:07:21 a.m. call to a Coco as outgoing, correct?
Correct.
Have you discussed that call with any member of the Commonwealth?
No.
And again, this call is at 5:07 a.m. on January 29th of 2022, correct?
That is correct.
There is no duration listed for that call. And if you just follow my questions, if you can, yes or no, is that correct? There's no duration yet listed.
Correct.
So what I
Interesting.
want to do is to also note that that omission is not the only omission of durations from this report, or I'll state it differently. Let me withdraw that. There is no population of the duration column for any call from 12:14:30 a.m. on January 29, 2022, all the way through this 5:07:21 call, and you don't start listing durations until 8:59:34 a.m. Is that correct?
Yes, and explainable. The artifact.
I understand
yes.
Mr.
Okay.
Brennan can
Sure.
handle those on his redirect.
Absolutely.
So there's not a population of duration of calls after numerous early calls and phone, as you call it, interactive phone activity. Nothing populated in this report until 8:59:34. That's correct?
Yes.
All right. Now what I'd like to do is to turn to the 22740 artifact, that was the subject of much discussion on direct. And I am going to refer to that as an artifact. Is that a parlance that is familiar to you?
Yes,
And if I refer to that as a timestamp also, is that a parlance that's familiar to you?
absolutely.
So I can refer to 22740 as a timestamp, and you would find that parlance acceptable.
Yes,
Thank you. So I'm going to do that. Just to keep it simple, I refer to it as a timestamp. Now, you've been on this case working for the Commonwealth since May of 2023, correct?
May 4th, 2023. That is correct.
So you've been on this case for 2 years, correct?
Not actively the entire time.
But you started on this case in May 2023. You issued a report in May
Correct.
of 2023, correct?
Correct.
You issued a report in December of 2024, correct?
Correct. After being rehired in November.
Right. And you issued more reports in 2025 correct?
That is correct.
So all of that activity has been on this case, correct?
All on this case. That
And
is
that's
correct.
been all on behalf of the prosecution, correct?
That is correct.
None of that work has been done on behalf of the defense, correct?
That is correct.
So let us now go to the timestamp of 22740. Your opinions on what is the meaning of that timestamp have varied from May of 2023 until today. Is that correct?
No, that is incorrect.
Let's cover that issue.
Sure.
Let's turn to your May 2023 report. Isn't it correct that the report and your findings were pursuant to a request from Detective Lieutenant Brian Tully?
Correct.
And how many interactions have you had with Lieutenant Detective Brian Tully on this case approximately?
I really don't know. I'd have to go look back at email and call logs.
Is it more than 5?
Yes.
Is it more than 10?
Yes.
Is it more than 20?
I don't know.
So somewhere between 10 and 20, would that be fair?
Again, I'd have to review my call logs. I'm not
But it
going to
was
test.
more than 10.
More than 10, I'm sure.
So the issue was your use of various forensic tools that revealed a timestamp, 2:27:40 a.m. timestamp on January 29, 2022. Is that correct? Is that a fair characterization of an issue you looked at?
Correct.
So if you could go to page 5 of that report. And I would ask that you go to the last paragraph that starts with "in the instance of the Google search," and let me know when you're there.
I'm there.
So it reads, "In the instance of the Google search, house long to die in cold, that was recovered from the write-ahead log associated with the X browser state DB SQLite database with the timestamp of 2:27:40 a.m. was marked by Celebrite as having this timestamp and being deleted." Did I read that correctly?
Fair. Yes.
So you use the words that Google search, house long to die in cold, was associated with the timestamp of 2:27:40 a.m. Isn't that what your words are in this report?
In that database, they are associated. That is correct.
Right. And in terms of page 3, if you could go back of your report, under relevant findings.
Mhm.
It starts with, there were 2 searches of interest that took place on the iOS device, and we're talking about Jennifer McCabe's device. right?
Well,
The device that was identified to me as Jennifer McCabe's. Yes.
That's identified to you as Jennifer McCabe. And it's what you talked about on direct examination as her
Absolutely,
device, right?
yes.
It's not a mystery as to whose it is. It's
Well,
not like you don't know, right?
In direct, I also use the phrase identified to me as Jennifer McCabe's.
Right. But your conclusion is the device you've been working on and analyzing for 2 years is the device of Jennifer McCabe.
That is how it was identified to me.
And did you have a different conclusion as to whose
I
device
have-
it is?
I always am very, very careful that I did not assess the ownership. Because
Yeah.
that was information that was given to me, not information that I personally assessed.
So are you uncertain as to whether the device you've been working on for 2 years is the phone
The
of Jennifer McCabe?
device that I've been working on for 2 years is the device that was identified to me by the Massachusetts State Police, Detective Tully, as belonging to Jennifer McCabe when I began working and received that device, as stated in the evidence analyzed section on this same page.
So let's go, and we're talking about, again, to get back to the center of gravity, we're talking about a timestamp of 2:27:40 a.m., correct?
That is correct.
And when you issued your first report in May of 2023, the timestamp you were looking at was 2:27:40 a.m., January 29, correct?
I was looking at multiple timestamps associated with the same 2 searches.
Right. So what I'd like to do, you said multiple timestamps. What times are in the multiple category?
What I was tasked to do was to look at the times, the search, the Google search history, I'm sorry, not Google search history, the Safari history, which includes Google searches, associated with those two search terms within that 12-hour period. That was the particular task, not the task of looking at the 227, just for clarity.
Right, and I appreciate that, but my question wasn't that. My question was, I thought I heard you on direct examination, which is why I repeated the question, what I thought I heard on direct, but I'll ask you the question.
Sure.
You looked at and talked about on direct two potential times for a Safari search, which includes Google, one of which was 2:27:40 and the other one was 6:23 a.m. Is that correct?
I analyzed the meaning of those two timestamps.
Right, so we're just talking about two times, 2:27:40 and then 6:23. Is that correct?
So you are only talking then about the one that we're also talking about 6:24 a.m.
Okay, so we
Eastern
got,
time for clarity, because some of these records are in UTC, some are in local.
fair enough. So you've got 2:27:40, you've got 6:23, and you got 6:24 that you were looking at, correct?
There are other timestamps that exist in the realm of what I was looking at, but those ones, correct, are the ones that are relevant in this report.
Exactly, and that's what we're talking about.
Okay,
We're just talking about this report.
Yes.
And so if you look under relevant findings, at the very bottom paragraph, you say, second sentence, a Google search for how long to die cold at approximately 11:23 a.m. and then how long TIDIE in cold took place at 11:24.
That is in UTC. I apologize for not having the timestamp format there, but that is the UTC time. The UTC time equivalent in Eastern local time would be 6:23 and 6:24.
So to be clear, in your report, you wrote 11:23 a.m. and 11:24, and you didn't put UTC next
Correct.
to it, did
They
you?
should. You are correct. That should say UTC. That is a typo.
And there's a significant difference between 11:23
It's a typo?
and 2:27:40,
That's
correct?
a pretty big fucking typo. It's a pretty big fucking typo. Supposed to be an expert. Why ain't your shit right?
11:23 is UTC, so its equivalent in Eastern time would be 6:23. The artifact of 227 is already in local time, so that is in Eastern time. So what we would be comparing is 227 and 6:23 and 6:24 to be appropriate.
Yeah, how do you
taking
know
into
it's a
account the
typo?
data storage and which ones are in UTC and which ones are in local time.
I understand your explanation now,
Perfect.
but in this report, there is no UTC time down. You have two additional times in addition to the two times, two different numbers added to the two, correct?
The UTC was a typo. It should say UTC next to those, and the chart shows all of those artifacts in EST and is clearly labeled that they're all in EST.
So you would agree that it's better stated to state it a different way than you have in your report?
I would say that both are equivalent. I should have had UTC there. But yes, it's easier for the audience to speak in EST. I would say forensics examiners typically communicate in UTC, but we translate for our reports. And I should have either communicated that in EST or included UTC. I will definitely contend that.
So in terms of your May 2023 report, your first report in this matter,
Yes.
you on page 5,
Mhm.
in the sentence underneath the block paragraph state, in the instance of the Google search, how long to die in cold that was recovered from the write-ahead log associated with
That's correct.
the X browser stage with a timestamp of 2027:40 a.m. was marked by Celebrite as having this timestamp and being deleted. Did I read that correctly?
You read that correctly.
Now let's move ahead to page 7 of your report.
Mhm.
Up at the top above conclusion. Importantly, at this time, you state, testing shows great inconsistency with timestamps parsed from this file. It is, however, definitive that the page existed in a tab.
Correct.
While a definitive reason as to why the timestamp is listing the time of 2:27:40 is unknown, the time is inconsistent with the timestamps associated with the same search. Did I read that correctly?
You did read it correctly.
So as of May 2023, you said the definitive reason as to why the timestamp is listed as 2:27:40 is unknown, correct? I'm just asking, is that what you wrote? Unknown.
I believe that the wording here is, sorry, I know I do use the word unknown. It says, while a definitive reason as to why the timestamp listing is a time of 02/27:40 is unknown. Sorry.
So you use the word unknown, your word in your report.
Yes.
Okay, so now what I'd like to do is to go on to the first proceeding in this matter. Do you remember giving testimony in a proceeding about a year ago under oath?
Yes, I do.
I am now going to go to that testimony, and if at any point you would like to have a copy of that, if it's the honor, if your honor would like, I will do it, but I'm going to start and then we'll see how it goes. So bear with me a moment. Do you recall in that testimony stating that you processed the image in several forensic tools? I use Celebrite Physical Analyzer, and then you list many other tools. You remember giving that testimony?
We have a
Yeah.
I'm sorry, Mr. Brennan, I thought I'd given it 1-12. My apologies if I didn't. It's June 14, 2024, page 1-12. You're welcome. So do you recall giving testimony about the various tools you used for this timestamp?
I do.
And do you recall stating that those tools were commonly used digital forensic tools that are very standard? Do you recall that?
I'd have to see the wording that I used at that exact time.
Would it be helpful to refresh your recollection if I showed you that?
It would be great. I would greatly appreciate that because I do not recall the precise wording, but I know that I
Fair
spoke to the
enough. I'll
tools
get
I
that for
used.
you. May I approach, Your Honor?
Yes, Mr. Lessie, you offered a transcript. Do you have the whole
I have a
transcript?
whole transcript of that. Helps.
It might speed things along.
Agreed.
Okay.
We have one else. I'm going to give you a transcript.
Thank you. I appreciate it.
So, may I approach, Your Honor?
Yes.
Thank you. Ready?
Thank you so
Okay,
much.
here we go.
And you said we're on 112?
Yes, please.
Yeah, she's a fraud. She sounds
113.
like
I
it.
see it. I see it's highlighted on the copy. So I
Right,
figured
so
that's
what I
the one.
wanted to do, the reason I said 112 is that's where I
Oh,
started with my
sorry.
previous question. So I'm not going to repeat the question, but just to orient you, so you have a fair context for the questioning.
Fair.
So I started at the bottom, 112, now I'm moving to 113, and I'm starting with line 7. Do you see that?
I do.
And it says, yes, they are commonly used digital forensic tools that are very standard for other forensic examiners to use on mobile exploitation. Did I read that correctly?
That is correct.
And then if you go down to line 22, you testified in that proceeding. So it's important to use multiple tools so you can see the results from different different data sets, and be able to compare those results and enhance those with manual analysis. Did I read that
Okay.
correctly?
You did. That's
And
correct.
then going up to page 114, line 5,
Slow down a little
Oh.
bit, Mr. Lessie.
I will, Your Honor. Thank you.
Setting her up.
Yeah, that's very, very typical for me to process with multiple tools to ensure that I'm getting the most complete interpretation from forensic tools. Of course, you go beyond that with your analysis, but it's absolutely pertinent to that. Did I read that correctly?
That is correct.
And then lastly, for this section at page 114, 17, the Sanderson tool is meant to look at specific type of data structures called the SQLite database. SQLite databases are very nuanced, and this particular tool allows you to take that database and explore it at a deeper level than the other forensic tools allow. Did I read that correctly?
Yes, you did.
Thank you. Now, if we can go to page 124 of the very same testimony. And feel free to go back a page just so you can see to page 123 that the topic is the 2/27/40 timestamp associated with house long to die in cold. Do you
Can I
see-
have a moment just to review and get context?
Absolutely.
Thank you so much.
Page 123:13, but if you need to go back further, feel free.
Okay, I'm good. Thank you.
You're welcome. So what I want to do is start with page 1-23, and this is your testimony. On line 16,
hmm
I have them in the timestamp order that is associated with the artifact. You use that word associated again, correct? Did I read that
Correct.
correctly?
Yes.
And that's associated with the Google search, how long to die in cold, and a 2:27:40 a.m. timestamp, correct?
That is correct.
Now, if you turn the page of the testimony, you state back then that on page 124, line 1, the browser state DB is an artifact that speaks to when tabs are moved. So when you're using your browser and you open different tabs, you may have a search that this time pertains to the time that the tab moved. It could be lots of things. Did I read
Correct.
that correctly?
You did.
Not one thing, you said it could be lots of things, correct?
That is correct.
And then you go on in line 10, and you talk more, and then you go down to the bottom. You go down to line 2:20. And you testified, we cannot tell by this particular artifact what time that search occurred. Did
Absolutely.
I read that correctly?
It's specifically pertaining to that particular artifact that in browser state DB that does not tell us what time a search occurred. That is correct.
Right. So you stated, and it was your statement then.
Wait, I thought you said you could tell us times when searches occurred. I thought you said, like, the suspended tab shit. Wait. Once again, science people, please correct me. What the fuck am I missing? What am I missing here? What am I missing? What am I missing? Ag, you're smart. What am I missing? Like PPP. She's a fraud. Oh. Oh my God, this is awful.
We cannot tell by this particular artifact what time that search occurred, correct?
That particular artifact.
Okay, so now let's keep going.
Man, she don't know a lot about she don't know fuck about a lot of every artifact. I don't know about that one. I don't know about that one. I don't know about that one. Sounds like there's a lot of artifacts. I mean, it sounds like you don't know a lot. Sounds like you don't know a lot, honey.
Mm-hmm.
If you go to page 129 of this transcript.
I'm there.
At the top.
Sure.
Line 1.
Yes, I 100% am fucking confused. Like, how does she square that circle? How does she square that circle? Like, it doesn't work. I don't get how she does that or square that circle. I don't know how she squares that circle. I don't know how.
2:27 isn't necessarily one time when the tab was closed. That's in my report. I say it's undetermined. Remember, we were just reading your undetermined
Absolutely.
in your May 23 report?
Correct.
Because there's a lot of things that can cause that timestamp to be there, including tab being moved, tab being minimized. The next sentence. I don't know exactly what caused the tab.
Okay, hold on here. She claims to use a bunch of known software. If you go to her site, she uses mostly her own software. She could create it. Oh, so she's just like whiffing. I made my own shit up. That she's the expert that says. So here's her argument. I made a computer program that says I'm the greatest ever. That's it. Awesome. So just like Ian Whiffen, I made my own shit. I'm awesome. Great.
To get that particular entry, but it's not, that timestamp is not indicative of the time of the search or any URL that's visited. But the first part of it is, I don't know exactly what caused the tab to get that particular entry. Did I read that correctly?
You read 100% correctly.
Thank you. Now, if we could turn to page 130 of your testimony.
I need to, yeah.
I'll see you both.
Unless he's trying to confuse the jury. And my friend John said court fell asleep with Alessi. Well, if they fell asleep with Alessi, they fell asleep when Hank was talking too. And if the jury did fall asleep, the defense team would have said something. So they weren't falling asleep. I get you're trying to, like, whatever you're doing, Kimmy, but that it don't work that way. The jury doesn't get to fall asleep. You're like, I was in trial today. You're always looking at the jury, so they ain't sleeping. Just telling you. This is a bit of a legal practitioner, like a little inside girl talk here. We don't do that. I know Kimmy's a troll. Dark Matter says these tools aren't certified by the manufacturer. Yeah, because Apple's not going to let them fuck around on the source codes. And Apple isn't going to verify you've interpreted our source code correctly. So these will never be certified. Oh, are you talking about the John DePetro guy, that fucking whoppy guy out of Rhode Island who does like hack radio? Nah, he don't count. Yes, that's it. That's exactly what it says. He types up a thing and it says Ian Whiffen is the smartest guy in the world. So let's skip ahead here.
And we can go back to,
Oh, let's see what the ass whooping does. Now, Alessi should have been allowed to ask that question. Yeah, I know Apple never lets anybody see their source codes.
thank you for
They
your
never
patience,
will.
Ms. Hyde.
Absolutely, sir.
What I'd like to do is to go back to your testimony in the first proceeding, and we can go back to page 1-30.
I am there.
Thank you. So I am going to go back just because there's been some time and give some context. So we're talking about the 2:27:40 a.m. timestamp, correct, at this page location?
We've been talking about that for several pages. Yes, that's correct.
You're absolutely correct. We've been talking about it for several pages, and bear with me. I think this
No
may be either the second to last or the last. So there you testified with regard, this was when you're referring to an artifact. You've agreed that timestamp is a fair synonym. You say on line 5, that means it wasn't in the regular database. It was in the write-ahead log. And to Celebrite's credit, that tool actually parsed the write-ahead log and displayed it where the other tools did not. So did I read that correctly, number one?
You read it correctly.
So am I correct that here, what you're stating is Celebrite was actually showing the 2:27:40 a.m. timestamp at that time during your testimony in the first
On
proceeding?
that date, that is correct.
Okay,
Yes.
so I just wanted to establish that, and you were giving Celebrite credit for actually showing that timestamp at that time of 2:27:40 at the time of your testimony back in June of 2024, correct?
That is correct.
Okay, so now let's go to page 1-36.
136, you said?
136, yes.
Thank you.
And on line 12, you note that so Celebrite and Magnet Axiom, and then you elaborate, both Celebrite Physical Analyzer, which is a specific tool, right, of
Correct.
Celebrite, and Magnet Axiom, another specific tool, correct?
Correct.
Both have file system viewers that then have SQLite database viewers. And you, skipping down to line 17, you talk about they don't allow for deep analysis of the write-ahead logs, which is why in my analysis I used the specialized Sanderson forensic browser for SQLite, correct?
That is correct.
So is it fair to say that what you did up to this point in June of 2024, with regard to the 2:27:40 a.m. timestamp on January 29, 2022, you applied a variety of tools to analyze the issue of when did the Google search occur that you used the words associated with a Safari Google search, house long to die in the cold?
There's a little bit of wording I would correct there if that's okay.
Right, but so let me see if I can ask the question
That'd be
in a
great.
different, more simple way.
Thank you.
You're welcome. So you used a variety of tools to analyze that house long to die in the cold search, correct?
Plus manual analysis and testing, yes.
Plus manual analysis and testing. All right, now let's leave the testimony.
Okay.
And let's go to your next report. And your next report is December 2024. Do I have
I have
the
it correct.
chronology correct, Ms.
That
Hyde?
is correct.
So in December of 2024,
Mhm.
just approximately 6 months ago, you issued another report, correct?
That is correct.
And you got the request for that report also from the Norfolk District Attorneys, correct?
That is correct.
And you state in regard, well, that report regarded the analysis of the same timestamp, correct?
Correct.
To 2:27:40 timestamp.
Mhm.
And in that report, under relevant findings, you state, and this is December of 2024, so it's from your May 2023 report, it's approximately a year and a half. Is that approximately from your May 23rd report? Approximately a year and a half?
Yes.
So a year and a half after what we just reviewed in your May 23rd report, and then just months after the testimony of June, right? So about 6 months after your
6 months later.
June testimony that we just went through, you went and looked at this issue again, correct?
That is correct.
And isn't it correct that when you were asked to look at the same timestamp in December of 2024, that Celebrite removed the timestamp from their tools?
Celebrite did remove that timestamp from the tool. That is correct.
Okay. And that timestamp was the subject of extensive reports and testimony that you participated in the first proceeding, correct?
That is correct.
And even though that timestamp, 2:27:40 a.m., that showed up in Celebrite tools, Magnet Forensic Axiom showed up, that was removed by Celebrite, correct?
Celebrite no longer reports it. The evidence is still in the data. I want to be clear, just that it doesn't change the data. They just removed it from their
what?
automated parsing and reporting.
Right, so they
Correct.
removed it from their automated parsing and reporting.
Yes,
correct?
they did.
Why did they remove it? Because they thought it was unreliable, or they didn't think it was good? There are better means of searching things. Why would they remove it? I don't know.
That is correct.
However, your former company, Magnet Forensic Axiom, still shows it.
Magnet Axiom Forensics currently shows it as a carved artifact and still shows that and gives a description in their artifact reference guide as to what they believe causes that artifact.
I'm going to ask the question.
Yes, it does.
Magnet Axiom Forensics, where you used to be the director of forensics.
That is correct.
Still shows that timestamp.
Yes, yes,
Exactly.
But
Why did they
Celebrate-
remove it?
Doesn't. In the
that is
automated
correct.
tools.
We don't
That
know.
is correct in their automated parsing.
And you would agree that Magnet Forensic is a very reputable company, correct?
Correct.
Let's go back to your December 2024 report. Do you recall just moments ago when we went through your testimony in June of 2024 in the first proceeding, where you stated various times how it was, I'll use the term best practices, to use multiple tools to analyze the timestamp?
Correct.
And you used many tools back then to analyze that timestamp. And you testified to those many tools on your direct examination, correct?
Correct. Yes.
However, in December of 2024, when you returned to analyze the 22740 timestamp, how many tools did you use to analyze that timestamp? Can you give me just a number? How many tools?
At least 4.
Well, in your report, let's go to your report, what your report says.
Mhm.
So in your report, you state that under relevant findings, do you not, that review of data from Celebrite shows that the artifact of a Google search from a Safari suspended state tab with the search term house long to die in cold, and I'm going to skip over, in addition to my own previous report, no longer shows a last visited timestamp.
I think that is not clear. The skipping there makes it sound like my report no longer shows that, and that's not what's being
That's a
stated.
fair statement. That's a fair statement. Let me rephrase it this
Thank you.
way. You're welcome. In this report,
Mhm.
you speak about Celebrite release reports, correct?
Are you referring to the Celebrate release notes
The
that come
release
out?
notes at the bottom,
Perfect.
right? You referred to that?
That's correct.
And that release note states that Celebrite has removed the timestamp value from records, and I'm assuming that's a reference to Celebrite's.
Celebrite no longer parses that result. That is the statement in this report. Correct.
Right. And so I'm going to go to page 4 of your report.
For sure. I'm there.
And I'm going to go down all the way down to the conclusion. In that report, is there reference to any company other than Celebrite in this entire report? Is
In
there?
this report, no.
Okay, thank you. Now let's go to your prior testimony in the first proceeding, where you said that it was important to use multiple tools.
Absolutely.
Do you still stand by your position that you've given today and that you gave in June, that it's important to use multiple tools?
Absolutely.
Now let's go back to the issue of the extraction of Jen McCabe's phone. And what I want to do is to cover a concept and see if I've got this correctly. Are you familiar with the phrase Apple source codes?
I'm sorry. Can you please repeat?
Absolutely, no worries, sir. Are you familiar with the phrase Apple source codes?
Apple's source code? Absolutely. Yes.
And isn't it a fact that Apple keeps its source codes proprietary, meaning very few people have access to it?
That's correct. It is closed source is the term we would use.
Closed source.
That would be the term of art. Correct.
And they keep it so close that they call it closed source.
And it's not just Apple. Lots of tools are closed source. That just means that the code isn't available like it would be for the tool I mentioned earlier, iLeap. That's an open source tool. Anyone can look at the code. For Apple, we cannot go look at the code that makes your phone run. That's correct.
And isn't it the case, and I refer to that as the MB postulate. It's a shorthanded, but I don't need to have you refer to it that way.
I'm sorry. Could you repeat that phrase? I was unfamiliar with it.
I'm going to skip it.
Okay,
I'll
thank
just
you.
go on. Basically, the concept that Apple has source codes that are closed sources. So I just refer to them as Apple's closed sources. wouldn't the best information about when a search occurred, what it's associated with, wouldn't the best information be in the Apple source code to answer that question?
It is acceptable in digital forensic science and in accordance with the NIST Science Foundation papers to conduct testing to determine how the functionality of something works. You do not need access to the source code to be able to speak to an artifact.
My question isn't that. My question is, isn't the best place to go is to the Apple source codes themselves? Or are you saying these physical analyzer tools are just as good and the information they pull is just as good as an Apple source code?
Those are those are incongruent statements. Apple source code is not a healthy way to do an examination because it would be so onerous, and we do not know the level of documentation. We don't know the language. That is not necessarily the most effective way to determine what data is. Forensics tools parse results of how data is. They don't interpret them. The examiner interprets them and provides meaning. And I would like to state that those three things.
But that's just an admission you don't know what you're doing. Because I don't know the source code, I'm interpreting something I don't know the basis of. It's like making a physics determination, but you don't know the underlying laws of physics and the underlying science of it. If you don't have the source code, how do you know what you're interpreting? How do you know you're right? You can't check your math. So again, am I wrong? Am I missing it here?
Should not be conflated. They are very individual concepts.
I think you misunderstood my question.
I probably did it because that's what I was seeing.
My question is this. Isn't the best source for information about data in an iPhone contained within Apple source codes?
Not necessarily. Because that doesn't perform operation.
Are you really serious? You're going to say the source code is not the best way to figure everything out? Maybe all this shit you and Whiffin can't explain is explained in the source code.
Performance is a better source in a practical sense to being able to determine what something is, as opposed to zillions, and no, I don't know the number because it's closed source, lines of code that may or may not have different levels of documentation. Apple themselves wouldn't be able to, any individual there who has access wouldn't know every feature of how every element works. Testing through the methodologies described in NIST is the accepted methodology in our science, not reviewing the source code.
I'm going to try it a different way. I understand what you're saying is, if I got it correct, you correct me. Are you saying that these physical tools make it easier to interpret and view the data?
I did not speak about the tools at all in the statement I just made.
Okay.
I spoke about manual testing and.
No, it actually sounds like I don't have the blueprints, but I know they built the house. And I can tell you they built the house correctly. But you don't have the blueprints to check. So how do you know they built the house to spec? She doesn't have the building specifications. So she can't tell me that the house is a spec. She's like a building inspector. Well, how do you know this is correct? You don't have a copy of the building code. Well, because I'm interpreting them like that. It's like she's missing the underlying foundation.
Checking the functionality and what results. Parse tools, again, these are three separate concepts. The concept of code and actually reviewing code to make a determination is different from parse tool results is different.
So Electron Ash, I get, okay, so you're saying she doesn't need the full source code to extract important info like timestamps. But wouldn't it help to show that, yes, my work is truly impeccable? Because right now, how do you know that's still correct? Number one, but number two, how do you explain these random deletions and shit? They're claiming they're random. We don't know how to happen. This would be a great way to figure out if you're telling us the truth or you're being assholes. The source code won't tell you that everything is built on the source code, right? Everything operates off the source code. Everything is built onto the source code. So you kind of need the source code to ultimately verify you're correct. Unless I'm wrong, that's fine. I'll be happy to be wrong. Okay, some people are saying she's bullshit, right? Okay. No, it's a bad analogy, all right. Okay, well, if it's a bad analogy, that's fine. I'm a tard, that's why I'm asking. Okay, Johan's saying there are data standards of databases that are logically structured so where you can parse the code and expect a result and can be verified by sending a known input and output and getting an expected output. Okay. So are you agreeing with me or not agreeing with me? Neo Dark Matter says they don't need the source code. They just need Apple to say the software is saying the info is correct. But the problem is, if Apple says that's correct, that means people can then start reverse engineering the source code. So Apple will never say that because that gives away information. Yeah, you need to show what system is actually doing it when it writes the timestamps. Okay. Okay, yes, but to say that Apple wouldn't be able to pull and extract this is so retarded. I was about to say Apple could probably figure out all the fucking shit with this even better. Even the court's unlikely to get a lot. The San Bernardino shooters, those guys who showed up and shot up the meeting of employees with GoPros on their heads, the husband and wife team, the FBI couldn't get Apple to unlock the phones for them. Like, there's no... Bev Cannoni and fucking bumfuck Massachusetts is not getting Apple to turn over source code. Apple would fuck her to death if they tried. So there's nothing there. So you don't need the code to understand what the code does. Yes, but you know what? If you want to explain to me that you can be trustworthy and credible, you kind of do. Parsing the source code is better. That's what he's getting at. Yes. But the argument that's being made was the source code make phone tell secrets. Yeah, well, it would explain that. It would explain why we can't find these deletions. Remember, Whitman's like, oh, there's random things that happen. I'm pretty sure the source code would say, no, that's not possible. Yeah, you're trusting the notes and books at school. Old books. Yes, this started with a motion about her getting rejected by another case. Yes. Unhung Hero for $20. Thank you, Unhung. $20. Mobile app engineer. The source code is helpful, but you can document the patterns with outside tools and with enough data infer what is happening. But it's all opinion without the source code or Apple confirmation. Yes. Well, thank you, Unhung. I appreciate that. Thank you for the help. Do you work for Grindr? I figure with my luck, that's probably the app you work on. Yeah. Lognav, how you doing, man? It's good to see you. It's saying the problem is not the source code. The problem is there is no documentation. Exactly. And you can't just reverse engineer their stuff by them just explain how their software works. Yes. So the source code can only be tested in execution. Okay, it's the laws of physics versus what we understand of the physics. Yes. Okay. Digital Void saying, okay, can you just recreate the iOS with enough time? No. And I don't think you can. I don't think you can ultimately. But yes, well fucking stated. There we go. Applesauce code is not available to anyone, but you don't think people have left Apple and said screw the NDA? And Unhung Hero is 100,000% correct. I bet people have screwed the NDA, and I'm sure that Apple, if they get the opportunity, will fucking kill them. So they've got to be careful. Do you think we know how to operate around that source code and grab that information? Hold on here. How do you think we know how to operate around that source code and grab that information? I mean, I'll accept that point here. You could reverse engineer anything with enough time, but yeah, but I don't think it would take forever to reverse engineer the phone. Applesauce. Is that what they actually call it? Applesauce? Luke says, as a mathematician, I'd rather kill myself than doing this mysterious black box that physicists are down for. Okay. Well, let's keep going. Let's keep going. Yeah, she still found different results across different testing, across different tools. Yes. All right. Let's keep going here. Johan, I'll get this in a minute. I don't think the jury, if I'm confused, I doubt the jury knows what the fuck's going on here. So let's keep going.
And from doing testing and validation. Those are separate concepts. They should not be commingled as if they equate to each other.
So have you ever learned of Have you ever spoken with Mr. Whiffen? Ian Whiffen?
I have
Wait, we need to rewind
parse
here.
tools. Again, these are three separate concepts. The concept of code and actually reviewing code to make a determination is different from parse tool results, is different from doing testing and validation. Those are separate concepts. They should not be commingled as if they.
Shouldn't they reinforce each other, though? I mean, like, okay, I get not commingling them, but shouldn't you be able to be like, this can, like, they build on each other? I'd argue it's pretty critical they all jive.
Equate to each other.
So have you ever learned of, have you ever spoken with Mr. Whiffen? Ian Whiffen?
I have spoken with Mr. Whiffen historically, but not since the term of this trial.
Have you ever spoken to Mr. Whiffen about whether the Apple source codes are the best source of information about topics like timestamps? Have you ever spoken? That's just a
I have
question.
not had
Have
that
you ever talked to him?
conversation with Mr. Whiffen, no.
Okay, all right. I want to move on to, and do you regard Mr. Whiffen as a reputable?
Mr. Whiffen is a reputable forensics examiner, and I've actually reviewed his work in other instances and peer reviewed his papers.
So you have regard for his
I have
reputation?
regard for his
I'm sorry,
reputation.
we have to wait for each other.
Oh,
to
yes,
talk
I'm
through the
sorry.
defense. It's all right, no worries. So you have regard for the opinions of Mr. Whiffen generally, correct?
Absolutely,
And
yes.
you believe he has a solid reputation, correct?
Absolutely, that is correct.
Now let's turn to the History DB database. You are familiar with History DB? History DB, are you familiar with that phrase?
I am familiar with that phrase.
Okay. Do any of the house-long searches appear in the History DB?
In this instance, no, we do not have artifacts in the history DB of either of those two searches.
So I want to just repeat that in a different way. So the History DB, is that considered a valid and valuable source of information in an iPhone?
That is a valuable artifact for Safari history. That is correct.
But the house-long searches we've been discussing do not appear in that History DB, do they?
That is correct.
You spoke about PYF PDF on your direct testimony. Do you recall that?
I do. It's the Python framework for PDF. It is a GitHub tool, one can download from GitHub to utilize to create PDFs using Python code. So a developer and a tool would integrate that to create a PDF.
And the PYF PDF can have the variables set, correct?
Yes, the Python script allows the developer to set things such as their name that they created the document. Yes.
I want to go to the extraction of Jen McCabe's phone that you talked about on direct examination. Is the hash value signed or unsigned?
A hash value isn't signed. I believe your question you're asking is if the Adobe document that contained the PDF that contained the hash values, are you asking me if that's signed? Because a hash value is something that matches. A hash value isn't signed.
Let me ask it this way. Is there any hash value associated with Jen McCabe's phone that is unsigned?
That is not a valid question. I apologize. We don't refer to hash values as being signed or unsigned. We would refer to the PDF that contains that value as being signed or unsigned.
Have you ever read a report of Mr. Ian Whiffen in this case?
I have, but I have to be clear. I have not read all of Ian's reports. I've only read some, so I don't know if I read some of his earlier reports.
Do you recall reading a report of Mr. Whiffen where he references a hash value being unsigned associated with the iPhone of Jennifer McCabe?
Can I see said report so I can validate if I did or did not? I'm not sure based on just that, because I wouldn't use the term hash value being signed. I did see a report in which Mr. Whiffen spoke to the PDF not being signed.
I just want to try to shortcut this and work off your last statement. You're now saying you do recall seeing a report of Mr. Whiffen where he said a PDF was unsigned?
I need to see, I do remember him referencing the PDF. I would need to see the report, especially since the characterization of hash value being unsigned is not a term of art that I am familiar with in our field.
Let me ask if you agree or disagree with this statement. This value can be used to compare with the original hash calculated at the time of extraction in order to validate the extraction data. However, this requires authentication of the original hash value, which is not possible with gray key extractions, as the PDF containing the extraction hash value is unsigned. Therefore, this hash value could be used as a suggestion of authentication, but cannot be guaranteed 100%. Do you agree or disagree?
His statement there says the PDF is unsigned, not that the hash value is unsigned.
Right, but it's nonetheless unsigned, correct?
The PDF is not signed. That is a correct statement. Gray key PDFs that purport that value are not an Adobe signed document.
Do you know the history of the extraction of Jen McCabe's phone? It's a
Can,
yes or no.
can you provide more clarity? What do you mean? Do you mean from the time the image was made? Do you mean from the time the device was received? Because I don't know the information pertaining to the receipt of the device into evidence, and then I only have the documentation
He's
of the
fucking
image
up right
forward.
now. Okay.
So I want to be clear about what period we're talking about.
It's an excellent point, and I am going to follow up with some questions.
Okay.
In an extraction, doesn't the extraction from a phone start with the raw data, raw image? You tell me, when someone brings a phone in, what's the first step that gets taken in order to do a full file extraction? What's the first step?
It depends. There's got to be steps with regard to network isolation. I need to know if the device is AFU or BFU at that point. So I don't have that information from this case, if that is the question. I get from the image forward.
So what I'd like to do, and this may be my last section of questioning, I'd like you to describe the ideal situation as to getting the most reliable data from an iPhone from the start. What's the most reliable way to do it?
I would say the most reliable way is following the recently released SWIG-DE Scientific Working Group on Digital Evidence document on best practices of evidence handling, preservation, and imaging. I may have that title slightly out of order, but it is the document released this January.
And tell me what that is.
Sure. In that, the first thing, from which point are we starting? Are we starting like extracting the data using a tool, or are we talking on scene, taking the device into evidence?
The latter.
Okay. So the first thing you're going to do is you're going to ensure that you are isolating the device. This is also going to depend on condition from the network. So typically this would be done with a Faraday enclosure in a best practice. However, there are alternative ways of isolating from the network, such as disabling all of the communication protocols, such as Wi-Fi, airplane mode, etc. The next step, once you've isolated, but you also want to make sure you're continuing battery stat. So if a device is on, you want to keep it powered on. If it's off, you want to keep it powered off. That's a general statement. So the best way to do that is to attach a battery charger, just like when your battery runs low, you plug in a charger in the back of these battery packs. We do that with that before we put it in the Faraday bag. A Faraday bag is an enclosure that blocks signal.
A Faraday bag's, just basically like aluminum foil. Anything that'll stop any radio signals from going in or out. So Faraday bags are great because they're EMP proof. So if you're a prepper, you know what a Faraday bag is. You make a Faraday cage. You can protect electronics with it. So a Faraday bags do work. But yeah, so I like how she's explaining a Faraday bag, but I'm sure a lot of you guys know what a Faraday bag is. You got to get a couple from InfoWars, yes. McAfee didn't kill himself. Yes, Michael Faraday. Yep. Faraday bag is not EMP proof. I'm pretty sure it is, though. A Faraday cage would be EMP proof. Okay, Unforced Ego for $20. I already have a Faraday cage. I made one. They're pretty easy to make, guys. You could put all kinds of electronics in there. Safeguard them for the future. I'm a software engineer professionally. She's full of crap when she says the tools based on RE are better than if they had access to the source. She's just straight lying and she has to know it. I was gonna say it's never any better. The original is the best. Having access to the Coke recipe is gonna be better than sitting there trying to reverse engineer the Coke recipe. It's always better to have the original. So, yeah, Faraday cage alone is not enough for a high EMP. Well, I have a 20mm ammo can that's multiple layers of foil that's been sealed and set with inserts of insulation. So, you can make a DIY Faraday, yes. So, let's see here.
From coming to the device. This is so a remote wipe command couldn't be sent, or so that more data isn't received to the phone, because phones are live and constantly obtaining data. So we're going to have it with a battery pack in the Faraday, presuming it was on. Again, I don't know the status of this device. The next steps are going to depend on what state that device is, and what make and model that device is, and what the current support for that device is. There are multiple types of extraction methods of phones. In the modern day on iOS, a full file system image, what we had on the devices in question in this case, is considered the gold standard because it has the most robust information. So at this point, the next question is what's the best image type? And that's going to depend on if we have a passcode or if we don't have a passcode.
If I could,
Please.
and I'm going to allow you to continue.
Yeah, please.
I want to break it down for the jury. So what I now want to do, you've stopped at a certain point, but you've talked about securing, what I would call securing the phone, right? And then making sure that there's no data swipes. You talked about airplane mode, Faraday bag, Faraday box, right? Do you know whether any of those protocols were followed for either the iPhone of Jen McCabe or John O'Keefe?
As I mentioned, I was not there for those processes. I don't have documentation of it. As mentioned, what started where my receipt of the device is from the image.
Exactly. So you don't know.
I can't testify to processes I did not or was not available or aware of.
Fair enough. But do you have a little bit of hint as to whether the phone of Mr. John O'Keefe was properly secured in airplane mode, a Faraday bag, or a Faraday box, based upon your own report of the iPhone of John McCabe? Can you determine that from page 5 of your report?
Obviously, there is data signals that are still being made and created. I believe that is what you're referring to. So the assumption is that I don't know at which point a Faraday bag is employed, but I also want to be clear. I don't know when, I don't have information outside of the digital forensics realm about this case. So I don't know precisely when the phone was taken into custody by law enforcement.
Fair enough. So assume that Mr. O'Keefe was deceased around the latest 9 a.m. on January 29th, 2022. Isn't there activity on that phone, health data activity, up to around noon of January 29th?
Health data activity would continue to be reported regardless of if the device was isolated from the network or not. Health data has to do with the movement of the device. So if the device was being moved even within a Faraday bag, that data would still be populated.
How about location data?
Location data is unlikely to be reported in a device that is Faraday enclosed, but I do not know what location data you're referring to, so I cannot speak in absolutes without having a better reference to the artifacts in question. If you're saying it's in my report, I'll look at it, but again, I never knew when the phone was seized, so it was not part of my initial analysis. Do I have permission to look at that time? Thank you, Your Honor. So bear with me, it's a big report, as you know,
It is a big report.
and it was at the bottom of my stack.
Pardon me?
All right, it was at the bottom of my stack. I had to lift up the other ones to find it. All right, so.
Your Honor, may I assist and point her to a page?
That'd be
Thank
great.
you. If you could turn to that report on your page 47
Mhm.
and continue on to page 50.
I do see incoming data that is consistent with the device not being Faradayed, such as the receipt of SMS messages, notifications from Ring, etc.
So the iPhone of Mr. O'Keefe was not secured in the manner you described before we got to this, as would be the best practice with regard to getting the most accurate data from a phone. That is, once it comes
okay.
in, that it's either be put in airplane.
I want to say all of you, Unhung Hero, Palmyra, Hail to the Break, Unforced Ego, Johan. Thank you guys for helping me, because I do not understand what the fuck is going on here. And I'm trying to do like a little research. I'm trying to Google on the side. I don't understand what's going on here. I don't understand it at all. So, Crystal Henderson gifting 5 subs. Crystal, you the man. Even though you're a woman, you the man. Thank you for your support and your generosity. Let's see though. Let's keep going.
Airplane mode, Faraday bag, or Faraday box. That's right. By your own report, you see activity.
I do see activity. It was not Faradayed. Faraday prevents wiping of the device and additional data. So actually, in this instance, it doesn't appear that the device was at risk of wipe because it was not wiped. And we actually have more data because we get to see the data that continue to come into the device. I'm not saying that's in accordance with best practice. I'm saying that that's what I see based off of what you just had me reviewing the data.
It sounds like you're trying to justify.
Oh, I'm not
if
trying to
right or
justify.
wrong, you tell me. It sounds like you're trying to justify the fact it wasn't secured. Am I correct?
No, you're incorrect. I'm just stating we have, you asked if we had more data or less data. We actually have more data with it not being Faradayed, but no, best practice would be to Faraday. I
wasn't my
100%
question.
agree.
My question wasn't, is there more or less data? My question was simply, doesn't your own report
Sure.
show activity up until noon on January 29, 2022?
Correct. And for clarity, my scope was till noon, so I don't know if there was activity beyond that.
Right, but as far as your scope goes, I want to be clear.
Yeah.
There is activity on
Absolutely.
this phone
Absolutely. The
which
phone-
shows that it was not put in airplane mode, it was not put in a Faraday bag, and it was not put in a Faraday box. And that failure is not best practice.
Correct. It is not in accordance with the
Uh-oh.
best practices. I agree.
Uh-oh.
I would have Faradayed it.
Thank you. So
If I,
that's
presuming all
okay.
things.
I have no further questions. Thank you for answering my questions, Ms. Hyde.
Thank you for your questions. Have a great day.
Thanks, Brian, any redirect?
Thank you. Of course.
Whenever you're ready.
Thank you, Mr. Green.
You are. You were asked when you began working.
That's kind of what I'm thinking here, KRM. And if you guys, all you computer people out there can tell me this, and God forbid, my biggest fear is like some computer channel is going to watch this and laugh at me. Did they fuck with the data? Did someone fuck with the data? And those artifacts are proof of them fucking with it? I'm just saying, to me, that's what it sounds like. Something happened. The artifacts don't make any sense because everybody's saying this shouldn't happen. And okay, we got one super chat to get to here real quick. Unforced Eagle for $5 says, that woman's attitude makes me want to Fed post, Sean. I'm going crazy. Ah! And then, let's see. Did I miss another one? Chugi Show says the white rag is too tight on the head. Could be. Ultimare is saying for $5, you are missing that she is in daycare for the state. The real issue is that this is all T reading. If you really wanted to know time, ask Google. Yeah. Okay. Is the hash change? If the hash is changed, the change of custody is broken. I understand, but I don't know. Like I said, I don't think we know anything at this point. Kurt, yeah, sure. Hold on here. I'll send you a link. Kurt. Let's see. Let me see what you think here. We have a special guest, chat. Court should be able to look shit up on the internet during the trial, yeah. There was a lover splat at a bio lab and someone got their suit punctured? Who, buddy? Yes, an EMP storm happened on the night of the blizzard. Okay. All right. So here we go. Hi, Kurt.
Yeah, I wanted to pick your brain on this evidentiary issue because I'm not sure what the answer is. I think the judge was right, but I'd like a second legal opinion.
Okay.
So here's what I understand they wanted to do. They wanted to question this state's witness with regards to a Maryland case that she was involved with, I believe. I'm not sure if it was her or not, anyways. But relating to these issues, and the Maryland judge found it basically not admissible for the purposes of Dober, I believe. Yeah, and so they wanted to use this case and then question her about it on the stand. I'm not sure that makes sense. I'm like, I understand that the case is usable for the purposes of this judge's Dober hearing. You know, what other courts have done would be informed to whether or not this judge should allow the witness.
Yeah.
In the scope. So I understand it's admissible for that reason. But I don't quite see how what the other judge did in the other case is a basis or fodder for questioning of the witness in front of the jury. That part I'm not so sure about. That doesn't make sense to me.
Well, I mean, you're allowed to challenge her reliability because remember, she's saying, I have science.
Yeah.
Well, I'm allowed to challenge your science. Like,
yeah. Well, no, I mean, you can ask the underlying questions.
Yeah.
You can ask the
Yeah.
you can ask all the underlying foundational questions.
Well, I think this also goes towards her credibility, though. It's like somebody else said you don't know what the fuck you're doing.
Yeah, I'm not sure if that makes sense for the same reason that if there was
mean,
a court in some other proceeding that had said
It
that
could
she
be
was
wrong too.
credible,
Sure. Yeah.
right, then you
And
wouldn't allow
yes.
it for bolstering.
Yeah, it would be a bolstering, but this is where I think she could say, "Look, no, they got it wrong. Here's my point." I agree. That's where I think the ultimate issue is, but they went into it. They got to go into it, though.
Well, with all the underlying stuff, yeah, I mean that's fine. Isn't it true that you didn't have access to the source code? Isn't that like all the foundational questions?
Yeah,
like all those are fine. But what they wanted, but I didn't need the Maryland case for them in the first place. I could have asked those questions.
Luke, it wouldn't be hearsay because it's not a statement; it's a document.
Yeah,
so you probably want.
It's not. It's a finding of another court, so it's not hearsay.
Yeah, and now Bev is right though. She can say, this is basically my equivalent in some other state. I disregard it. And that makes sense.
Yeah, that makes sense to me. Because I'm just like imagining,
Yeah.
In the same way you can't bolster just because another judge found it not to be credible for the purposes of their own dope bearer. Doesn't seem like it necessarily makes it fodder for this courtroom and the questioning of this witness.
but at least he was allowed to get into quite a bit. So I'm
with
not
all the underlying stuff, I think is fine because
but he was really able to make it happen anyway. So
yeah, maybe it was a distinction without a difference in the end.
I think so. I mean, I think he probably got a lot. I'm sure Bev clipped the wings on it a little bit, but I'm sure they still got away with a lot because it's.
I mean, the only question he wasn't really allowed to ask is like, isn't it true that some Maryland court found that you're full of shit?
Yeah,
that was the only question he wasn't allowed to ask.
Yeah, he did everything else but that, and I think that now she mentioned something about Maryland, which I think that doesn't help things because now she's introducing the whole issue of kind of like Jen McCabe saying another agency or the agents, and it's like you're tipping your hand about who was here, you're volunteering. So
yeah. It just seemed
I mean I get it.
I think the judge was right in the ultimate conclusion, but I wanted a second opinion.
Yeah, I mean the more I think about it, Bev was right to say you can't say specifically what happened, but ask every other question, and they've
all the underlying questions. All the underlying questions is fair game. That's all fair game.
I think it has been hilarious how she's been dancing around the issue of either her or Whiffin's wrong, and she won't say which one. So,
which one?
Well, it gets to the issue of I think she's faced with a problem ultimately, and unless he left it out there, who's right? You or Whiffin, because you guys both can't be right, and I think there's an issue, and I think that she didn't really have an answer for that.
No, I think that's fair too. I think that's absolutely
fair.
But
that's a really bad.
And also on just separate and apart from the somewhat esoteric legal issue, I wanted to kill myself at several points during this testimony. Is that a normal feeling?
I mean, not this one. Because I'm going along with that. I don't understand it, but I think I can understand the idea that she doesn't really know what she's doing, and she refuses to admit.
Did you get to the part where she's talking about the restaurant and the pizza yet?
Yeah, though that part was awful.
Yeah.
Even as a fat guy, I couldn't keep up with that.
It was pretty bad.
No, but her argument.
My computer science degree is crying tears.
Well, my political science degree is completely dumbfounded. But I will say, I don't know a lot about technology. I'm very technology retarded. The idea she could say the source code is not the best way to figure out all these things, and that would not be the best way to validate any of her arguments is complete bullshit. So,
yeah,
I was very stunned. She said,
and you know what's interesting is like I have absolutely zero memory of her testifying from the first trial. That's
because she didn't look like a dope the first time.
Well, I guess not, but I mean, I'm watching her and I'm like, my memory is not being refreshed, John. I'm watching her. I've got nothing. Nothing's coming back. So I don't know if my mind like deleted her testimony from because I'm like I've never heard this woman before in my life. It's like,
I don't
I
recall
got
her.
nothing.
I don't recall her myself,
Okay.
but
All right. So I wasn't alone on that. That's nice news.
yeah,
Okay.
Johan and some of my other people here, they've been saying that unless he was doing good for a while, then after a while he crashed and burned and turned into a boomer. But it didn't matter because if she realized that he was being a boomer, she could have just destroyed him, but she didn't. So that just shows you she's an idiot too.
All right. That was all I wanted to know. Thank you. For
No. I
thanks
mean,
for
like,
the-
I think that's ultimately, yeah. They
Thanks
got
for
what they
look-
needed without.
Oh
putting
yeah,
that
yeah,
in there.
no, it's fine by me. So thanks for the legal colloquy.
Yeah, sure.
All right,
Guys,
cool.
Kurt on civil law.
I'll let you get back to it. Bye bye.
Yep. See you, Kurt. Guys, Kurt over at Uncivil Law, friend of the show. Leslie did great. I mean, he did good, but I mean, he did all right. So let's keep going here.
On analyzing phones in this case, and you said it was in May. Was that in May of 2023?
May of 2023, May 4th, 2023 is the email I have of a note. Thank you. Yes.
Okay.
It's easy to remember because May the 4th be with you.
When you first were asked to begin work
Fucking choke yourself. Fucking choke yourself. I love Star Wars, but fucking choke yourself.
on this case in May of 2000,
I hope this black woman right here, I hope right here she pulls out her fucking handgun and shoots her in the fucking head. That's how bad that is. Also, you guys are wondering why is the podium all the way in the back of the courtroom? Because the courtroom is roughly shaped like this. Bev is here. The camera is like over here. The jury is right here. The witness is right here. And one of the things you do in trial advocacy, like here's the witness, here's the jury. You want them to hear you. So where do you stand? Well, remember, in this room, there's these big tables, like you have the prosecution table. And then right here is the defendant's table. So where do you stand? Well, there's nowhere to go except right here. And that way, everybody in the jury can hear you talk. Because if you stood right here, all the back half of the jury wouldn't hear shit and see the back of your head. So you present yourself in a way that you're projecting and presenting to the whole jury. If this was a bigger courtroom or a differently set up courtroom, that can all change. But that is a function of the layout of the courtroom. Somebody had asked that earlier, so I wanted to address it. So, also, you guys are wondering where stuff is. Okay, well, this other side over here is the victims. So here's Paul in the corner. And then this is all Karen's family here. And then the reporters are like back here, where Turtle Boy would be. That's a rough map of the courtroom. That's why he's all the way in the back.
2023. What was the catalyst for you to begin working on this?
I was contacted by Mr. Tully and then contracted, a SAO was signed, and I began work on the initial request to look at those two search terms on January 29th. Does that answer your question?
Sure.
Okay.
Was there a certain claim that was lodged that you would have focused on?
I was to focus on the two search terms from January 29th, 2022.
And would you inform why? Was there any context to that?
Probably, I don't recall the exact conversation that I had with the DA's office and Lieutenant Tully at that time, but I'm assuming that I was given that context. I have in my notes that I was to look at those two searches on that date and do an analysis about those.
Were you asked to reach any particular result?
No, I was asked to provide my report, not to reach a particular result.
Were you asked to reach a conclusion that the 227 timestamp was inaccurate?
No.
When you engaged in your analysis, was it independent of the district attorney's office?
My analysis was independent of the district attorney's office. I actually, in the first case, had very little communication with the district attorney's office during the period of my analysis.
Was there any input from any outside source on what your result or ultimate opinions would be?
No.
Would you ever allow anybody to affect your input?
No.
Throughout the course of your efforts with this phone, have there been changes to software?
Absolutely. As mentioned on direct, software updates are near monthly.
I want to ask you about changes to the Celebrite software. You were asked about certain reports you wrote. Were the reports that you wrote relative to different requests for analysis?
Yes.
The report regarding, report number 3, regarding changes to Celebrite software. Was that report limited to the timestamp change, or was it to include other efforts?
The scope of that report, may I review what I have documented as the
Please.
scope? I believe we're talking about report 2. That's the one about the Celebrite change.
Yes.
And I have the request was to understand changes made in the newer version of Celebrite Physical Analyzer to artifacts pertaining to the timeline of a particular Google search on January 29, 2022, namely how's long to die in cold.
When you looked at the Celebrite software and report, was the timestamp characterization changed or removed?
Yes, it was removed. That timestamp in the version starting in May of 2024, Celebrite actually removed that, and they put a release note stating that it was due to the ambiguity and potential for misconstruing the meaning of that data.
Was there any other releases informing other reasons why that was changed other than the potential that somebody could misconstrue, misinterpret, or distort the information?
Can I read Celebrite's own statement?
Please.
Celebrite's statement
To yourself.
to myself? Okay, roger that. Thank you.
I was about to say, you don't get to read Celebrite's statement out loud. You are not Celebrite.
I appreciate that. Can you repeat the
Share with
question?
us, was there any reason other than the concern about misinterpreting? Or
They said
distorting?
that
So what's your understanding?
my understanding is that it is not a reliable timestamp, and that is why Celebrite removed it.
You were asked about Axiom. Axiom.
So they're saying that they generated unreliable data, or are they saying Apple's provide like which are they saying that the timestamp's unreliable because based on what they do, it generates unreliable data, or is this data from Apple, the source code, that's unreliable? Like how, in what way is it unreliable? Like who are they attributing the unreliability to? 'Cause I don't understand that fully. So, yeah, the timestamp can mean several things, and I think she's trying to avoid getting sued. They quit reporting the timestamps because they aren't sure what it is. Yeah, well, there you go. Yes, and that means the code they got is unreliable. Well, no, their interpretation of the code is unreliable. To argue Apple's code is unreliable would get you fucking sued. So no, the Apple's code is not reliable. So it's almost over. Let it ride. Yeah, this is a weird fucking interpretation of shit. Okay, so let's keep going.
Is it the same or different?
Magnet Axiom and Celebrite Physical Analyzer are two different tools that both do forensic analysis of mobile phones.
You were asked whether Axiom still has a timestamp that was similar to Celebrite before the change.
Axiom shows what I spoke to on direct, where they have it as a parsed versus carved result. And so that particular result shows in the suspended StateDB artifact as carved.
Do companies like Axiom and Celebrite give releases, updates, information about how to interpret their reports?
So Axiom actually has a document that's released with it called the Artifact Reference Guide, and that actually gives a brief description of the fields and of artifacts. All tools, when they release new artifacts, they put out in a release note. Not all artifacts are clearly documented that are parsed. However, all of the vendors regularly put out webinars and blog posts that explain their new artifacts, but not necessarily all.
Is there any releases or cautions from Axiom on the same issue about misinterpreting a timestamp?
Axiom, in their artifact reference guide for this artifact, does speak to the possibility of misinterpretation and states that the timestamp can be earlier than the search had occurred based on what different reasons could cause that timestamp.
Let me ask you about a Faraday bag. You said that best practices is to isolate an item in a Faraday bag.
That's correct.
Do you have any information, or did you know the travel of Mr. O'Keefe's phone that night, or where it went after?
I'm sorry, can you clarify the time period?
On January 29, 2022, from say 6:04 in the morning until later that afternoon.
I did not have access to that information.
When you analyze data from certain devices, are they always placed in a Faraday bag immediately after an incident?
There's a lot of times when this is situation dependent. An example of when you would not put something in a Faraday bag is when you have a deceased victim and you're going to be using their biometrics to possibly unlock the device. Because a Faraday bag is enclosed and then can't be opened, if your intent, if you don't have the password, is to use a deceased person's fingerprint to unlock the phone, we don't want to put the person's finger in the Faraday bag. So usually those phones would not be Faradayed, but they would typically have airplane mode enabled or SIM card removed. But no, SIM card removed doesn't actually work on iOS, so I won't get into that.
understanding or having the opinion that this item was not placed in a Faraday bag at 6:04 in the morning, does that in any way affect your opinions about the data that you analyzed on this phone and the conclusions that you reached regarding Mr. O'Keefe's phone?
It does not have any impact on the conclusions other than the fact that it wasn't Faradayed and more data came in. So we have additional data.
1.3.
You were asked a very specific question about history DB, and it was simply
Oh,
whether or not
1.35.
how
Sorry.
long to die in cold, whether it appeared in history DB. That isolated question, does that provide any context for you in your analysis and conclusions about how long to die in cold and that it occurred at 6:23 and 6:24 the next morning?
The absence of the history DB artifact doesn't mean that that search didn't occur at that time. We have multiple corroborating artifacts, which is usually what we look for, 2 artifacts that demonstrate is like very good. You don't necessarily need that. But in this instance, we have both from the mobile Safari plist, which tracks the history, as well as the knowledge C DB. So we do have 2 artifacts showing that those searches were done at that time. Of course, 6 seconds apart for the difference between the knowledge C and the mobile Safari plist.
On direct examination, you were not asked questions about Mr. O'Keefe's phone.
That is
but
correct.
You were on cross-examination, so let me follow up. You have a report that you authored regarding Mr. O'Keefe's phone,
That is correct.
and you had an opportunity to look at the healthcare data for January 29, 2022,
That is correct.
page 6 of your report.
Thank you.
You noted that there were steps that began at 12:11:09 a.m. Is that accurate?
That is accurate.
And the way healthcare data works, you have an understanding whether steps means a person actually took a number of steps, or does it mean something else?
Steps doesn't necessarily mean that you took a number of steps. It's based on the motion of the device. So it could be steps. It could be you're carrying it. It could be that you're in some other kind of motion. You could be on a bicycle. You could any number of things. And the number of steps is.
Okay, so you're verifying there was movement. You're now admitting there was movement. Was there a bicycle? Like, no. So there was movement. At least you're admitting there's movement. And the movement's not explained.
Based on the presumed gait, based on the input into the Apple Health app in terms of gender and height. So it determines a gait and then prescribes a number of steps, but it is possible for other things to cause steps to occur.
Yeah, but right now you're just speculating.
You were asked specifically if you saw that there were reported movement or
Now,
health
she's an expert. She could speculate, but she's fully just fucking guessing now.
steps at 12:21:10 a.m. and specifically pointed out to you notation or characterization of 80 steps. Is that accurate?
That is what's stored in the database. I try to clarify, as I did for you, sir, that that's what's stored in the database. I'm not saying that 80 steps were taken.
And by the way, in addition to the healthcare analysis, you did some analysis on the movement of a car, didn't you?
For Ms.
Your Honor.
I'm going to deny that question.
Can these health steps occur if somebody's holding a phone while traveling in a car?
As mentioned in my report, it's caused by motion. It could be various motions that could cause it. You could be using an elliptical. You could be in a vehicle. You could be on a bicycle. It's not necessarily steps taken.
Based on your analysis of Mr. O'Keefe's phone and the report that was pointed out to you in cross-examination, and do you have information or opinion where Mr. O'Keefe's phone was located around 12:21:10 while those steps registered?
Objection, Your Honor. So,
That's beyond the scope of the process.
It was pointed out to you at 12:21:10 there was a registered 80 steps. Is that accurate?
That is correct.
And then you were also asked about the last healthcare data, the last movements of this phone. And it was pointed out that began at 12:31:56 for 20 seconds.
That's correct. Per the data in the database.
And is that the last movement of Mr. O'Keefe's phone that evening before 6:04 that you saw when you analyzed the entire data in the phone?
May I have one moment to review?
Yes.
That appears to be the last before the 6 a.m. hour.
So that 20 seconds, it began at 12:31:56. What was the last movement in seconds in time at that time of Mr. O'Keefe's phone?
I'm sorry, can you repeat?
Yes, if that was a 20-second interval at
That's correct.
12:31:56, what was the last second that evening that Mr. O'Keefe's phone moved?
12:32:16.
And then when you analyzed the phone and were asked about these times, Is there any movement between that last movement and 6:04:01?
Between the 12:32?
Yes, 12:32:16 and 6:04:01. Any movement of that phone whatsoever?
I do not have anything supporting that in my report.
Do you know what was going on with Mr. O'Keefe's phone at 6:04:01 a.m. on the morning of January 29th, 2022?
I do not know precisely what was happening with his phone at that time in terms of movement. If that's, or are you asking me? I'm sorry. Can you clarify what you mean
Yes.
by the question?
The next movement after 12:32
Is the 6:04?
6:04:01
Correct.
a.m.
Correct.
Do you have any information about where or why there was movement of the phone at that time?
I don't. That wouldn't be inside my digital evidence. I don't believe.
And the last question is the next movement at 6:15:14. Do you know if that phone was being moved by somebody or somebody else than Mr.
The
O'Keefe?
phone was in motion. I do not know if it could be by a person. It could be on a rail car. I don't think it was on a rail car for clarity, but I don't know what is causing that motion at that time.
Thank you very much.
Any follow-up, Mr. Woods?
Wait, hold on here. So I don't know what happened at this time.
Somebody or somebody else than Mr.
The
O'Keefe?
phone was in motion. I do not know if it could be by a person. It could be on a rail car. I don't think it was on a rail car for clarity, but I don't know what is causing that motion at that time.
Thank you very much.
It's a big fucking problem if you can't explain it.
Any follow-up, Mr. Woods?
Yeah, this is a big problem.
We have a moment here.
What
Ms.
the-
Hyde, you
Predator?
were asked questions by Mr. Brennan just moments ago about Celebrite and release notes. Do you recall those questions?
Yes.
And did Celebrite, beyond stating that their opinion was the 2:20:40 a.m. timestamp was not reliable, did they give any reason at all for why they concluded it was not reliable in that? I'm sorry, we'll wait for the,
Thank you. I appreciate it.
and I'll repeat the question.
Thank you.
May I, Your Honor? Thank you. In that release note, does Celebrite state any reason for why they wrote not a reliable timestamp?
There are other.
I'm sorry, my
published, but
question
not
is, did they
Celebrite?
state in the release note whether there's a reason for why they concluded?
Thank you, ma'am. Thank you, Your Honor.
And please try not to talk.
I will,
Sorry, Your Honor.
Thank you.
2.
Not asking you to read it, just asking whether or not they give any reason for the conclusion, not a reliable timestamp.
One moment. I'd like to review what they wrote. Thank you.
Absolutely. You're welcome.
Yes, they do. They state that further research since is the reason that they're doing it, that there's further research.
Did they state what that research is?
They don't, but
All right, but they don't state what the further research is.
that is correct. They
All right,
state
now
that
what I'd like
it's
to do is-
unreliable.
Move on to Axiom.
Mhm.
You were asked questions by Attorney Brennan, and you referred to Axiom as using a different parlance with a timestamp of carved, correct?
Celebrite uses this deleted demarcation or recovered demarcation. Axiom does not do that at all. They speak to how they recovered the artifact, be it that it was parsed. When I say parsed, I mean the item was where it was expected to be in the algorithm, found it, located it, and said it's here, versus carved, which is when they have to go into an unexpected area, such as slack space, which would be the areas that are not yet used or were previously used to extract the data from that.
So Axiom actually recovers the timestamp, but Celebrite does not. Is that correct? Is that correct?
Yes,
Okay.
currently, previously, when we did the first case.
Right, but
It's the
currently,
opposite.
Celebrite
Correct.
doesn't, but Axiom does. Axiom recovers 2:27:40 a.m., correct? Timestamp? They
That
recover.
is the timestamp that they show for that artifact. Correct.
Exactly. So now I'd like to go back to the next topic, our discussion about Mr. O'Keefe's phone and secured or not. You talked about one example of maybe needing to use a biometric to unlock a phone, and that might be a reason, as I understand it, as to why someone might not put it in a Faraday bag or box. Do I have that correct?
Correct.
Okay, do you know whether the passcode was immediately provided on the phone of Mr. O'Keefe?
I do not have that information.
Assume that the passcode was immediately provided for the phone of Mr. O'Keefe. Can you think of any other reason why that phone wouldn't be put in airplane mode, Faraday bag, or Faraday box?
Best practice would be to put it in a Faraday bag.
Okay. And that phone was obviously not put in airplane mode, Faraday box, or Faraday bag after 6:04 a.m. on January 29, 2022, correct?
Correct.
Now let's go to,
Well, I don't know if at some point past 12 o'clock. My report only goes to noon, so just for clarity, I don't know
Fair enough.
anything past noon.
fair enough, but from 6:04 a.m. until approximately noon on
Correct.
January 29, 2022, at least that time, that phone is not in airplane mode in a Faraday bag or Faraday box, correct?
It would appear such. Because I didn't analyze past that, I don't know if it had been potentially Faradayed and then it broke Faraday and got data, but I don't suspect that based on this. It appears that that data was live. But I just have to speak to the fact that I
Okay.
just don't know because I didn't go past noon.
Okay.
But you're going past noon.
Right.
I'm not.
Okay.
My
yeah.
question,
6
and
a.m. to
I'm-
noon,
Mhm.
it does not appear to be Faraday.
So to be clear, from 6:04 a.m. on January 29, 2022 until at least noon of January 29, 2022, the iPhone of Mr. O'Keefe is not in airplane mode, it's not in a Faraday bag, and it's not a Faraday box, correct?
Unless it was in a broken Faraday bag, like they put it and it was failing. But it does not appear to have been placed in Faraday bag.
All right.
No, I'm just being honest. You should test your Faraday bags. They go bad. I use Dr. Katz's testing methodology, but 100% it appears to have been receiving signal for that entire period and not in a Faraday bag, which would be best practice unless biometrics were needed.
So let's now go to hopefully what are the last two categories of questions.
That's a lot of spurging right there.
With regard to the iPhone of Jen McCabe, do you have any knowledge as to whether over 200 calls were auto-deleted on her phone? You analyzed it.
We can see that calls were auto-deleted. You're asking me if the number of, I just want to make sure I understand the question. If the number of calls that were auto-deleted, if that exceeded 200?
My question is, do you know whether there was auto-deletions on Jen McCabe's phone? Do you know that?
I'm uncomfortable with the term auto-deletions because
How
I
about
don't know
deletions?
what that is inferring.
Okay. Did you analyze her phone at all for deletions?
I analyzed her phone to see if there had been deletions of call logs. And what I found was that there were records that were removed by the system and not recoverable from that database, but were recoverable from BIOS.
Understood. Now, what I'd like to do is to address your answer in response to Mr. Brennan's questions, where you said that the issue with regard to Mr. O'Keefe's, or just generally your proposition, that there was no impact.
So at the end of the day, Jen McCabe called 200 people or made 200 phone calls figuring out what the fuck to do in 3 days. That's a big fucking problem.
On your conclusion because more data had been obtained. Did I get that correct?
I believe my statement was there was no impact on my conclusion with the fact that it had not been in a Faraday.
Right. So isn't it, though, the case that when a phone's not in a Faraday and is therefore active, data can be overwritten?
Yes.
So if data can be overwritten when it's not in a Faraday, you can lose that data, correct?
Is there data that we're concerned? Yes, theoretically.
Right.
Yes.
You talked about, in response to Attorney Brennan, the 12/31/56 steps, and you said the last according to you, last movement 12/32/16. Do you recall those questions?
I recall the questions.
To boil it down, isn't it correct that that phone was moving at that time?
May I check the timestamp again? I
Absolutely.
apologize. There's
Oh, no.
a lot of timestamps going back and
Please
forth.
do.
12/31/56, is that
Yeah,
the?
that's the start. Yep.
Oh, yes, this one there definitely is. Yes, yes, yes.
So, doesn't matter what kind of movement, but that phone was moving starting at 12/31/56 and still moving until 12/32/16 a.m. on January 29, 2022, correct?
Yes,
Thank you. Appreciate again you answering my questions.
thank you.
All right, Ms. Hyde, you're all set.
Thank you, Your Honor.
Courtesy counsel about scheduling. First, feel free to stand up and stretch.
Well, chat, that was fucking weird. That was some weird testimony. And not weird in a good way. Oh, look, Paul's in the back. Paul's in the back of the thing, chat. And where's that comment I saw earlier? Do I still have it? Tech Guy South? I thought you sent it. Yes. Paul like fat law guy pictures. Fat law guy draw good. Paul not sad anymore. Paul have bald friend. Sit with. Paul whisper to mom. So, all of this for over 20 seconds of movement. Paul like thick lady. Paul smash. I feel they both lost way too much noise. Well, here's the thing. If the state lost, that means the defense did well. Remember, they just have to point out she don't know what the fuck she doing. So there we go, chat. That is the end of day 11. I mean, that was weird. Yes. Mom ignored Paul. Paul sad. So, all right, guys, we're going to catch up on some of these comments here and make sure I didn't miss anything. Yeah, Island saying, so Karen Reed drove across town in 3 minutes. They're running into issues with that. I think there's some problems. I think there are some problemos. Debbie says Donald John Trump, the Emperor of Mankind. Nominated Dr. Casey Means for Surgeon General. Beats the heck out of Dr. Jeanette, his original nominee. Yeah, we'll see how well that works. Thank you for the super chat. Whiskey 77 has been a member for 11 months. Thank you for your support. Saying she wasn't wearing her head wrap that blocks the CIA gamma rays when she made the typo. Yes. Nico says he's been a member for 18 months. Remember, chat, Nico's the guy who did our song. Says you and PPP are wearing the same shirt today, twinsies. I'll have to go look. Okay, Ultimate, we did this one. We did this one for Shugi already. Johan saying you create something similar because Apple's source code is based on FreeBSD, which is openly available. Okay. Held with the Break says this is no different than emulators. They figured out the black box based on inputs and outputs. Okay, well, that makes sense. I'm not the only one who doesn't understand this, and that makes me feel better. Suki with the good Gucci. We're not going to go to Corral no more? With 10 sobs. Thank you, Suki, for your support, your generosity. An Island says, just a reminder not to use your biometrics. That's correct, chat. No fingerprint or Face ID. Actual codes are the way to go. Because otherwise, they can use your body to open your phone, especially after you're dead. But it's also not a Fifth Amendment violation for you to use your face. So take your face off. So, nice one, Nico. Love the song. Yes, Nico did a great thing here. Use mushroom print for biometric. FYI, Google's the default search engine by Safari. I just saw an article. Apple told the DOJ they're looking at AI alternatives. Yes. In all seriousness, you have some smart computer peeps in chat. No, I realize, I know some of you guys had computer knowledge and stuff, but like tonight really made me feel better. You guys kind of know what the fuck is going on. I mean, overall, computer guys, did she sound like she know what the fuck she was doing? Like who? Like I just it sounds like her and Whiffen are two. They contest, they contrast with each other, they contradict, and like it seems like they contradict, but they also can't explain the unexplained, or they both have similar unexplains. Logan saying this 227 thing doesn't appear to me relevant. I'm going to attack on another front: the precision and location data. It's a number provided by the software, and we cannot say if 7 meters is accurate. That would be, I wonder why they didn't do that. I'm sure they had a consultation on that. She's outcome driven. Well, yes. Her program's off GitHub. Well, that's interesting. You're saying, oh hell no, and I'm rusty compared to my IT team, and they were losing shit over this. Well, there you go. That helps me feel better. That's me feel better. She knows how to do things, but I don't think she knows why they're right. Well, yeah, okay, that helps. That helps. She knows how to do stuff, but she doesn't know why she's right. That's hilarious. Robert says, use someone else's face for your Face ID unlock. That would be fucking hilarious. If you just flip through a magazine, you're at the doctor's office, flip through a magazine, you're like, Face ID, click. And then you just have a normal, because of the iPhone, can you do a normal like button code and Face ID? Because if that was the case, that'd be fucking funny. That'd be a great, because if you mess up with the iPhone too many times, it shuts down and locks down, right? That would be fucking hilarious. Oh no, 2.0's chasing Clyde with the wet vac. Oh no, Clyde! Clyde, come here. Come here, Clyde. I got you, Bubba. Clyde, come here. He's scared. Shit, I got him. Oh no. Oh no. Louis is like a cow. Like the first day it rained, I was like, oh my God, somebody tracked shit in everywhere. And I'm like, no, it's Louis just tracking in mud. He is a heifer.
Yes,
I will clean that for you when we're done.
Really?
Yeah.
Okay, cool. That's all you.
You're welcome.
Make sure you put it on the charger.
I will.
Laundry started.
Okay, thanks.
Thank you.
Mm-hmm. I love you, baby.
I love you.
Mwah. Also, Clyde. I know, Clyde. It's done. You ready to go? That was a anxiety yawn for Clyde. Clyde. Well, we're gonna set you down. Okay, Bubba? There you go. All right, chat. What kind of dog is Louis? He's like hold on. Hey, what kind of doodle is Louis? 2.0? Bernedoodle? Okay. Bernedoodle. There you go. I have to put away clothes from now on so I know where things are. Thanks, Young. But no, that was very, very interesting how that worked today. It was a good day for the defense, I would say, overall. Because the prosecution didn't make a lot of headway. Do I think that right now, if I had to gauge, we're 11 days in, Hank Brennan's out ahead. Hank's still out ahead. Remember, they're ahead of the curve. And remember, I told you guys, I think there's a good chance Karen gets there is a very good likelihood Karen could get convicted here. Retrials are very dangerous as a defendant. Retrials are very, very dangerous. So, Loodle says that's it. She's the girl with the pearl earring. I don't get how I came up with that, but thank you. Doodle Bernie? No, it's a Bernie doodle. A Bernedoodle. Yes, no shock in her voice. Sean's gonna clean. Oh, I'm cleaning up the wet vac. We have one of those wet vacs, and because of all the dog hair and just getting on the floors, because we have the laminate flooring in the house, so it's just cleaning it out and putting on the charger. I help. Oh, the expert witness. Okay.
Yeah. No, I should clarify that Sean does like 95% of the chores around here because he's my bitch. You were liking that where it was until I ended, right? But anyway.
You know, chat. When we're talking about stuff here. Have we talk about it's potentially criminal. Let's talk about domestic violence right now while we're at it.
No, Sean does do a lot around here because I work a lot. He works a lot. But he's also very, very helpful. Definitely do more than me.
Well,
you do.
Love you, baby.
I love you.
Clipped. Yes, kick Sean. Yeah, well, kick Sean. He's a. Are we gonna win some crime? No. She turned that ship around pretty quick. Whiskey 77 says, "You heard it. Sean is a biatch." Lol. Well, as like I said, I think I've said it before. My boss, one of my summer jobs when I was in high school, he'd say, "Biatch, you biatch." So, gotta keep the pimp hand strong. Yes. The front of the boat fell off that one. Yeah. Selfish Sean. That's kind of that's gonna be my autobiography title. No Mayo says Mama JF time. Well, I can't do that if she's a Fed. They're gonna know where she is. Isn't this how IDub's downfall began? Yeah, but he's also poops his pants all the time, so a little different. You never have the source code. I understand you never have the source code, but that means you can't have anything, and it's all hypothetical. But anyways, I think that Hank Brennan's out front right now. I still think there's this very serious risk for Karen Reed. We're going to see how the rest of the trial goes. And the one thing I will bring up, somebody put this up out there, and this is a very interesting thing. This is the Commonwealth's witness list. And I have some concerns because a bunch of people on this have, here's their entire witness list. Everybody in red has been called. So we've got some people. We got some people we know they're going to call. We do have nature's source code. We fucking crack DNA and we CRISPR shit. We do all kinds of things, man. We do have the source code. I would argue. But anyways, everybody in red is already been called. But I think we're going to put in green the people they're probably going to call. I think they have to call certain people. So Judson Welcher is the aperture guy. He's the head crash expert. They're going to have to call him. Dr. Scorty Bello is the medical examiner who did John O'Keefe, but it sounds like they're going to use Renee Stonebridge because she's from the ME's office. So they're going to use her. Now, what are they going to do from here? Well, I think they're going to, do you guys think they're going to bring up James Crosby? Maybe as a rebuttal witness? I don't know. So we'll highlight him for now. All these experts from the MSP crime laboratory, probably not. I don't know what Bode technology is. Lieutenant Tully's going to have to. And here's one I think they have to call. Michael Proctor. They have to call him. He's their lead investigator. He built their investigation. He built their investigation. And if he doesn't show up, you're basically condemning your investigation. Proctor has to come in. If they don't, he's going to get called by the defense. So I don't think that you have to call Proctor. Proctor's like the big one. Because if you don't, you're condemning your investigation. Yuri Buchanan is going to get called. Sergeant Bukaki. Lieutenant Lank is going to get called because they went into the house. I think he's going to get called. Sergeant Good was involved a little bit there. But I don't think the rest of these people they're going to call. The only other one they might call if they were smart, they would call this one, the bartender at the waterfall. Because she can talk about Karen Reed drinking a ton of fucking alcohol. There was also somebody from CF McCarthy's. So, but yeah, this would be very helpful. But the rest of these people, they're not going to call. They're not going to call any of these other people here. The Conner Keefe aren't on this list, which is interesting, but I don't think they call any of these people. I mean, maybe they call Brian Albert. I don't know. That just becomes unnecessary, I think. Just to say, did you see the lights? And he's probably going to be like, yeah, no, I didn't see him. I sleep real well. But who knows? The rest of these, I think they'll probably pass on. But I think that's kind of their list. I mean, they might have more people. Some of you guys are saying the neuroscience guy. Okay, maybe. But I think, like, Proctor has to go. Proctor has to go. What about Brian Higgins? I don't think they want Higgins. Higgins is really bad for their case. Especially the way he destroys their evidence. Yeah, I don't think you call Higgins. I think they're going to call the kids. They were so effective last time. They weren't, though. So, did we see the last clip that Brennan played to the end of the day? No. I didn't see a clip there, so I don't think they had one. Why would the Commonwealth call the defense lawyers? They're not doing that. They're doing it because they're fucking assholes. They put him on the witness list to fuck with them because Hank Brennan's a dickhead. That's Hank Brennan. Hank Brennan's being a dickhead. And then just like he calls in, he tried to do Turtle Boy. He did that to fuck with his ability to be present at trial. There's no reason why calling Turtle Boy. But there's also no reason why you list opposing counsel as a witness in the middle of a case because that's just poor form. That's poor form. So, John's kids did remember them. Did they call them last time? Am I remembering? I think they did, but it was very quick and they didn't show up. They had clips, Sean, get your shit together. Okay, I didn't see it. Sorry. I'm surprised they didn't list Karen Reed too. Yeah, well. Yeah, they put opposing counsel because of the ARC motion. Yeah, but I think, well, once again, Hank was being an asshole, and we realize now Hank was being a dickhead, so it doesn't matter anymore. I think Higgins played a big role in O'Keefe's death. Let us see the clip. All right, I will find the clip, I guess. Hold on. Give me a second here, chat. All right, let's see. There's a clip. Where's the clip? Where's the clip? Where's the clip? Okay, here we go. Clip 15. All right.
Please.
Absolutely love Jen McCain. Jen McCain, it's me or her. Either I'm going down, Jen, or you are.
That one really doesn't get you anywhere.
So, folks, I talked to the lawyers
That really doesn't get you anywhere because we both know they're antagonistic.
briefly about scheduling and sidebar, and I'm told we're actually ahead of schedule. So with that, rather than beginning a witness who's probably going to take a while, we may as well let you go and enjoy the rest of this beautiful afternoon. So we're on schedule, ahead of schedule. We'll reevaluate that tomorrow. Now you will see lawyers and sidebar asking for as well to talk a little bit about scheduling. Those same cautions, please do not discuss this case with anyone. Don't do any independent research or investigation into this case. If you happen to see, hear, or read anything about this case, please disregard it and let us know. And be very careful with your social media use. We'll see you tomorrow morning. Thank you.
All right, for the court, please. Close the notebooks to follow me.
All right, so there we go. It's all done now, chat. It's all done now. No. They seem to end court early a lot. Why do they play these random clips in no really context? They're Karen Reed statements. So Yeah, that it's because they're trying to use Karen Reed's statements to show she's a bitch. And Electronic Chat says, let's face it, the Boston accent is funny. Karen is Fall River. That's a different accent. The massholes will let you know. It's a real thing. And Titan 22 for $9.99. Nice. I like the Raptor on your profile there. Thank you, by the way, for your super chat. Thank you for being here. Look like a new face. Thank you for sticking around. I think Karen's guilty of DUI, 100%. I think most of the people involved in the story were guilty of a DUI. Nobody was able to drive a car, I think, except for Carrie Roberts. I think the jury will convict if they play the interview clips, but she does not take the stand to talk to him. I don't think so. I mean, remember, at the end of the day, I think jurors are smart. Like, in jump cutting this, just looks really bad. If she, her taking the stand, I think it's really going to depend on how well the trial's going. If she's taking the stand, it's because they don't think that it's going well. That's my thought. But yes, the way Hank's done this, I mean, it sounded good, I bet, in his head. What he probably been better off doing is offering a big fucking supercut at the end. Like, that's how I would have done it if I'm Hank. Because if you do them piecemeal and then do them again, nobody's going to care because they've already seen them. But if he had done like a big supercut, that probably would have been banger as far as the effect on people. So, but thank you for the question. And I think so too. I think, if they could convict her of a DUI, they would be able to. Could you charge your DUI plus 3 years hence? Well, remember, they charged her at the time. But yes, now I would argue it's probably too late. They could probably amend charges at this point because they charged her initially. So, yeah, I don't think she's taking the stand. I think they're going to be... Their case is very confident. Remember, the MEs support their theory, ultimately. So, Mark says you're giving them ideas. Well, they'll survive. But yeah, microdots might do something, or Afix. You could probably do something with all of those and make a thing. That would probably be more effective. No, they would not do all that. I don't think that'll help. You won't get jury nullification like that. I wouldn't expect it. Tagged you on my reactions during the Elise questioning of Hyde. Well, thank you. I appreciate that, Speak Life. Speak Life Garden, Homestead, and Permaculture. Thank you. Chloe was probably drinking, yeah. Well, she didn't do her job. For all you guys know, Chloe's on meth. Yeah. So, all right, guys. Well, it's 10:45 Eastern time. We are gonna we're gonna end it here, and we're gonna get ready for day 12. We're gonna start a little earlier, chat. Remember, we're gonna start around 5. So remember, we have the Thursday night show we do every Thursday night, starting at 9:30 Eastern. Guys, if you're new, we do this every Thursday. When we don't have live streams or trials to cover, Thursday nights though, we save that for this. A lot of stuff's going on. Diddy's trial is kicked off. Apparently, got very intense. The Abercrombie & Fitch former CEO is incompetent to stand trial. There's a crazy story out of Southern Ohio involving police and murder that's going on. And then we also have the idea of a raccoon smoking meth in Ohio. That's actually kind of funny. Just happened a day or two ago. There's body cam of a raccoon playing with a crack pipe in a car. Very funny, very funny. Then some other stuff that's happened that's very interesting. Updates on the California bar exam. Apparently, people have figured out that their tests were not graded and graded to them. Someone else got their grade and they got someone else's grade. It's getting worse. The California bar has sued the test maker. It's getting very, very interesting. So if you guys want to join us 9:30 Eastern, it is a great time to be had by all. Do the Haitians eat the raccoon? No, because it's on the wrong side of the state. What's going on in Ohio, dude? This is Ohio. This every day in Ohio, brother. Every day, brother. Yeah, it's Ohio. Yes. So, have you ever seen a defendant give an extra warm coat behind on every defendant's chair? Hi everyone. Now plant your heirloom tomatoes now. Have I ever seen a defendant give an extra warmth coat behind on every defendant's chair? Did I miss something there? I'm not sure. I'm sorry. Fair Maiden wins. I'm not understanding you. I'm not understanding you. I'm sorry. Every Supreme Court case about Miranda, except Miranda about police misconduct, came out of Ohio. Well, to be fair, Terry v. Ohio happened in Ohio. Mapp v. Ohio, the exclusionary rule, that came out of, that came out. Yeah, they all came out here. A lot of them did. Ohio's Florida of the swamps. Where do you think Florida Man came from? Florida Man moved to Ohio. So you see, we are very much similar, you and I. How many spiders in the P.O. box so far? I don't know. I'll find out tomorrow. Girl Dad Giga Chat says, what's the name of the Ohio case? Which ones? There's multiple criminal cases in Ohio. Ohio v. Reiner, Terry v. Ohio, and some other stuff. Everyone from Ohio's tried to live in Florida. Well, I don't know about everybody, but yeah. Ohio, where the original point store next to your niece's elementary school originated from. Yes. 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 The original porn store next to your niece's elementary school originated from. Yes. So. Oh, with that said, guys, we're going to wrap this up. And I'm going to let you go. I will see you guys tomorrow. And I should see Lori Daybell. She's a better issue than... Does she? I thought her case is over. I thought Lori was done. I thought she'd been convicted. So. But anyways, chat, I will see you guys tomorrow. In the meantime, just remember, guys, just because you did it does not mean you're guilty. And right now, Karen Reed, still not guilty. Lori Daybell has one more case. Well, that'll be great. That'll be good. We'll cover some stuff there. But anyways, chat, you guys take care, and I will see you tomorrow. Good night, chat. I know the casino's on tonight, so go over there and say hello.
Weapons, blacksmithing, and models of planes, esoteric works, and even some trains. Much merriment had while drinking White Claws, tips on hunting, and even talking the law. Whatever you do, just don't talk to cops, even when they nab you on illegal stops. Just cause you did it doesn't mean you're guilty.
Scott, this is a great question because Apple's going to say no. We're not coming in to talk about this. It's proprietary information. Lol. That's what Apple would do.
But please talk to.
Good night, Scott. Very good question.
Was that the fat guy?